Good morning. This hearing is in the matter of case number CFI 044-2021 before Justice Wayne Martin. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Charles Russell Speechlys. Lead counsel is James Bickard Smith. The defendant is represented by Adil Shah Goddard. Lead counsel is Mahendrapal Sethi Casey. Thank you, Your Honor.
Good, thank you very much. Now, gentlemen, I think we agreed that we would set aside 4 hours for this hearing, didn't we? And on the basis, or not? Is that my recollection of that faulty? Yeah, I mean, I can sit for longer if you want. Do you have an estimate of how long you might need?
Your Honor, my time estimate for how long I shall be is 2 hours 15 minutes, so 15 minutes over is essentially.
All right, Mr. Sethi, will you need the same amount of time?
I'm content with whatever timescale Your Honor has put aside. If 4 hours it is, then we shall cut our.
Oh well, I just had, for some reason the booking has been made for 4 hours, and I thought
That's
that
fine.
might have been no, but it's okay. I can sit for as long as we need. So, but I think that should be ample time. I would think 2 hours, two and a bit hours so. Each, yes. And we'll take a break. Mr. Bickford Smith, you might need just a few minutes in reply. Of course, you won't know that yet, but it might be good to keep a bit of time up your sleeve for that as well.
Yes. Okay. Well, then I'll try and do the main submissions in 2 hours.
Yes.
Now, Your Honor, on housekeeping, I should check that Your Honor has a bundle.
Should I have a separate bundle? Should I for this hearing?
You should.
No, I don't have it. I'll just go back and have a look in the system and see if it's there. No, the last bundle on the system when I logged in yesterday was the trial bundle for the prepared in February.
No, there should be a bundle. It may just be the name I have saved it under, but the name I have it under is 1 May hearing bundle.
Right. Well, I probably need to log. When did it go up? Do you know? Was just recently, was it?
I had it yesterday.
Might have gone up since I last logged in. I think the best thing would be for me to go back out and log back in again and see if I can find it. So I'll do that. Yes, there it is. Hearing 01 May. Yes. Okay, I'll pull that up.
Can I check how many pages that is? So in due course, when it.
Yes, it's the authorities. The last authority is just over 1,000 pages.
Okay.
The last authority starts at page 1001. 1091.
The last authority I have starts at 1198.
Well, you've got the better of me there, Mr. Bickford Smith.
I'm sorry about that. Can I just check the one that starts at 1091? Is that a case called Dunn?
Dunn, yes, that's it.
There are, in fact, other cases that follow that. Okay. Well, we are where we are. I'm just going to crack on.
There it is. All right. Yes, please do.
The unfortunate thing is that Your Honour therefore won't have 1194, I believe.
No, I don't. Is there some way that your instructors can get that to me?
Yes, I'm going to ask for that to be sent separately. The bits from 1099 to the end of the bundle. Okay.
Good.
Has Your Honour had, apart from the bundle, the opportunity to, has Your Honour received the closing submissions?
Yes, I've received and read them, and I'm very grateful to all for their preparation. Obviously, a lot of work has gone into them, and they'll be very helpful to me, I'm sure. So I expect that there was more than just the two of you involved in that. So my gratitude extends to all of those involved in their preparation, which, as I say, they've been very helpful. They're very thorough and very informative. So I'm grateful for that.
Good. I'm grateful. The position that has, I think, is to be welcomed, is that Your Honour will have received two versions of a chronology and cast list,
Yes.
I believe.
Yes.
That was close to agreement. It has now been agreed. When I use the word agreed, I think we should be clear. This is not intended to create some form of estoppel against anyone.
No. It's nothing more than an aide memoire.
Yeah, and that the claimant's version of that document has been agreed. And I say it's the claimant's version. It reflects very substantial work by the defendant's legal team as well. So
where will I find that? Because the two, I looked to see if I could find any differences in the two versions I had, and I couldn't spot any offhand, but I assume there were. But,
there are no real material differences, Your Honour. It was simply that the claimant wanted to delete some what we consider to be uncontroversial references, which we thought would be helpful to you, such as witness paragraph references in their statements. But there's no real material differences upon close checking.
All right. Where do I find Mr. Bickford-Smith? Where do I find the final version of that? Or is
if Your Honour types in the 315 to the bundle,
the most recent bundle?
Yes, the most recent bundle.
Yes. My system is very slow, so you may as well talk while the document's coming up. But my internet speed out in the Antipodes, the internet is tediously slow. Here we go. It's up now. Yes, I have it now. Thank you.
Apologies for interrupting. I've just emailed the registry 2 PDFs of the hearing bundle in case that's of assistance.
Oh, good. Thanks.
The authorities section is a separate PDF.
Good. Yes, Mr. Bickford-Smith?
Yes, and I should just check to round off this housekeeping section as fast as possible. It should be that if Your Honour inputs page 5 into this most recent PDF, Your Honour should have the claimant's closing submissions.
Yes.
And if Your Honour inputs 107.
Yes, that'll be the defendants.
No, that 107 is the appendix A to the claimant's closing. And then 137 is the defendant's.
Right, all right. Good, thank you.
Now I need to try and see you.
Those, Your Honour, are presumably documents, of course, as you've confirmed, you've already seen, so you'll have marked up your own versions.
Yes, yes. Well, I've seen them on the screen, so I've got my version marked up. Yes.
Well, what I'll endeavour to do when I refer to them is to refer to paragraph numbers. I think that may be the easiest thing.
Thank you. That'll be helpful. Thank you.
So, Your Honour is the judge of both fact and law. On the facts, there have been 9.5 days of witness testimony, and I want to begin.
Sorry, can I just interrupt? I'm sorry to interrupt, Mr. Bickford-Smith. Your Honour, in trials like this, if the claimant has given evidence first, the claimant tends to respond and do closing submissions second. Does Your Honour prefer to hear from the claimant first?
Well, that used to be the well, certainly I don't know what the current practice is in England, but it used to be the practice where I practiced about 25 years ago. But then it got abandoned about 25 years ago, and so on the basis that, you know, I think in the older, that practice grew up at a time when trial by ambush was quite common, and so if the defendant went into evidence, the practice was the defendant would close last and then followed by the claimant. But as I say, that was generally abandoned about 20 odd years ago where I am. But I'm in your hands, gentlemen. If
it's still the case. It's still the case.
I mean, I believe I'm right in saying that in the DIFC court rules, it talks about the claimant going first. I'm just going to check that.
Thank you.
Miscellaneous provisions relating to hearings, I think it is.
It would be worth checking just for completeness.
Failure to attend, timetable, general organisation, information technology, skeleton argument. Hang on. Yes, 35.72. Unless the trial, sorry, this is on page 483 of the Blue Book. Unless the trial judge directs otherwise, the claimant will make his oral closing submissions first, following by the defendants in the order in which they appear on the claim form, with the claimant having a right of reply.
All right. Well, I think that's the answer to that, Mr. Setti.
That is. I'm grateful.
Yes. Dubai and Australia are in the same camp.
Your Honour is the judge of both fact and law, and on the facts, as I say, there have been 9.5 days of witness testimony. I'm going to begin just with, and it really follows on from what has just been described about documents and the documents which are there to assist Your Honour in reaching a judgment on the facts. Now, we now have a chronology document to which I have referred the court, and that chronology document is supplemented by submissions on the facts. Now, in the claimant's submission, these are to be found at section C of the claimant's submissions, and this begins at, for Your Honour's paragraph reference, this begins at paragraph 26.
Yes.
And that is internal page 13, bundle page something else.
Yes.
Bundle page 17.
Thank you.
And again,
I've got that.
I trust this won't surprise the court. What these do is, you can see they go to documents in the bundle. So we see in paragraph 27, those are bundle references.
Yes.
We then, in due course, when we follow down, by the time we get to, I believe it is subparagraph 6 on page 14, you'll see that final reference there is to cross-examination, which we can see a cross-examination reference. So that's a transcript reference, which is in the form of day, PDF page, internal page. I should say, with apologies, that some of the references lack the PDF page, just go straight to the internal page. Yes. But that is a process with which I'm sure Your Honour is familiar.
Yes,
and then on page,
I've been able to navigate the references in both submissions without difficulty. Thank you.
Now, there is a more methodological point, which is, this is how we say that we would expect to see this done, i.e. there are references to the bundle, references to the cross-examination, and so on. Now, and then we see, Your Honour will see submissions in the ordinary way. Now, I do have to flag that a singularity of this trial closing is that there is a very substantial document which the bank have served as an appendix to their submissions, and this is their appendix 1. This is at their internal page 62, and that
yes, I've read it, Mr. Bixby-Smith.
Well, the point about that, which your Honour may have seen, is that this is a series of summaries or extracts from primarily the bank's witness statements. So can I take your honour to page 63, in their internal page 63, page 199?
I did notice that when I read it, actually, Mr. Bickford-Smith.
And the submission that underpins that and is to justify it is at paragraph 6 of the bank's closing, the main closing. It said a remarkable feature of the cross-examination of the defendant's witnesses is how well their evidence stood up in the face of intense scrutiny. The oral evidence heard at trial was consistent with the written statements of the defendant's witness. At Appendix 1, D sets out the suggesting findings of fact on the evidence seen and heard at trial. Well, with respect, and I do recognise that there have been some big documents flying around here, there has been a lot of work. But I do have to make very clear to the court at the start that we do not accept that the findings in Appendix 1 are findings that reflect the evidence seen and heard at trial. They reflect the evidence that was in the witness statements. And second, as regards the submission that a remarkable feature of the cross-examination of the defendant's witnesses is how well their evidence stood up in the face of intense scrutiny, Your Honour, my simple submission is that is not the trial I appeared at. Now, I referred to this as a housekeeping issue, but it is one that raises a fundamental issue. And the fundamental issue is the bank's general lack of engagement with the facts in the light of cross-examination. And cases, as Your Honour will know, are decided on the evidence, not on the statements. And all of the defendant's witnesses, without exception, were challenged in cross-examination by detailed reference to documents in the bundle. And it is, can I just check Your Honour can still see me?
Yes, I can, although I can see you, but what I'm doing is I've just received an email that's got a bundle attached to it, and I've just been opening that. And where is it?
Have I received the same? Hang on, let me just.
It's got one May hearing bundle, but when I open it, it seems to only go up to page 500.
That it may be an email in two parts.
Yes, maybe.
I haven't received this. Wait a moment. Could I just ask to be forwarded it on by those?
I think the first part is the it's everything except the authorities.
And then there's consolidated authorities bundle, and that starts the next page. Right, I've got it. So there are two bits.
Yes,
right, I've got it, and that goes. Okay. Now I'm just checking that. That goes through to page 1200 and something.
Well, we're there.
All right.
We're there.
Good.
We're there, Your Honour.
Yeah.
Right, can I just check, Your Honour, that I have the same document that you've just been supplied with? So, yes. Have you just been provided with a bundle which is paginated to what page?
1200 and something. 1208 or 9 or something. Mine came from Aaliyah. Aaliyah, could you send the email that you've just sent to me to council if you've got?
Yes, Your Honour. I'll do that now.
Thank you.
I'm just checking that I've got exactly the same things. Yes, I have as the second part. I have this in a separate place. It's called Consolidated Authorities Bundle, and it starts at page 505.
Yes, that's it.
And so hopefully
we're all on the same page now.
Quite literally, yes. And it is in fact hyperlinked. Yeah, good. I now need, sorry, I'm at the moment flying blind. I can't see anyone. Okay, I can now. Good. So Your Honour should now have everything, and to complete, Your Honour will be taken, as we're dealing with all of these document issues in one go. Your Honour will be taken to the trial bundle.
Yes,
and
I've got that open.
Yeah, And so that is where we are. And Your Honour, I remember having hard copy transcripts, as do
Yes.
I, but I believe that they are also available in PDF by day.
Yes.
Indeed, I know they are because I've been using them. So that's the full suite of documents. I now need to try and get back to seeing the right document. Hang on, here we go. So one thing just to round off on Appendix 1, if I may, can I take Your Honour back to Appendix 1? That's the document at 198 of
Yes.
the 1st May bundle, internal page 62. The approach that this takes is as if the cross-examination had never happened. And in fairness to the bank, that also reflects the position with regard to the claimant. That is to say, no submissions are made on this about what was said or not said by the claimant in cross-examination.
Yes.
And
as I read it, it seemed to rely mostly upon witness statements, augmented to some extent by documentary evidence.
It's normally
there may have been 1 or 2 transcript references, but not many, as best as I could see.
I couldn't find any, but I don't exclude the possibility that there are 1 or 2. But the document references, I think, can normally be followed through, because if you look at the witness statement paragraph referred to, you know, sometimes that refers on in turn to the documents. Yeah.
So would it help to actually hear from the author of the document? Just so that we don't hear any other unjustified commentary. It is clearly and self-explanatorily a summary or collation of the defendant's witness evidence at the end of any relevant paragraph, where you see the source and the relevant paragraph references from various witness statements. Those are the initials followed by a number in square brackets in bold at the end of most paragraphs. It is transparently, unambiguously, in large measure, a helpful, we think, collation by themes, relevant themes, in relation to the issues to be determined, by reference to various of the witnesses' admittedly written evidence. And to that extent, it is, we consider, to be quite a useful document, because there is a great deal of factual evidence which is not in dispute in relation to dates and people and places and what happened and what was said. And so in terms of the primary uncontentious facts, as well as some contentious facts, it is helpfully set out there. But it's unashamedly a helpful collation of the relevant defendant evidence.
Well, I take it to be a statement of the defendant's position on the basis of the witness statements and the documents.
Yes.
Without reference to either the claimant's evidence or any of the oral evidence.
Yes.
That's basically what it is. All right.
It is what it is.
Yep.
It's either going to be helpful or completely unhelpful.
Well, it'll be a helpful statement of your position without reference to those other things. So.
Yes.
Well, it might.
Well, Your Honour, what it means is that you don't have to stitch together numerous respondents' witnesses' accounts of related to the same theme or event or series of events. You have it in one place.
But well, in a sense, that's right. But in another sense, if I want to see what the witness said about their written testimony in cross-examination, I've got to go to the transcript.
Yes, and in relation to transcript references, in the main body of my submissions, I've dealt with transcript references.
Yes, all right. Well, as you say, it is what it is. Mr. Bickford-Smith, back to you.
Your Honour, I try to be quite amenable and open, but I should just say a couple of points. The first is I'm more than happy for Mr. Sethi, as the author of that document, to make his point as he has, but I am also conscious of time and having quite a lot of ground to cover, and really here we are 25 minutes in, and I've as they say, barely got started. But the second and more substantial point is, as I say, I try to be quite open and amenable and polite about things, but I do have at the same time a job to do, which is to put my client's case. And the case here is very simple. The bank is proceeding, save for some paragraphs of my learned friend's main submissions, to which I will come. The bank is proceeding as if the 9.5 days of witness testimony that the court heard did not occur. And that is the wrong approach as a matter of principle. But beyond it, what we say behind all this mess about which document and which transcript reference, etc., what we say is that it is a case of mind the gap, because the gap here is that the bank has not been able anywhere in its submissions to mount a sustained defence of the credibility of its own witnesses. And it has also been unable to make a serious critique of the credibility of Mr. Mahmood, save in respect of extraordinarily discrete incidents. And what we instead see in the main submissions are a variety of what can fairly, in my submission, be labelled objections or quasi-objections. Now, I'm going to have to spend an hour going through these. And in my submission, this isn't what closing in this matter of all matters should be about. This is a case that should be decided on the facts, on the credibility of the witnesses' accounts of those facts, and on the law. And that's what I'd expect to address in closing. Now, instead, what I'm being met with is what I can fairly describe as a very large number of objections of various types about the pleading, about various points on discrimination law, which I'm going to take Your Honour to, and which are wholly unrealistic. And then we are having points about what was or wasn't put in cross-examination. And I'm going to deal with those objections because that is an important part of my role, and I don't want Your Honour to end this hearing with some form of lingering doubt about the materials that Your Honour has and Your Honour's ability to reach findings of fact as submitted in Section C of our skeleton argument. But the real concern I have about doing this is that I am mindful that, yes, I have to do it, but Your Honour concluded the last hearing by saying, well, what we need to focus on here is the discrimination claims, an observation with which I entirely agree. And I am concerned here at what I would describe as a risk that in dealing with the bank's objections, I cause the court to lose sight and party to the court losing sight of what I say are the reasons why the claimant's claims should succeed. So what I want to do at this stage is to go back through the claimant's case in a nutshell and explain why he should succeed. But I referred to Groundhog Day. Now, Your Honour will have the transcripts, and can I refer Your Honour to the transcript of day 1?
Yes.
And what Your Honour will see is that as much as it might be interesting for me to take Your Honour at this stage back through the pleadings, you will see that I began the trial by doing that. And then Your Honour helpfully indicated at page 7 of the transcript, which I believe is page 2 of the PDF, that Your Honour had read the transcripts and much else besides, and that was very helpful. And I then turned on to the areas of disagreements between the parties as to what was and wasn't in issue, and so on. And that passage, for Your Honour's reference, extends from internal page 7 of the transcript through to page 16 of the transcript. So Your Honour knows the case, and so should the bank. And I say so should the bank because what we have seen in closing is that the same points, plus some others, that we saw being taken by the bank in opening on day 1, and which I addressed orally on day 1, are being taken, and these remain in my submission bad points. So I'll just give one example of that. In paragraph 7 of the amended particulars of claim, And that for your, I'm not going to take your honour there. I'm simply going to say that it's at pages 11 to 12 of the main trial bundle. And there the claimant states that since the age of 6 months, he's never lived in Pakistan nor held a Pakistani passport, identifies himself as a British Asian. Now, the bank submitted in opening that the claimant was of Pakistani national and ethnic origin and of Pakistani race. Now, on page 8 of the day 1 transcript, I pointed out that this wasn't the bank's pleaded case and that no positive case had been averred by the bank on this issue. Now, 3 points on this. No evidence has been led over the course of the trial by the bank to rebut what the claimant has said at paragraph 10 of his witness statement about this. That's at page 7412 for your honour's reference. And I do not therefore see on what basis the bank can submit at para 8.2 of their closing, and that's at page 145 of today's bundles. It's submitted here. Sorry, 140. Sorry, it's 146.4. Sorry, 8.2. My apologies. I was right first time. 8.2, page 145 of the bundle, paragraph 8.2, internal page 9. It said, second sentence, this is clearly correct given that he was born in Pakistan and is of Pakistani national and ethnic origin. This presented a problem for C. Well, I don't see the basis for that submission. And second, this is a potentially.
What's the problem? I'm missing something here. Why don't you see the basis for it? Is that not said at? Was that not said at POC 7?
POC, right? No, Your Honour, there is a distinction.
That was the original one, and then when there was an amended points of claim, the word Pakistani was substituted for Asian.
Yes, but the point is that to state the obvious, that the claimant's what's asserted in 8.2 is that he is of Pakistani racial and national origin, and that is not the claimant's case. And it's not his evidence. He has never had Pakistani nationality.
All right.
That's so that's not what 8.2 says. It doesn't talk about nationality. It talks about being born in Pakistan.
I mean, Your Honour, if we're going to have...
Let's not mislead. Mr. Victor-Smith, let's not mislead.
I'm not misleading. You're misleading.
Well, I think, Mr. Setti, it would be better if we don't want to be here all day. I think it'd be better if we just remain quiet. And make notes. You can correct things in your course of your address.
What's said at paragraph 12, page 12 of the APOC, this is bundle page 12 over the page. He left Pakistan when approximately 6 months old and has since then never lived in Pakistan nor held a Pakistani passport. He identifies himself as a British Asian, not as a Pakistani. So there is no pleading here and no evidence of Pakistani national origin. What is being done here, and it's, my learned friend is quite careful with his language here. What he's doing here is to give the impression that for the purpose of what nationality is, for the reference of the law, the claimant is of Pakistani nationality. But that's not what he is submitting. It's what he is suggesting.
Well, I didn't read it that way, but anyway, I'm not sure that it's a massive point. I don't think the case is likely to turn on this point, Mr. Bickham-Smith.
I agree it isn't, but the point I was actually using it to illustrate is that a series of debates that were had on day 1 in opening, the points there are being run again by the bank, and we say they are bad points. So, for example, I would refer Your Honour to pages 44 to 47 of the day 1 transcript.
The PDF pages? Or is that the internal pages?
That's the internal page.
Internal, yes, all right. Yes.
And you will see there that was there was a discussion before the court about skin colour and this Caucasian comparator, which ended up at page 47. Your Honour will see that Your Honour made a suggestion, which was a helpful suggestion as to what the claimant's case was. And that was, I say it was helpful, I had believed, in resolving a position where the parties were not ad idem. But then we see at paragraph 8.54 at page 146 of this bundle.
Yes.
Essentially the same point being run again.
Yeah.
And so I'm mindful of time, but I do just want to say that the reason why I am not going to take Your Honour through the pleading yet again is simply that this was done on day one. I believe that there was clarity at the end of that. And no one can say there has been a surprise in what has how the case has been led thereafter. And I'd also refer Your Honour, somewhere Your Honour will have the opening skeleton argument. And just for reference on that, the claimant's case was there opened on the basis that there was hostility to him from the management of the Islamic banking unit, that the unit had previously been hostile to another non-Pakistani, namely Mr. Vaseli, that objection was taken to the claimant as a British Asian. Then on the facts, I suspect that Your Honour is by now extremely familiar with the generality of the factual outline, but just to deal with salient issues, we have a position that within the unit that became substantially worse after the claimant circulated the draft of the Group Islamic Banking Compliance Framework document in December 17. There we have 7 hours of meetings, said there was a toxic mixture of resentment at compliance norms being imposed, and as a British Asian being the person to do so. And then it was said why the bank's denial was unsustainable. Then we went into the January 2019 grievances, which were duly referenced. And then we made the point, the very important point, that after a meeting on the 5th of August, I'm losing Your Honour. Hang on, let me just see if, is that, can Your Honour still hear me?
I can hear you, but I can't see you anymore.
Okay, let me try turning the camera back on.
There we go, that's better.
Following a meeting on the 5th of August 2019, at which really there was a boiling point about the compliance framework discussions and the follow-up arguments and everything. And this is post a series of events, including the 365. We have the position where Mr. Akbar approached Mr. Vaseli on the 6th of August and told him to tell his friend, referring to the claimant, that he was behaving inappropriately. He told Alessandro to tell me that he knew how to deal with British people, even if they had been their masters, etc. And we have seen
just on that one, Mr. Bigford-Smith, of course, the defendant denies that was said.
Correct.
And the evidence that I have on that is Mr. Mahmood's, the claimant's hearsay evidence of what he was told by Vaseli. Mr. Akbar denies having said that, and he denied that on oath.
Correct.
So how do I find that those words were actually said when the person who is alleged to have said them hasn't been called to give evidence, and the person who is alleged to have heard them hasn't been called to give evidence, and the person who is said to have said them has denied on oath that he said them?
Your Lordship has to follow the well-known guidance as to the reliability of contemporary documents and as to the credit of witnesses. And what
contemporary documents are all hearsay. There's no direct document from Mr. Vaseli saying it was said, is there?
No, but there is an email which is virtually contemporary at 2978.
From Mr. Mahmood?
Correct.
Well, it's just hearsay on hearsay, isn't it?
Well, Your Honour, that is the nature of the evidence, and well, we say
that's why I'm saying it strikes me as a problem, and I just wanted to give you the opportunity to put a submission on it.
Yes, well, I will do so.
There's no, you haven't led any evidence as to why Mr. Vasselli wasn't called, so I just don't know whether he was available and wasn't called, or I'm not going to speculate about that. The fact is he hasn't been called.
What we say is that he was someone who the bank, it was open to the bank to call, as much as indeed more than us.
But you carried the burden of proof. You carried the burden of proving that what you say was a discriminatory comment was made. You were aware that the maker of the alleged maker of the statement was going to deny it. Surely you carry the burden of calling the witness to counteract that denial, don't you?
There is, Your Honour, I don't accept that. There is a written document from Mr. Vasselli himself contemporaneously about what was said. Hang on, let me go to it.
And ultimately, this complaint, Mr. Mahmood's complaint, was dismissed on the basis that Mr. Vasselli had made conflicting statements, as I recall.
That is correct.
So if on the evidence before me, Vasselli has made conflicting statements and he's not called, what should I do?
Well, Your Honour, this was explored indeed by Your Honour himself in the cross-examination of Mrs. Al-Najjar. And what emerged was that Mr. Vasselli had not made conflicting statements.
All right. Well, if there is any direct evidence from Vasselli, I think it's important for you to take me to it.
Okay, well, I will. That's helpful. I will do so. I may. I'm assuming that at some stage we'll have a brief break, and
after about 2 hours. After about 2, we'll break about 10 o'clock your time.
Okay. Well, I will still be going then, but albeit I won't have much to do. But I will come back with the reference then. So the point I was seeking to make, rather than actually to go through each of the facts, and on this I should say that I will, when I come back to this, go to section C of the plea of the opening, because this is dealt with there. Perhaps not with the references that Your Honour has just averted to, but I will come back to that. The point I was seeking to make is that the court knew, and everyone knew from the start of the case that was being opened. And the court also knows that the bank denied the claims, and the court saw the bank's opening. Much of what the claimant has said was dismissed as an unfounded allegation of conspiracy. Their issue was joined, and there were then evidence. So the battle lines in this case were drawn, and were clearly drawn. And the question for the court is, where at the end of all of this evidence does the matter stand? Well, where it stands in my submission is that after the cross-examination of the defendant's witnesses, a number of matters which were being advanced in opening on an inferential basis have in important cases been made out, either by admissions or by testimony, which will have left no neutral party in doubt that the claimant's case on the events has been made out. Can I just give 2 important examples of that?
Before you do, can I just go back to this issue about Mr. Akbar's statement after the meeting on the 5th of August 2019, the
Yes.
contentious statement. Let's say I found that the statement was made by Mr. Akbar as alleged by Mr. Mahmood. I just want to put that in the framework of your case. So are you saying that the making of the statement was an act of discrimination? In other words, that the bank is bound by Mr. Akbar's statement? Or do you say that the act of discrimination was the failure to investigate and rectify the statement made by Mr. Akbar? So in other words, are you saying that Mr. Akbar was relevantly the bank?
Yes.
So is the bank vicariously liable for him?
Yes.
Or do you say that the failure of the bank was failure to investigate?
No, we say it's vicariously liable for his actions.
So if any employee says to any other employee any racist comment, then the employer
that's the entire nature of vicarious liability and discrimination law. That's how it works. Otherwise, otherwise, who is the bank liable for?
Well, so two labourers out on the road, one abuses the other, racially vilifies the other, then the employer is liable for that without more, you say?
Well, okay. In UK discrimination law, there is something referred to as a section. Hang on. There is a particular defence within UK law. Your Honour's asking it. I'm glad that Your Honour is asking these questions because it gives me the opportunity to deal with them. There is a provision which allows an employer which has taken all reasonable steps to prevent discrimination in its workplace being liable on some bases.
Well, of course, I've got to apply the DIFC law,
and there is no. The point is, there's no equivalent provision in the DIFC.
The DIFC law prohibits an employer from discriminating. Now, surely there must be some limit to that. So, in other words, the labourer out on the road, to take my mythical example, you wouldn't take his acts to be the acts of the employer for the purposes of discrimination, would you?
You would. Yes, you would.
Well,
because otherwise,
otherwise
you get into.
Law?
Yes, well, the question, Your Honour, is how does the statute allow one to draw a line otherwise?
Well, by saying whether for example, if a manager of somebody takes an action that is discriminatory against the person they supervise, then I can see that the manager would be taken to be the employer for that purpose. But if you've got two employees at the relatively the same level, and one says something inappropriate to the other, I'm just wondering how that becomes a discriminatory act by the employer.
Well, an employer.
Your case is the employer is liable for everything that each employee says, and so if there's any discriminatory act.
Yes, that is the case. Yes. Yeah. I mean, that is, if I may say so.
I'll hear from Mr. Setti on that point in due course.
If I may say so, I mean, it may be that we revert further on this, but this is, I mean, one goes to Lord Hoffman in the Meridian case and the question of attribution. Within discrimination law, the actions of other employees are attributed to the employer for the purposes. Yeah. Where one gets into doubts and debates in English law is about the status of people such as, for example, independent contractors, and the like.
But let's take this one step further. The two anonymous complaints that were lodged in January of 2019, I think it was, both of them contained racially charged observations. One was a cop of the colonial era, and the other was behaving like an English scholar. Now, you say that if I conclude that those complaints were made by employees of the bank, it follows that the bank is liable for them.
Correct.
Is that the proposition?
Yeah, that is exactly the case. Yeah.
Well, it seems a very odd result. It seems a very odd result that the employer is liable for people who do things anonymously, and who can't therefore be identified. How can the employer ever guard against liability of that kind?
Well, there is no. I think I should be. Sorry, Your Honour. I don't mean to be rude by getting up, but I just need to get an English law book. Is that?
No, by all means, no, go for it.
Sorry. Under the UK discrimination statutes, the employer is vicariously liable unless there's a specific.
I'm not trying a case in the UK, yes. Mr. Vic.
Yeah. Okay. Sorry. So
what's the law of the DIFC on this?
The basic point I'm making is that in UK law there is a specific provision which marks out an exception to the general and long-established principle in discrimination law that the bank is axiomatically liable for the acts and omissions of its employees. Now, the issue
is that the law of the DIFC?
Well, in my submission, it is the law. It is the law of the DIFC because if it were not,
I'd like something a bit more than your say-so for that, Mr. Bickford-Smith. How does it become the law of the DIFC?
If one looks at the definition of employer is an establishment or entity referred to in Article 4.1a. Yeah. So in other words, there is no narrowing of the employer to the management of the employer. It is the employer as a legal person. But
of course, in relation to criminal law, there are all kinds of principles developed again under the common law in relation to the level at which a person has to be in order to be the relevantly acting on behalf of the corporation and to be the mind of the corporation. The fact that employer is defined in that way doesn't tell me anything, really, does it, about whether vicarious liability principles extend in this context to discrimination?
Well, Your Honour, the correct employee. If Your Honour is going down that line of reasoning, the line of argument leads in my submission to the cases on vicarious liability, not in criminal law but in tort. So you're looking at cases where an employee, there is an argument as to whether an employee has done something in the course of their employment.
Yes, all right, but that's under English law. What about under DIFC law? Do the English principles of vicarious liability apply in the DIFC, and if so, how?
Well, we submit that they do, Your Honour. I have to say I'm slightly...
I know that. I've heard you say that before, but I want to know why.
Well, because this is a statute modelled on UK discrimination law, and
but it doesn't, as you pointed out, it doesn't contain a provision that would otherwise exclude very broad coverage. That is the provision in the UK about reasonable measures.
Yes,
so then you read it. You say an employer discriminates. So you've got it on the natural ordinary meaning of it. But it have to be some act on the part of the employer, and there must surely be a point at which, when you go down the corporate chain, there will be a point at which the acts of the person are not the acts of the employer, the acts of a fellow worker, co-worker.
That is not an analysis that that is not an argument, that is not an analysis that commends itself, because that point is not described anywhere in the statute. And if the statute is not given broad coverage, then an entire class of acts naturally fall outside it, and what one is left.
Well, what's the law of the DIFC in relation to vicarious liability of employers, and where is it to be found?
Hang on. Law of damages. Law of obligations, I believe, is where this is. Hang on. Let me just get this here. In the law of obligations, Part 3, Article 15.
It's a DIFC law of obligations, is it?
Yes, that's correct.
Yes, all right.
Has your lordship got that?
No, I don't have it to hand. I'll try and find it somewhere on the internet. Yes, what's it say?
An employer is jointly liable with his employee in respect of liability of the employee under this law arising in the course of his service. So it's a course of employment test.
All right. So that's just the reference again. That's DIFC law of obligations, chapter 3, is it?
So no, part 3, article 15. Part 3, article 15.
Thank you. Good, thank you.
And I am advancing these submissions, but I should step back here and say the following. If one follows Your Honour's analysis, the operative question would become the question Your Honour asked about, is the act complained of? Not so much the statement itself as what followed when that was escalated within the bank. That would become, on Your Honour's analysis, the operative question, or so it seems to me.
Yes.
And
so that's the question I want to know. So in other words, you're saying that the mere making of the anonymous complaint is an act of discrimination, or is it the failure to respond appropriately to the complaint that is the act of discrimination? That's really the question that I'm...
Well, we would say both. We do say both, but I want to focus on the second issue now. Yes. Because if Your Honour is taking, to pursue the line of analysis that Your Honour has begun, it's fruitful to consider this. And this, I suppose, takes us back, funnily enough, to the analogy or non-analogy with UK law. Because in UK law, it's clear that the act itself is an act of discrimination. If the focus of the law is a different focus and focuses on what the employer has done or not done, then it would follow, we say, as night follows day, that it is the failure of the bank to do anything when these matters came to, I mean, it's worth bearing in mind, these were matters that actually went through the bank's ERHR function. So what we say is that the bank is liable at that stage for not having done anything. And that is pleaded by reference to a discriminatory state of affairs. And we say that to take your honours example of the two labourers and co-workers, what we say is, I've been thinking through that analysis at the back of my mind. That is not analogous, we say, on the facts with the position here, because the position here is that the claimant is working within the global Islamic banking unit and is subject in the course of his work there to mistreatment and detriment. And this is not, to take an example that can arise, and which I have had in the past. One has a situation where two employees go out to a bar, something occurs, and one of them complains about the other's conduct. Now there, one is, if you like, quite far from what one might call the focus of employment, the core of employment. Here, one is looking at things that are happening at the heart of the claimant's workplace. So, for example, the meetings. These are things that are work meetings. They are not leisure meetings. They're attended by Mr. Sheikh, Mr. Akbar, and others we've gone through. These are core employment claims in our submission.
Well, just go back to I've now got Article 15 of the Law of Obligations in front of me. And as you said, it provides an employer is jointly liable with his employee in respect of liability of the employee under this law arising in the course of his service. So there has to be, so the employee has to be liable for Article 15 to operate. But the employment law doesn't impose liability on fellow employees. It only imposes liabilities on employers.
Okay, well, in which case...
So the employee wouldn't have any liability.
Yes, okay, in which case I was trying to illustrate the general principle. Can I go back to the employment law, please?
Yes.
Article 54.
Yes.
So, in fact, it is the case, my apologies, it is the case that the UK defence is mirrored here.
Right.
I got that wrong. I think I probably got it wrong because it isn't a pleaded
defence.
Right,
there it is. Yeah, so there it is. Article 54. An employee is liable for any act, attempted act, or omission employed during the course of employment will only be liable pursuant to 54(1).
So there is the defence.
I'm sorry to interrupt, Your Honour. It's not the same as UK law. It needs to be fair and just to hold the employer vicariously liable.
Yes. Sufficiently connected with the employment that will be fair and just holder, and in case of discrimination, if the employer is unable to show it took such steps with reasonably practicable to prevent the employee from carrying out the act, attempted act, or omission, or doing anything of that description. Well, there's nothing that the employer could have done to stop the anonymous complaints, is there? Or indeed, Mr. Akbar's alleged statement to Mr. Vasselli. What could the employer have done to prevent that?
With regards to the statement to Mr. Vasselli, Your Honour's question might apply to anything that one employee says to another.
Yeah.
What we say is that the answer to that lies in, and with respect to my learned friend, I do think that the UK case law is helpful here, because what the focus on in the UK cases is on matters such as what policies and procedures does the employer have in place to deal with discrimination in the workplace. So to take a very simple example, if the bank had taken the decision to investigate the anonymous complaints or to investigate discriminatory activity in the past, then the anonymous complaint seen in this case is much less likely to have transpired, isn't it? And then the question.
Well, they did investigate the complaints, and they found that they were not, and they dismissed them. The complaints against Mr. Mahmood were dismissed. They didn't. Yes. They didn't investigate the statement about, as far as I'm aware, on the evidence. I don't think there's no investigation about English scholar or cop of the colonial era.
What they did was they investigated the complaints against Mr. Mahmood. What they did not do was to put 2 and 2 together with regards to those complaints read in conjunction with the January 2019 grievance. They did not.
So you say they should have spotted that Mr. Akbar was the likely source of those.
Well, they should have seen that the claimant was clearly the victim of a campaign of complaints which had, as per those anonymous emails, a nationalistically tinged hue. And they should have investigated what was going on in this unit. If not then certainly when Mr. Akbar made his later comment. And what they did instead was, in the first instance, not to look into that aspect of it at all. And in the second instance, they purported to investigate this, but as Your Honour has said, Mr. Vaseli's evidence was dismissed on the basis that it was uncorroborated, and then that he had made inconsistent statements. But what we say is that there was more than enough here for the bank to be on notice of what was going on in this unit, and it is conspicuous for not having taken action against those involved in it. And so we say that likewise, the court is presented with a straight dispute of fact between the claimant and Mr. Long about the claimant having raised a series of issues about his treatment in the unit with Mr. Long, including, in particular, allegations that he was being mistreated on grounds related to his nationality. Now, the question is, how did the line manager react? And what is, I believe, common ground is that Mr. Long did not escalate anything or do anything about those complaints if they were made. So if the court concludes that those complaints were made on the facts, again, one has a position where nothing has been done about them when they have been raised.
Right. Well, what would you do about the racially tinged comments were made in the anonymous complaints? They weren't made in there were 2 complainants who identified themselves, who Ms. Al-Najjar spoke to. And there were 2 anonymous complaints. One, I think, from a nom de plume, Jack James, and the other one was just, I can't remember what it was.
The other one is redacted, I believe.
Yes. So how do you investigate those complaints? I mean, I know you say that they should have conducted a more detailed investigation, but how would you do it? I mean, you've pieced together a proposition to the effect that there is commonality between the language in some of these complaints and Mr. Akbar, but that's after 10 days of trial and the investigation of many thousands of documents. In practical terms, how could the bank, in this context, have conducted that process and arrived at that conclusion as a matter of practical reality?
Sorry, I'm having some quite big pauses on the line.
No.
Is this unique to me?
Yes. Well, certainly. Well, it's
yes,
not my experience.
Seems so. I'm fine.
Can I just? Can Your Honour still hear me now? I'm just going to see if that speeds things up a bit.
Yes. Right.
I'm also going to try. Sorry, while I'm doing this, I'm just going to message someone to try and get a hard wire to plug in, which can speed up my internet. It appears that internet problems are not unique to
Australia.
Australia. A40, given that Mr. Setti and I are in not that far away from each other geographically, I'd hope I'd have similar luck to him, but there we are. I think that the position, sorry, I've got to be quite, I should say, being candid, that I am surprised by Your Honour's questions, but I don't say that they are unwelcome, because it's important, if Your Honour is troubled by these issues or thinking about these issues, that they are out there, and as such I welcome them. With regards to the test here, the first point to make is that the bank has not pleaded a defence by reference to or alluded to Article 54(2) in its pleaded case. It has not led evidence as to, and the burden would be on it. Don't forget, in Article 54(2), if the employer is unable to show it took such steps as were reasonably practicable to prevent the employee from, etc., etc. So we say that on this issue, the burden would lie with the bank as a matter of evidence. Now, I don't want the case determined one way or the other on the burden of proof, but I simply make that point. I also make the point that the nature of the inquiry here, posited by Your Honour, is one where one needs, in my submission, not to look at the individual incidents individually. One needs to ask the question, was this employer put on notice of the fact that there was discrimination going on against the claimant in this unit? Your Honour has correctly said that at the end of 10 days of trial, that picture has emerged. Well, Your Honour hasn't said this. I would submit that that has emerged with clarity.
Well, with respect, the reason I'm asking these questions, Mr. Bickford-Smith, is that, as you recall, at the end of the trial, I said what I'm really interested in is the evidence of discrimination by reference to one or other of the protected characteristics. And it seems to me that the closest you get to that are the three things that we've been talking about. That is the reference to a cop of the colonial era and the reference to an English scholar in the two anonymous complaints. And the third is the alleged statement by Mr. Akbar to Mr. Vaselli. Now, of course, your client also says that he was mocked, his accent was mocked and so forth, but that's denied by a lot of other witnesses. So in terms of the hard evidence, it seems to me it's those three things. And so that's why they're of particular importance.
Your Honour, Your Honour, there are in fact two. Your examples 1 and 3 are the same. Yeah. So the colonial cop is the alleged Akbar comment to Vaselli. So 1 and 3 in your.
No, I thought, well, wasn't it English Masters? Akbar to Vaselli was English Masters, wasn't it?
I better just double check that. I thought it was your 1 and 3 were the same, but nevertheless.
Yeah.
Well, Your Honour referred to another example, which is the claimant's witness evidence at paragraphs 10 and 52.1. And that evidence was unequivocal. And it was that his nationality and accent and vocabulary were the subject of regular negative comment. There was negative.
The denial of that was equally unequivocal. And Mr. Long contested any assertion that all the assertions made by the claimant that he had reported those matters to him.
Yes,
and so I don't know how I'm going to resolve those conflicts, but
the court
with the two written complaints, we know what was said because we've got the documents. But that's everything else is contested. So that's the significance of these two.
But Your Honour, I should make the observation, which is a very important observation, that the fact that something oh sorry. Can you still hear me?
Yes, I can.
Okay. the fact that something, it is of the nature of most discrimination claims that they do turn on what was said or not said, what is undocumented. And the court, in my submission, has to make findings of fact on that by reference to ordinary principles about the credibility of witnesses. And that is why, we have advanced submissions on those in such detail.
Yeah.
So that is what we say on that. But what we say is that these are not isolated, the incidents to which Your Honour has referred are not isolated and one-off incidents occurring out of a clear blue sky.
Well, the only source of that proposition is Mr. Mahmood's evidence, isn't it?
That's correct, Your Honour.
All right.
And the question Your Honour has to reach, that has to answer, is whether Your Honour believes Mr. Mahmood's evidence or whether it believes the evidence of Mr. Akbar, Mr. Sheikh and Mr. Long. And there is no ambiguity about the fact that as a lone claimant bringing his claim, the claimant is on a numbers game, starting from the position of being 1-3 down.
There's another point here too, isn't there, Mr. Bickford-Smith? So that if I were to find, of course I haven't made up my mind yet at all, if I were to find that there weren't a continuing course of conduct, then in relation to the three issues that we've been talking about, you'd have a serious limitation problem, wouldn't you?
We would have to ask the court to extend
you'd have to
time.
invite me to extend time. And
that
on what
is
basis?
correct.
Well, you can deal with this later if you like, but you need to tell me at some point why you say I would extend time if I came to that conclusion.
This has been, I believe, dealt with in the written closing.
Oh, well, I must have missed that. Whereabouts do I find that?
Sorry, I've just got to try and find it. It's so the law is set out at paragraph 226 of the submission. That's on internal page 81, bundle page 85.
Yes, I've got it. Yes.
And then at paragraph 285,
yes,
we make our submissions on that.
285, let me just go there.
I'm going to hazard the camera again. If I log out, to state the obvious, that is not anything other than...
That's all right. All right, 285, yes. All right, yes. Right.
And before moving on to this, can I say that Your Honour has referred to a conflict of evidence, but that conflict of evidence, it's credibility, and I include within credibility, just to be clear about this, what the documentary evidence before the court shows. In other words, whether that documentary evidence is more consistent with the claimant having given a credible account of events, or whether that evidence is more consistent with the other witnesses having done so.
Yes. Okay.
And with regards to continuing course of conduct, can I deal with that issue now?
So just before we leave 285, I'm just reading it now. You say, this is a case where the true reasons for the bank's conduct were kept hidden. What do you say the true reasons were?
We say that what there was, and this was, I believe, said already, but if not, it was certainly said in opening. There was a toxic admixture, we say here, of hostility to the claimant for having raised compliance issues, and hostility to the claimant on grounds of his national and racial origins. And where those two most conveniently crystallize is in the reference to a colonial cop. Now, Mr. Long's evidence was that it's not uncommon for compliance people to be called cops because they're involved in the business of regulating the business. And what we say here is that there is a combination, a toxic combination, we say, of resentment at the claimant for raising these issues and resentment at the claimant on grounds of his racial and national identity. That's what we say. And what we also say, and when we talk about the bank's unforthcoming approach to pleading its case, I simply refer to the fact that in the original defence, no reference at all was made to the January 2019 emails.
When do you say Mr. Mahmood first became aware of the January 2019 emails?
It was after the particulars of claim were filed, because
he didn't. It was after these proceedings were started.
Correct, and the means I believe is referred to in paragraph 285, which was that what happened was that the claimant made a data subject access request.
Right.
And the response to that came in after these proceedings were issued.
Right. Okay. Thank you.
So we say that our primary position is that this is a continuous course of conduct, because the point, let me give a counter example. I'm mindful of your honour's example of two labourers. It may be helpful to give another example. There can be examples where one sees an employee bring a claim in respect of things happening in different job roles, in interactions with wholly different people, and so on. Now, in this case, the core of the claimant's complaint relates to how he was treated by a series of people who remained, and I use the past tense because it is the case that personnel have slightly changed, but over the course of his employment in this role, it is the individuals who Mr. Sethi sought to identify in cross-examination, fairly enough, who are indeed named in the witness statement and the bits of the particular claim. And it is in respect of them that the claimant's complaints all focus. And in this regard, can I underline, because I'm sure my learned friend, well, he may point this out. I would be surprised if he didn't. But Your Honour will see that, for example, in our closing, we are not pursuing allegations, for example, relating to Mr. Mahboob's conduct of the investigation. Those were things that were out there. They were open to us on the pleading, but those are not being pursued. And the reason for that is that Mr. Mahboob gave an account. There were obviously disagreements, as Your Honour will remember, over the course of the cross-examination. But Mr. Mahboob conceded that the nature of his investigatory task, that Your Honour may recall this business of upwards only escalation, i.e. that rather than going to conduct a detailed factual investigation of what happened in a forensic or quasi-judicial way, the bank's approach is to escalate, i.e. to go to what the managers are saying. That was his evidence. And in the light of that evidence, it follows that the nature of his role was different to what it had been apprehended to be. And in any event, that is now water under the bridge, because that is not a point being pursued in closing. But the reason I mentioned Mr. Mahboob is that he is someone, Your Honour will recall, he is based in, I believe, Hong Kong, or that region. Now, he is someone who is an outsider from this unit and what is going on in it. The core complaints relate to what was going on there and also what is going on up the compliance management chain. So those are the claimant's complaints. I trust that
well, can I just ask you, in relation to what you're pursuing, you pleaded a claim for breach of duty under Article 43 of the Employment Law. Do you press that?
Yes, we do. It's not a claim that actually, as Your Honour may be aware, it's not a claim which gives rise to anything other than a small fine for the employer.
Yeah.
I don't want to describe it as a derisory fine, but certainly for an institution of the size of this defendant, it's not it's not in any way a significant sum. But what we say is that when Article 43 says an employer shall provide and maintain a workplace that is free of discrimination and victimization and without risks to an employee's health and safety, we say that that is a duty which has a meaning, and it goes to the points we're talking about. And it goes to the fact that even when these matters come to the attention of the bank's ERHR function, steps are not taken to protect the claimant. Now, this oddly is a semi-pleaded issue, because there was the Article 43 claim is pleaded fairly and squarely, but the point I'm making in terms of environment is that Your Honour will recall there's this long debate about which particular policies and procedures of the bank were or were not in force in the UAE at the material time. And what we say is that underlying that technical series of debates, which in fairness, I think that the bank has succeeded in my submission in demonstrating that one of the particular policies was not in force in the UAE. But that would go to a contractual claim that hasn't been brought.
Has a limitation point been taken against you in relation to your Article 43 claim?
I think, in fairness to the defendant, a general limitation point is taken. I don't think that anything specific is said about that claim.
Do you say there's any difference in the relevant limitation principles for that claim as compared to the Chapter 9, the discrimination claims?
Well, I have looked at this. That is a position where prima facie the restricted time limit that applies to Section 9 in my submission, and this is a submission that I suppose cuts both ways. What I would say is that it does apply, or it should apply by analogy to Article 43. But sorry, no, it's not that it should. It could apply by analogy to Article 43, but the more likely outcome in my submission is that one goes back to the general principle that a claim has to be brought not by reference to an act, but by reference to the end of employment. And that is that is Article 10, subject to Article 61(2), a court shall, can I just check Your Honour has Article 10?
Yes.
A court shall not consider a claim under this law unless it is brought to the court within 6 months of the relevant employee's termination date. And this claim was. So what we say is that is the primary position and the claim is in time. If the court is against us on that, we say that the position to put it this way, if the discrimination law time limits apply, the extension provision must also apply. You can't have the one without the other.
Yes, sir.
But our primary position is by reference to Article 10.
Yes, thank you. When was the date of termination? Can you help me with that, Mr. Bickford-Smith?
Yes, I've got to go this. Hang on. I think the easiest place to go for that, I'm about to go to the pleading, but actually, why not go to the chronology? Where is it? Hang on. I believe this, I'm trying to give a date which is non-contentious. Mr. Sethi will correct me in due course if I'm wrong, but I believe the correct date is the 9th of January, 2021.
Yes, all right, thank you.
Let me just...
And those proceedings would commence in April 21, I think.
Correct.
Yes, thank you.
So that claim, we say, is in time. So, Your Honour, I've been addressing Your Honour's questions, and I'm grateful to have done so. What I wanted to turn to was Your Honour's wider question about how does Your Honour make findings where matters are denied by bank witnesses and there is no corroborative evidence in the form of other witness testimony to support the claimant's case. And in my submission, the correct answer there is for Your Honour to consider what has emerged over the course of cross-examination, the credibility of the accounts which have been given, and that is the way forward. And what we say is that a particularly important point which has emerged here is that, can I stick to the January 2019 grievances?
Yes.
Has Your Honour got in our closing the appendix on witness credibility, which is at page 107 of today's bundle?
Yes, I can get it. Yes.
And if Your Honour goes within paragraph, within that to paragraph 29,
yes, I've got that.
so what we say is that what he says there initially is he came to know through the normal speak up and HR process that there was an investigation going on and certain grievances. That was post the investigation. And that was clarified, day 6, page PDF 22, page 86, that this was clarified as having occurred on the 16th of June 2019. But then I took Mr. Sheikh to the email at 1898, which is an email of the 29th of January 2019, in which it said in terms we'd not be able to discuss the grievance as HR treats such cases as confidential when they are following up. And we then had Mr. Sheikh and the way he dealt with that. And in my submission, the position very simply here is that he has ended up with some denials. I don't know what grievance this is referring to, but the contemporary email, we say, speaks for itself. And that is an example of how we say Mr. Sheikh's evidence proceeded. And what we also say is that an important aspect of this is what Mrs. Al-Najjar said on day 8. This is day 8 of the transcript. PDF 6, page 24.
Yes.
And what she says was, and can I possibly take your lordship to that transcript reference?
Yes. Day 8. Yes.
Day 8. And one sees on page 24.
Yes.
This was in the context of her, of Mrs. Al-Najjar's onwards referral of these to Ms. Tabara. And what her answer was there was, I came to know these two colleagues were going through a lot of anxiety and stress and they weren't feeling comfortable dealing with Shiraz. So I asked Rayhan to guide them to speak to me because it came from, I think, Sahel to Rayhan, or Rayhan found out. And as I said, okay, fine, they can meet with me and share their issues. They need to share their issues, etc. So the position is that, far from it being the case that Mr. Sheikh only came to know about these issues in June 2019, he was actually aware of these from much earlier, as is shown both by that email and by that passage of Mrs. Al-Najjar's evidence. And can I take your lordship to, I'm sorry to move around, but it is important. Can I take your lordship to day 7?
Yes.
PDF 50, page 15.
The PDF 15, is it?
PDF 15, internal page 57.
Yes, I have that. Thank you.
And Your Honour said, well, the question you were asked, Mr. Akbar, I'd be grateful if you could answer it, is whether you agree that you were providing assistance to those two ladies in relation to their grievance against Mr. Mahmood by sending them the emails. So these were the emails that we found in the bundle where in September 19, Mr. Akbar forwards on to the eventual complainants documents. And he says, yes, well, when this thing happened, I provided my emails in order, and Your Honour said, in order they could use them to ventilate their grievance against Mr. Mahmood. And he says, yes, because they were already aware of it from being part of the team. And then I put that Your Honour, of course, has the great advantage that Your Honour will get answers to his questions, being the judge of fact. I, as an advocate, then turned to the question of, I pointed out that part of this grievance shows that these complainants knew things about what was being said in management meetings where they were not present. And I didn't get anywhere with that. But and we had a long exchange there, and this was sort of redolent of it because we got a denial, we then got through, and there we got to the email which Mr. Akbar denied. And this, sorry, as we're on this page, page 60, I'm not privy to this email before this one, so could it be, etc. And what I submit unequivocally about this is first that there was a campaign going on against Mr. Mahmood as of January 19. Second, that when Mr. Akbar came to give his witness statement about this, and can I now, sorry, go back to the trial bundle?
Yes.
7768. The header is on the previous page, 7767.
Yes.
And what I say is that this evidence was untrue. And in my submission, the court should have no hesitation in finding that Mr. Akbar has been caught out in evidence because of the coincidence between the content of this email and the content of his email to Mr. Peters. And that is, Your Honour, integral to and exemplary of the kind of fact-finding exercise that we say it falls to Your Honour to do, i.e. to look at the submissions that are being made in section C of the claimant's closing in support of his contention that the claim is made out.
So what do you say is a lie? The paragraph 63?
Paragraph 64.
Well, the email referred to in paragraph 63 is the anonymous email.
Correct. And what we say is that
Mr. Akbar admitted that he gave the emails to the two.
It's a separate email. But this, your lordship, was sorry, Your Honour may recall, was where we went to that email and then we went to the content of Mr. Akbar's emails to Mr. Peters in September 2019. Sorry, 28.
Okay.
Does Your Honour recall that moment in evidence?
Yes, I do. Yes, I do. Yeah.
And what we see was that Mr. Peters said, I'd remove this bit of your response to the claimant because it looks too personal. It's not going to go down well. And then we see the same material in this anonymous email.
But again, the statement in 64 is that he hadn't seen the email of the 30th of January. That's not directly contradicted by the fact that he may have given his email to Peters to somebody, is it?
Well, that isn't what he said.
But he's saying in 64, I didn't know that this anonymous email had gone in. Is there any reason to doubt that?
There's every reason to doubt that, Your Honour. These are complaints raised by two people who he is line managing.
No, I'm talking about the anonymous. We don't know. This is the anonymous one. We don't know who the author of speakingup.com was.
No, correct. But the question is,
I take your point in relation to the two people who's managing. I take your point entirely, but that's not what he's talking about here. He's talking about the anonymous email.
Yes, but what we say is that, I mean, someone must have got the content of this email from somewhere, mustn't they?
Yes, but the fact that he might have given it to lots of people in the previous September, but that doesn't mean that he knew that somebody was going to use it on the 30th of January, does it?
Well, Your Honour, it's open to Your Honour to find that there is a coincidence here, but then one would need to go back to the fact that in his I3 interview, Mr. Akbar showed his awareness of all four complaints. And he, in cross-examination, sought to resolve from that. But it's perfectly apparent, we say, that I mean, I say this to Your Honour. There are distinctions between what can realistically be shown by an employee in a discrimination claim and the detail with which, say, one will be able to make out another civil claim if in another matter. I mean, it needs to be understood that discrimination claims depend on the court drawing inferences and making findings of fact. Now, I think possibly at this stage I should go to the operative question for discrimination law. And can I go to Nagarajan? This is in the old authorities bundle.
Yes.
At page 51, I hope. Can I check that? Let me see if I can give another. Let me give the
old authorities bundle are in section K of the previous Oh, they're in the trial bundle. Well, I've got Nagaraj, and it's number 13 in that.
And what one sees in that is in the, I'm going to go from, does Your Honour have a pagination that says 8201 at the top?
That's what I'm looking at, yes.
If Your Honour goes to 8212 of that report.
Yes.
So some points there are made by Lord Nichols of Birkenhead. We do not always recognise our own prejudices. Many people are unable or unwilling to admit even to themselves that actions of theirs may be racially motivated, etc. And then next sentence, an employer may genuinely believe that the reason why he rejected an applicant had nothing to do with the applicant's race. After careful and thorough investigation of a claim, members of an employment tribunal may decide that the proper inference to be drawn from the evidence is that whether the employer realised it at the time or not, race was the reason why he acted as he did. It goes without saying that in order to justify such an inference, the tribunal must first make findings of primary fact from which the inference may properly be drawn, etc. So one then goes on to the question of inferences, but the point I wanted first to refer to the nature of inferences, but then can I go to the bottom of that page? Decisions are frequently reached for more than one reason. Discrimination may be on racial grounds, even though it is not the sole ground for the decision. A variety of phrases with different shades of meaning have been used to explain how the legislation applies in such cases. Discrimination requires that racial grounds were a cause, the activating cause, a substantial and effective cause, a substantial reason, an important factor. No one phrase is obviously preferable to all the others, although in the application of this legislation, legalistic phrases, as well as subtle distinctions, are better avoided so far as possible. If racial grounds or protected acts had a significant influence on the outcome, discrimination is made out. So that's the test. And there was, and I can short circuit this, there was then some debate about what the words significant influence meant. And in the case of Eigen and Wrong, and this is also in the authorities bundle, it's number 21, I hope.
That's the trial bundle.
Sorry?
Yes, I've got it. Yes, I've got it. Thank you.
What's said there is at paragraph 37, because there was some controversy about what the word significant meant. What's said there is, and this is at page 8343, a significant influence is an influence which is more than trivial. We find it hard to believe that the principle of equal treatment would be breached by the merely trivial, etc. So that is the test that we say the court should helpfully apply. And we say that the question is therefore whether the claimant's race or nationality played a more than trivial role here. And we say that where you have evidence that at the flashpoints of this employment, racial and national expressions and points are creeping into the narrative, that is a sure pointer that the inference to be drawn is that those thoughts were in the minds of those in the unit, of those managing the unit. And one of the oddities of this case is that it is the bank's case that the claimant's inability, as it puts it, to build a better relationship with the unit was integral to his eventual selection for redundancy. And what we say is that that is a very clear example, to go to Your Honour's question about what the employer knows. The people making that decision, Mr. Long and Mr. Sheikh, were aware of the claimant, were aware of what we say had been occurring. and they made the decision to terminate. And we say that that is the correct set of inferences. Now, there are cases, the reason I mention this is there are cases where a decision is made at point B by people who are wholly extraneous to what has gone before, and that is simply not this case. So I've taken your honour through the case and our case on continuing act. What I wanted to turn to, and will now turn to, if I may, is the nature of the bank's objections. Unless I don't think it would be sensible for me to deal with this in reply, because I've got quite a lot to say, and it's been
I
put
agree.
in.
Yes.
I should say that I am behind where I hope to be, but I will be as brief as I can. Can I simply deal with the following points? And this is all by, I'm going to go through this partly to save time, simply by reference to paragraph numbers within the bank's submissions. And for reference, that starts those start at page 137 of this bundle, and I'm going to pick this up at 7.4. The point that is made there about race. Our submission on that as a matter of law is that the court should not conclude that race discrimination excludes obvious facets or manifestations of a claimant's race, such as skin color or ethnicity, and there's nothing in the legislation to support that approach. I've covered the Caucasian point, and in any event, I have a time issue now. Paragraph 8.5 is quite important here, because this is an attempt to narrow the claimant's claim on race by alighting upon particular phrases used in some parts of the particulars but not others. And the reason this is important is that this is the foundation for later complaints about matters not being put to witnesses. The first point to make is that the legislation itself it provides broad descriptions, namely race or nationality. It does not set out in detail this need to define characteristics in the manner suggested. The next point is paragraph 40, just for your honour's note, paragraph 40D of the particulars referred to in the specific context of the colonial cop argument incident. British nationality and stereotypes of the conduct of British people during the era of colonial rule, etc. And one can see that part of that, i.e. the colonial rule aspect, coming into 8.53. But that is something that is said at that point in the particulars of claim in support of the averment of discrimination. It is not narrowing the claimant's case to a point about colonial rule. What matters is whether there has been discrimination on grounds of national origin and identity. Likewise, with regards to Mr. Vaselli and Mr. Mabeen, those are points pleaded in support of the averment of discrimination. It is not the case that one can reach where one gets to in 8.61 of these submissions. And the reason this matters is that what's later being said is that, well, let me just deal with, sorry, paragraph 9.2 I just want to deal with. And in my respectful submission, this is not what these cases are not relevant to the issue that we have here, because in the Akwiru case, the court was concerned with discrimination on the grounds of immigration status. That is a separate point. We then have in Patnell Nice, again, you're looking at a residence requirement. I mean, these are not arguments or requirements for discrimination in employment. And the other point is that the because of point, in my view, does not on these facts take the court anywhere that's necessary. Put very simply, either the court is going to make a finding of fact in one direction, or it isn't. And I don't think that the difference matters there. Now, the reason this matters is that when we come on to section 16, which starts at page 158, it's paragraph 16. There are a series of complaints made about the cross-examination. Now, there are so many of these because they're not just made here, they're made later on in the body of the submissions, that it's quite hard to deal with these all in one go. But I need to make the following points briefly. First, in many cases, the complaint depends upon a false premise as to what the claimant's case is, or what the claimant needs to prove to establish liability. Second, there is repeated recourse to what I would refer to as the rule in Brown and Dunn, but there is not a proper consideration of what the rule does and doesn't require. And third, I find all of these complaints perplexing because whatever else can be said about the evidence of, for example, Mr. Akbar, there's no doubt that he knew that what was being put to him and chose to deny it. Now, analytically, the correct starting point, and can I now take Your Honour to today's authorities bundle?
Yes.
And hopefully Your Honour will have a page numbered 1194, which I believe may be PDF 690 if Your Honour is working off a separate bundle.
Yes, I'm working on the PDF 690.
Now, this is FIPSON.
Yes.
I doubt that Your Honour needs to be taken through the basics of FIPSON. But can I simply take now, why has, hang on, 12 point, hang on. Yes, 12.12 at paragraph 1, page 1197. I hope it's clear. It's clear on the screen there. In general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted. The rule applies in civil cases as it does in criminal. In general, the CPR does not alter that position. This rule serves the important function of giving the witness the opportunity of explaining any contradiction or alleged problem with his evidence. If a party has decided not to cross-examine on a particular important point, he will be in difficulty in submitting the evidence should be rejected. Thus, where during the trial a witness has not been challenged as inaccurate, it was not appropriate for that evidence so then to be challenged in closing speeches. However, the rule is not an inflexible one. If there's a time limit, etc., not practicable to cross-examine on every minor point. Failure to put a relevant matter to a witness may be most appropriately remedied by the court permitting the recall of that witness to have the matter put to him. Now, the first point following from this is that the fundamental point of cross-examination in that context is to challenge the witness's own testimony, and that was what was done in that case. If a witness has chosen to say nothing about an incident and to stay silent, one is put back onto the question of what the scope of the obligation on the cross-examiner to put allegations. And it's at that stage that I would like, please, to take Your Honour, again within the consolidated authorities bundle, to tab 15, which is at page 1017 PDF 513. That's for the case. This is Mr. Justice Nugee, now of course Lord Justice Nugee. And when one gets to, it's a long judgment, but the operative bit comes at page 572 of the PDF. Now, as there's a specific reference to Australian and Canadian practitioners knowing all of this and possibly applying it applying it in their jurisdictions, can I just invite your Lordship to read through paragraph 111 and the quotation. If your honour is in fact already is going to say to me that your honour knows this quotation backward already, I'm not going to insist upon your honour reading the document.
No. No, we're very much alive, and his lordship was right to refer to Australian practitioners being very familiar with this.
And we
but
then
I should say though, it has been watered down to some extent in practice by the practice of the exchange of witness statements.
Yeah.
Sorry, no, you go.
No, that's right. And what we say is that not only is it watered down in that, certainly in, I'm not going to give evidence about Australian procedure to an Australian judge. No. I think that would end fairly badly. But certainly in England and Wales, what one sees is the position as put at 112, namely that the question becomes the one identified, perhaps unhelpfully, at the bottom of 112 after the excerpts, sufficient to draw his attention to the fact his evidence was not accepted, and giving him the opportunity of giving his explanation. 113, rule of basic fairness, and then Brown and Dunn, the facts, of course, were that their witnesses were not challenged at all. And then 114, so long as it's clear from the thrust of cross-examination or from notice given beforehand that a witness evidence will be challenged, I do not see that it's necessary to continue exploring a point in detail where the witness has already had an opportunity to state his case. As Mr. Morm himself said, Mr. Hawkesbridge denied that tax considerations were a purpose, and having done that, it was inevitable that he would deny that obtaining sideways relief was his main purpose or one of his main purposes. Having obtained the answers he did and having challenged them, I do not see that it was necessary for Mr. Blair to continue to ask the main purpose question. It would have been an empty technicality. Now, we say here that this should be applied as follows. First, the bank's witnesses knew the allegations the claimant was making, both from his particulars and also from his witness statement. I point out that there was an opportunity for reply evidence. The position, as I had taken it to be before the exchange of closing submissions, was that the battleground here was clear, namely that the bank witnesses had gone into a blanket denial of discrimination having occurred, full stop. And that is, in my submission, really the end, at least as a matter of generality, of this point. I do want to take your honour, because this point is, a point that is taken repeatedly by the defendant. I also want to take your honour to the main authorities bundle, if I may. And
yes,
to page 397. It's the Denby case. Let me get it.
You said So this is today's bundle or the
no? Sorry, bundle? This is the main authorities bundle, and is the easiest thing for me to give Your Honour a. Sorry.
Was it Denver? You said.
Yeah. It's tab 42.
All right.
And this is a decision of Mr. Justice Kerr. And again, as I'm trying to deal with this as briefly as possible, can I go to paragraph 54 of that judgment, which is at 8725 of the initial bundle?
Yes, got that. Thank you.
So the case is set out, and then Your Honour will be very familiar with all of this, and then we come on to paragraph 58 on FIPS and the relaxations of the rule. We have further discussions, etc. But what we say at paragraph 60 is where, in fact, a point made by Your Honour comes in. Lady Justice Carr noted that in modern litigation, Mr. Justice Carr noted that in modern litigation, the parties have more advanced written material. The springing of an unfair surprise at trial is much reduced by the expansion of pleadings, written witness statements, lists of issues. It's safe to say that here the MPS and the tribunal had more material stating the nature of the claimant's case than did the defence and jury in Brown and Dunn. There's then discussion of the Cheng case, which is a Privy Council case. And can I just briefly, this is 8728. One factor, this is in paragraph 55 of Cheng, that one factor specifically mentioned is the closeness of the grounds to the points which were put to the witness, the reasonableness of the grounds not being put, etc., whether the ground had been raised, the plausibility of the notion that witness might have satisfactorily. Now, this thus far, if I may say so, we are in the orthodox application of Brown and Dunn. But the interesting point that we come into is at paragraph 62, which is one of the questions here is the defendant explaining its own conduct? Because one of the defining characteristics of this case is that the defendant has chosen to explain the basis of its decision-making in some detail. So that's the statement of the law. And then one looks at the application of it, which in my submission is persuasive here, and that's at 8733 paragraph 80. And we see a submission such as made by him, should have been squarely put to him, do not fully and properly reflect the pleaded case and cross-examination. Complained that the questions did not include a direct suggestion that he'd been guided by others in making his decision, etc. So points very much what we're seeing here. And then 82, I'm unable to conclude that there was procedural unfairness of the Brown and Dunn type here. The context included the expectation that the MPS would be likely to proffer a full and frank explanation of the claimant's treatment. The tribunal noted its admission to do so, its lack of transparency, and some evidence consistent with a desire to disguise the influence of senior decision makers. I think it was adequately put that he conversed with the other two, may have been subject to the influence, pleaded as much, etc. The claimant had no direct evidence of conversations and had to rely on inference from policy documents and such matters as the holding of meetings, documents from which did not disclosed. A direct question of the type envisaged would undoubtedly have elicited a flat denial, which the tribunal would have rejected. And then here, yes, a point isn't directly pleaded, but then the court goes through it and say that this matter had been out there in a clear enough way before the tribunal for the finding to be properly made. Now, I've taken your lordship through that case, because it is an application of the correct principles, we say. Now,
where it's arrived in Australia, and I think to a significant extent international commercial arbitration as well, of course they're not bound by the rules of evidence, but the rule in Brown and Dunn traditionally was an exclusory rule, so that if you didn't put the proposition in cross-examination, you couldn't put it in closing. But that's now been modified by current practice, and it now seems to be, rather than going to issues of procedural fairness, it forms part of the fact-finding process. So in other words, you look at the extent to which the case has been, when you're evaluating the probabilities, you look at the inferences to be drawn, and one of the facts that you would take into account is the extent to which the witness has been given the opportunity to dispel that inference.
Yes.
It's not conclusive, but it is a relevant factor. So that, for example, if you wish to contend that there is an inference to the effect that certain things were motivated by discrimination on the ground of a protected characteristic, and if you haven't put that to the witness, then that will be relevant to assessing whether the inference should be drawn. Doesn't mean it won't be drawn, but it is a factor. Now, on a couple of occasions, you put that squarely to a couple of witnesses, but on other cases you didn't. So I think that's basically where we're at, isn't it?
Well, yes and no. Yes, as a matter of generality, I accept that analysis, but I do not accept the I do not accept the premise to this extent. In my submission, once the witness has availed themselves of an opportunity to deny in blanket terms that there was any discrimination, it is redundant then to say, well, you discriminated against them at this instant, that instant, because their answer is clear that there was no discrimination.
But have they in every case been given the opportunity to deny that there was any discrimination?
In my submission, they have, yes.
Through the witness statement?
Through the witness statement, and where relevant, through the cross-examination. The way I'd put it is that there's nothing being pursued in closing where we say that the witnesses were not given a fair opportunity to meet the case.
All right. Well, I'll just have to assess that on a case-by-case basis. I think.
Well, can I in assisting the court with that process, can I just give some very quick references?
Yeah.
And can I also flag the particular importance of the issue of a concern here at false premises about what needed to be put, which is very important. But if we go to paragraph 17.7 in brackets 6 of the defendant's submissions, sorry, 17.17 6. Some of these paragraph 17 ones are very lengthy.
Yes.
But this is, I believe, at page 44 to 45 of the internal pagination.
Right, thank you. Yes, I've got it.
What's said here at the bottom is, even if made, C's claim is the comment that SA was uttered, da-da-da-da-da. So the reason why C says Mr. Akbar made the content is very, very specific to being on the grounds of C's British nationality and Asian race, and being partly of Pakistani origin, and having a British accent, and or appearing to have repudiated a Pakistani identity. This was not put to SA. Well, we say first this is wrong as a matter of the pleading. But secondly, we say, and the reference there is sorry, I'm not going to waste time on that. But what I'm going to go to instead is the transcript. Sorry, I should give the reference. It's 61 to 61A of the amended particulars of claim for your honour's note. But then if I go to day 7 of the transcript.
Yes.
At page PDF 18.
Yes.
One sees a long exchange starting. This is about Mr. Vasselli, so we may as well start it at the top.
Yeah.
And it says,
would you just repeat the page reference for me?
PDF 18, internal page 69. Sorry, day 7.
Day 7.
PDF 18, internal page 69.
Thank you.
And it was put, the truth of the matter is that the hostility to the claimant from you, shaded here again into a point about his British nationality, didn't it? Answer, not at all.
Yeah.
So, and in fact, this comes after a lengthy period of cross-examination where Mr. Denard had made a whole series of denials about discriminating against the claimant. So, in my submission, this is it is not correct to say that Mr. Akbar has not had the opportunity to advance his case. He has. And it is also plain as a pikestaff that what one would have dealt with, even if the claimant question been put with further iterations, refinements and complexities, is that one would have got blanket denials. So we say that this is not a valid Brown and Dunn commission. The next type of Brown and Dunn complaint we have with which we do not agree is seen at paragraph 17.22, a few pages on from this. This is, I take this as a simple example, but it is an important one. It said it was not put to Ms. Bajwa in cross-examination that Mr. Zulu's disciplinary decision was reached because of the protected characteristics. Well, it wasn't the bank's case that she was the decision maker. It wasn't the claimant's case that she had discriminated against him. It wasn't incumbent on the claimant to put to Mr. Bajwa an allegation that someone else had. That's my submission on that, Your Honour.
But I understand your Brown and Dunn point, but what is the basis upon which I could infer that the outcome of the disciplinary appeal was motivated by race or by discrimination on the ground of a protected characteristic?
Because we say that this is not a complaint directed at Mr. Zulu. I mean, he's the decision maker nominally, but what we say, and I mean, I'm mindful of time. I can answer this point. It's going to take me 5 minutes, but I'm going to do so. But I don't believe in dodging questions. The answer to this.
No, well, I just want to know what your case is. You say that you do submit that the outcome of the disciplinary appeal decision was motivated by discrimination on the ground of a protected characteristic, do you?
Correct, and it's also, I believe, pleaded victimization. The point here about that appeal, which Your Honour may recall, is that what one sees is that Mrs. Al-Najjar comes in when Mr. Zulu asks the basic question of, which followed which happened first. This is shot down on the basis that Vasselli is conflicted, he's changed his testimony, etc. There is no debate but that Mrs. Al-Najjar had seen the claimant's complaint against Mr. Akbar before disciplinary action was undertaken.
Right. So your reasoning then is that Al Najjar has the improper motivation and she has influenced Zulu.
Correct.
Is that that's
but
the way it works?
it's put as it's primarily a victimization claim. But the point about it as a matter of discrimination law is it's really a matter of causation. If your honour concludes that the reason why the original disciplinary was undertaken was discriminatory, then the question that your honour is going to have to ask himself is, apologies for using common law concepts, but is there effectively a break in the chain of causation? In other words, your honour can say very fairly, and I'm not going to mess around about this, your honour can say that it hasn't been put, or at least hasn't knowingly been put by me, because I wouldn't put it, that Mr. Zulu has taken a negative against the claimant on grounds of his nationality. And the question is going to be, does the court consider that the chain of causation catches this act, or does the court say, no, there's Mr. Zulu's made his independent decision and that's the end of it, and it's not being put that he's a discriminator and therefore I dismiss that claim? That's a matter for your honour.
Yes. All right.
Your honour, I'm nearly done, but I'm not so nearly done that I can't suggest a sort of 5 minute, 10 minute break.
Why don't we take 10 minutes?
That would be great.
So return it a little after the half hour.
I'm grateful.
Yes, all right. Leave the lines open in case there are technical issues, but turn off cameras and microphones and be back in 10 minutes. We could?
Yes, thank you, Your Honour.
Resume when you're ready, Mr. Bickford-Smith.
I can hear, Your Honour. I was getting the reason for the delay was I was getting a reference which I either promised or meant to promise to Mr. Vasselli's evidence.
Yes.
And there are multiple versions of this. And the first example is that at 3224.
Let me just pull that up.
At the top of that page.
A minute.
And can I also refer, Your Honour, to Mrs. Al Najjar's cross-examination on day 8 at pages 109.
3224. What's this? Yep. I'm looking here.
It's the bit in red at the top of the page.
And what is that? That's a statement from...
Okay, sorry, to put that in context, 3222.
Yes. So this is a file note prepared by Tabra, is it? Or...
Yeah, that's right. To which you can see at 3223, Mr. Vasselli has added text in red. So that's what this is.
It may be useful for me just to interject to say, Your Honour, this is in the bundle as version 5 of Mr. Vasselli's.
Right, thank you. That's right. I remember that. I remember now. Yes, that's right. There were various versions, weren't there? Yes.
And we went through through the versions.
Yes.
In some detail.
Right. Well, yes, I'll have to revisit all that. No doubt.
And can I refer, Your Honour, to day 8 cross-examination? And there is, I'm not going to take up Your Honour's time going through this in detail, but if one starts at page 109, one sees a long exchange with Mrs. Al-Najjar about these various versions and so on?
Yes.
And what we say effectively is that what can be seen over those versions is that further points are being raised by the questioner over the successive drafts, and those questions are being answered in writing.
Yes.
And the reason I referred to, Your Honour, to the passage also is that Mrs. Al-Najjar stated in terms her view that the complaint couldn't have been upheld in any event because it was not corroborated by a witness.
Yes.
So that is where we are on that. Now, I was covering the Brown and Dunn points, and I'm afraid I possibly forgot to make one important point, which is that the defendant's argument depends on categorizing as background matters a series of matters that are not background matters. So, for example, at paragraph 17.2, there's a description of issues as background, but we do not accept that the circulation of the compliance framework and what followed it is simply background. It was a core part of the claimant's case that the reactions to the compliance framework were motivated by race and nationality, and that was put to all the witnesses. So, for example, again, I'm conscious of time, but can I refer to the transcript of day 6?
Yes.
And can I refer specifically to PDF 39?
Yes. Yes.
And there we see the question put to Mr. Sheikh, the reasons why the Islamic banking senior management team reacts so strongly and so negatively to the claims included the fact he was a British Asian. And then he said, I don't think that anything has to do with his background or his nationality or his being British Asian. So that's an unequivocal denial. That's anything. To be very honest, it never ever came up as far as I was concerned. This conversation has never happened.
Page 39 on day
6. So this is PDF 39, page 155 of the internal pagination.
Right.
Can I check that Your Honour has that? Sorry, I'm unable to see Your Honour, but hopefully Your Honour can see me.
Yes. Yes.
155.
It says, I can't see. Read again what you were saying. It was about the MSA.
Does the transcript say day 6 in the top left?
Yes.
Page internal page 155.
Yes. Starts the top. Is an offer made to the claimant of an MSA
No,
or mutual separation agreement.
No, it's not that. That's not the one. It should start against Mr. Patel, Zunaid Patel, on page 153.
No. Day 6. No.
This is the 26th of February.
Yes. That's odd, isn't it?
I don't see it either.
Can I ask Your Honour to do a word search for the words "the" space reasons?
I've only got a hard copy transcript.
Okay. Can I ask those instructing me to send another copy of this PDF, because it may be that I have a rogue copy. I know that this was a day when there was a problem with the transcription link for 15 minutes. It may be that there are two versions of this document. Let me also go to my hard copy. Day 6. Day 6. 155. Oh, hang on. No, this is wrong. Can I ask you, I'm going off my hard copy, which for some reason is different from my soft copy. Can I ask your lordship to get your honour to go to page 163 in the internal pagination near the bottom?
Yes.
The reasons why.
Yes.
Is that there or not?
Yep. Yes, that's it. Yes.
So that's put. And the reply is, I don't think that has anything to do with his background or his nationality or his being British Asian. To be very honest, it never came up as far as I was concerned. This conversation has never happened where we looked at him in a different way. Just pausing there, the we shows that Mr. Sheikh clearly identified himself, and obviously correctly so, as part of the Islamic Banking Senior Management, which is the terms of the question. So, I mean, he correctly identifies this as an allegation against him as well. And he answers significantly in a collective way, which is why this cross-examination had taken this turn. Our approach was we had Mr. Mahmood, etc. And we have an answer there. And we then have further down 164. I put to him that what had happened hadn't happened to him elsewhere, and then over the page. Mr. Viselli is not subject to anonymous complaints, etc. And
yes.
at the bottom of 165, we set the point being made to him is that whereas with Mr. Viselli, one set of things had happened, the claim was treated differently, and the point was expressly put. The point is that with the claimant, you don't move on, and the difference I put to you is connected with his racial status, etc. So Mr. Sheikh has given blanket denials here. And it's simply not right, therefore, to say that he wasn't given the opportunity to give his response to allegations of discrimination. He did so. He gave a blanket no. Issue is joined. And in my submission, that's the end of that. With regards to there's one specific point about Mr. Sheikh I should mention, which is that Mr. Sheikh was called before Mr. Akbar and Mrs. Al-Najjar, and as great as my powers of advocacy may or may not be, Your Honour, one thing I can't do is jump into a time machine. So I was obviously not able to put to Mr. Sheikh points which emerged from the cross-examinations of Mr. Akbar and Mrs. Al-Najjar. Now, I don't, for myself, see that as necessitating a recall of Mr. Sheikh to answer those points. But I do want to be very clear about this. There was important evidence which emerged from Mrs. Al-Najjar's testimony about the extent of her interaction with Mr. Sheikh and the exchange of information about them routinely about HR and ER matters, including with regards to Mr. Mahmood. And that evidence was squarely contradictory to what Mr. Sheikh had deposed in evidence. Now, the way that the closing has been drafted is to avoid making the allegation that, in reliance on the matters I've just mentioned, that Mr. Sheikh had given dishonest or inaccurate testimony to the court on that basis. We say that there is enough other material to draw the conclusions that we need on Mr. Sheikh's credibility. But I do want to be clear about this. There are many ways in which, the more this closing goes on, the more I can see the number of ways in which I may be unable to persuade Your Honour, and Mr. Mahmood may lose his case. But what I would say is, whichever way the case is resolved, it would be deeply regrettable were it to be resolved on the basis of matters that emerged from later evidence not having been properly put to earlier witnesses. And the witness we're talking about here is Mr. Sheikh. And it is the case, and I will not shy away from this, that if we had had those examinations first, there would have been several other lines of cross-examination of Mr. Sheikh. I'm not going to mess around about that. But the closing has been drafted in a way which we say is tenable in and of itself. There are punches it has to pull in this regard. But if the court is seriously concerned by this Brown and Dunn argument, specifically I would mention as against Mr. Sheikh not having been given the opportunity to comment on things, then as per Phipson, the correct way of remedying this, I mean, a lot of the Brown and Dunn cases are appeal cases, but the correct way of remedying this at first instance would be to go through an exercise that I have to say I regard as of questionable use, unless this point is of technical validity in your Honour's finding, which would be the recall of Mr. Sheikh for what would be no more than an hour to wrap up these loose ends. But you'll have noticed that is a point that I'm making right down my batting order, because we say we have enough there.
It's not something I would lightly contemplate.
No, it's not something I would lightly ask for. I can tell you, Your Honour, can I also say that we all change our mind on points in life. If Your Honour changes his mind on this point, and when Your Honour is writing the judgment, Your Honour becomes very troubled by this point, and Your Honour orders a hearing, first of all, I would have no objection. But secondly, can I please urge, and I mean no disrespect to anyone when I say this, because I know that it's entirely outside the court's own hands, but can I please say that any hearing would please come on as soon as possible, and we just get it over and done with and fast, because there has been quite a, as the court will see, quite a period here, and we would want this resolved, if this is a matter of concern to the court, very fast. Now, as regards Mr. Akbar, because I've been so detailed about other witnesses, I'm going to put simply some references. It's paragraph 7, day 7, PDF 18, 69. And I think that's really the only one I'm going to go to. The others I'll just mention for your honour's note. But if we go to page 17, and I hope that this is one where the page numbers of everyone match up.
Well, I don't. Page 69 is on PDF 18 of my.
Yes, that's right. PDF 18. That's I misspoke on that case. It's also a PDF halfway down the page.
You took us to this a little while earlier.
Exactly. I've gone there already. I think that we have, as regards Mr. Long, for your note, what was put to him specifically were the points about protected acts, the points about his knowledge of the claimant's complaints. That's an example of that. Day 5, PDF 41, page 161. And it was also put to all the relevant witnesses that the key decisions were made at the by or at the behest of Mr. Sheikh or Mr. Akbar. So, for example, the court will recall the long exchanges with Mr. Long, my apologies, regarding the rating, the performance rating given after the 365 feedback that the claimant submitted on Mr. Akbar, and it was explored in some detail there what role various people had in that decision. Mr. Long's evidence, as the court will recall, was that it was his decision. Our case was that this was a decision into which Mr. Sheikh had factored, etc. That point is pursued in the closing. Now, the final point I want to make is that with Mr. Long,
yes.
Sorry, Your Honour.
I'm tangled up in cords here, but never mind. Yes, all right.
I didn't know my submissions were having that effect.
No, it's my. I've got so many computers open. I've got cords everywhere. Anyway.
Well, if Your Honour saw a broader video broader video of my room, Your Honour would possibly instruct me to get a personal injury lawyer on board, such as the trip hazard. But I am surrounded by an island of papers. But the couple of points. So just standing back, this Brown and Dunn argument. I've taken the court to Denby. One can see a tension between the obvious importance of fairness to witnesses, but the obvious importance as well to the court not being simply in the position where a series of people don't deal with issues or deal with issues in a very evasive way, and then the court saying, well, I can't be sure enough of this, and this, effectively the court saying, well, there's been discrimination here, but I don't think the right allegations have been made in the right way against the right people, and therefore the case fails. And that is something the courts have come out strongly for the reasons seen in Denby. The next point is that I don't see any point on Brown and Dunn and Mr. de Groot unless I've missed something. I've gone through these submissions because to me this is of the smacks of a sort of procedural objection. My submission is that the case has been put clearly to the bank's witnesses. They have met this case, and we are a very long way away from these cases. I think that my learned friend has cited it's Secretary in State and Dunn, but one sees that in Dunn, 2 points. One sees first that the operative findings relate to entirely unexplored issues, and that on no conceivable view can be the case here. To move on to an ancillary point, the court also needs to bear in mind the general approach, which I hope is the same in Australia. I could be wrong, but the general approach that the court takes where a defendant or a party has effectively shut up shop when in possession of relevant knowledge. And the case in the UK on this is the Preston Petrodel case. That is in the authorities bundle. Is it an authority with which Your Honour is already very familiar?
No, I'm not. I'm not, Mr. Bickford-Smith.
Well, it's a. I'm going to find it. Consolidated authorities. Yes, this is in the bundle, the extra bundle, today's bundle at tab 12. This was a.
No, I've got it in PDF, so I don't have tabs. Can you give me a page?
379.
Right, thank you.
The PDF, which should have 883 written at the top.
Yes, it does.
This was a judgment of a 7-member composition of the Supreme Court, and it concerned the issue of ancillary relief. The operative point in it is that what the court had to deal with was a situation where there was an argument, or there'd been an argument at first instance about piercing the corporate veil with regards to a series of companies. And just by way of very brief background, a practice had grown up in the family division in this in the UK, whereby the family division felt able to, as it put it, pierce the corporate veil quite readily, and the House of the Supreme Court said, well, no, you can't do that. But then what the court went on to find was that that didn't mean that the court simply had to give up. And so one sees it. Can I pick this up at paragraph 44 of the judgment in Prest?
Yes.
So there, Lord Sumption approves a dicta from a tax case, which is, in my submission, uncontroversial. The silence of one party in the face of the other party's evidence may convert that evidence into proof.
So this is paragraph 44, did you say?
Yes, of Sumption. I've got a, sorry. No, okay. The problem your lordship has is that paragraph 44.
I'm in the Court of Appeal.
Yes, I know that, and it is paragraph 44, but it's paragraph 44 in the Supreme Court, and I have I'm getting there very fast. It is at PDF page 449. Is it? No, sorry. It's 456. No, it isn't. Yes, it is paragraph 456. So first of all, there's Harrington, which is was the Railway Board case with which I think all law students, possibly worldwide, are familiar, or within the common law world. So that was a case where the railway company had shut up shop, and the court said no. A court's final paragraph of the reference from Harrington, final sentence, a court's entitled to infer from the inaction of the appellants that one or more of their employees decided to allow the risk, etc. Then we have the pullback from that, which was it is explained and quite possibly a factor in other jurisdictions. And then we have the position set out in Coombs, and what's said in Coombs in there, and the crucial bit really, a prima facie case may become a strong or even an overwhelming case, but if the silent party's failure to give evidence or to give the necessary evidence can be credibly explained, even if not entirely justified, the effect of his silence in favour of the other party may be either reduced or nullified. And then what Lord Sumption said.
What's the silence you're referring to here? What's the analogy to this case?
Well, if I can get there, is
all right.
Sorry, it's in the next paragraph. So this is about disclosure. There is a public interest in the proper maintenance. Partly for that reason, the proceedings, although in form adversarial, have a substantial inquisitorial element. The family finances will commonly have been the responsibility of their husband. The concept of the burden of the proof, which has always been one of the main factors inhibiting the drawing of adverse inferences from the absence of evidence or disclosure, cannot be applied in the same way to proceedings of this kind as it is in ordinary civil litigation. These considerations are not a license to engage in pure speculation, but judges exercising family jurisdiction are entitled to draw on their experience and to take notice of the inherent probabilities when deciding what an uncommunicative husband is likely to be conceiving. So the point is that where a party, as in that case, has shut up shop, the court, and where that party has the relevant information, the principle is that the court can draw inferences. That is also the Harrington principle. The reason I refer to it here is that the bank has served voluminous evidence, but a factor repeatedly returned to in our closing submissions is that on very material incidents, the bank has simply not led evidence. And the simplest example.
What subject are you referring to there?
The simplest example of that is the fact that we know there was a meeting in July 2019 as between Mr. Long, Mr. Sheikh, Mrs. Al-Najjar, and I believe it's Mrs. Tabara. Now, the point about that meeting is that if one places it in the correct context, it is plainly apparent that it was a very significant meeting. Mr. Long gave evidence that this was option discussed in this was a mutual separation agreement. Another issue was performance management and so on. Now, can I just give the reference, because this is an important point. Can I give the reference in our closing submissions, please? It's paragraph 101. Now, it is, we say, extraordinary that both that incident and then one sees in the next paragraph an email from 2020, February 2020, revealing that around the same time, July, August 19, there was a discussion of an MSA. Now,
well, you asked questions about this meeting, did you?
I did. But the point I'm making,
I'm struggling to see what the point is. Then,
my point, Your Honour, is a basic point where the bank has avoided incidents and issues and given no evidence about them. The court
has given evidence about it in your cross-examination of these witnesses.
Yeah,
these witnesses were produced for you to cross-examine, and you did.
Yes, well, as long as the court's proceeding on that basis, I'm content. The point yeah. So that's that. Then we have continuing act. Now I have just one point to add. I've already covered continuing act. Can I just deal with one point very briefly? There is a need to keep firmly in mind what degree of knowledge the claimant had at which material times, and I've referred to the DSAR in that regard. And then I want to conclude with some comments about the, not comments, submissions succinctly about the victimisation claims. Your Lordship will have in mind when deciding on the victimisation claims, the wording of the statute, which in my experience in victimisation nearly always gets forgotten. And in this case, it's paragraph 6, article 60. I say this because victimisation, of course, has a common meaning, which is not the same as its legal meaning. That's why I'm dealing with this point. Can I just draw article 60 to your honour's attention? So subjects the employer to detriment or dismisses him because the employer does a protected act or the employer believes that the employee has done or may do a protected act. Each of the following is a protected act: bringing proceedings, giving evidence or information, doing anything, making an allegation that the employer or another person has contravened this part 9. Now, we say there is no serious doubt here. Those are referred to, by the way, as protected acts in the statute. That's where the language comes from. There's no doubt here in our submission that there are a series of protected acts. The question the court may have, and I don't know whether the court has this question, but I mention it. The question the court may have is, well, if your case is that the claimant was being discriminated against anyway, how did things get worse upon the protected act or protected acts occurring? And I mention that because it is a question that can evidentially creep into victimisation claims. And my response to that is straightforward. If one looks at the chronology, and all of this is set out in section C of our closing, if one looks at the chronology, one sees that it is when, and I'll just take the leading example, it is when the claimant escalates the complaint about Mr. Akbar and what Mr. Akbar said to Mr. Vasselli. One sees after that a series of actions taking place in short sequence. And it was put fairly and squarely to the witnesses that this was about victimization. And this particularly matters because as regards Mrs. Al-Najjar, your lordship will be aware that there is no case put to Mrs. Al-Najjar that she has personally discriminated against the claimant. Yeah, the case that was put to her was that she was acting at Mr. Sheikh's behest and in liaison with him. But the victimization claim stands against her. The key issue on victimization is an issue of causation. And that is an issue which Your Honour will be more than familiar with as a matter of general civil law. The final point I make about victimisation is that this is a very unusual case because we have contemporary evidence that the claimant, Mr. Mahmood, has raised these issues internally. And it is to the serious discredit in my submission of the bank's internal systems that one sees that escalation was never thoroughly investigated by reference to the actual facts. Finally, with regards to harassment, this is all dealt with compendiously in my closing submissions. Can I cut a very long story short and say, if Your Honour is with me on what happened, for example, in the meetings after the circulation of the draft compliance framework, Your Honour is going to find that there has been harassment within the meaning of the statute. If Your Honour is not with me on the claims involving direct interaction between the claimant and others, then Your Honour is going to be against me on the harassment claim. And with respect to the very interesting law in this area, it's not a case that turns on fine points of law harassment. What we say, and just to wrap this up, is that on the issue of remedy, I am surprised to see what is submitted at the end of my learned friend's skeleton about the claimant not having served a schedule of loss, and this all has to be the issue subject to further evidence. There was no direction for a schedule of loss. The court knows the operative point, which is that the claimant was out of work for more than a year afterwards. The basic statutory cap is a year. And therefore, it's very hard to see how the claimant's claim does not succeed up to the level of the basic cap. With regards to, because he hasn't been challenged and rightly not on mitigation. With regards to the issue of Vento bans, I believe that somewhere in the closing submissions it was promised, the Vento guidance was promised, and I certainly haven't seen it in this bundle. I think that's a matter that we can send to the court afterwards. But in a nutshell, the Court of Appeal in England has laid down a series of guidelines for injury to feelings awards. Those are obviously expressed in sterling. They are obviously not directly applicable in this court. They may be of assistance to the court in evaluating what award of injury to feelings, if any, to make. And the reason I deal with this issue briefly is not because there has not been a very good case made out for an award of injury to feelings. It is because given the 1 year cap on a basic award, and given the fact the claimant was out of work for a year, I think that's really that. The issue that does arise, and which is important, is where we stand on damages under the law of damages and remedies. Now, can I simply flag that this has been dealt with in opening, it has been dealt with in closing, and I don't intend to expatiate upon the basic point that Article 42, and this is for your honour's reference, this is, I'm afraid, in a little passage of this skeleton that got a little bit full of typographical things, I think. Oh no, it just comes before that. Paragraph 233 in the closing. May in its discretion award damages to an aggrieved party in an amount no greater than 3 times the actual damages, where it appears to the court that the defendant's conduct producing actual damages was deliberate and particularly egregious or offensive. Now, I flag my submission that this is an issue of fact. Your Honour has discussed what the degree, if you like, of culpability or the degree of lack of control or the degree of knowledge of the bank. It is going to be Your Honour's task at the end of drawing the findings of fact and law to reach a decision on whether an award is merited, and if so, in what multiple. And I think that further submission on this issue is OTOs. What is not OTOs is to end this claim by saying, and I consider beginning by saying this, but I just wanted to get to Your Honour's questions. Mr. Mahmood is the first individual to have taken to this stage a claim under the 2019 employment laws anti-discrimination pleadings provisions. These are important provisions because they extend to workers in the DIFC a right not to be discriminated against. Now, there was previously a right, but there was no remedy. The key question that the court is going to have to face underpinning all of this is, for there to be a sensible remedy, for this legislation to have meaning and value and to stand for something, it is important that undue hurdles are not erected in the path of claimants. And this point is the final authority I'm going to take Your Honour to. It's in the original authorities bundle. And it's the case of the King and the China Centre. Very well known.
Do you have a tab number?
I will do. It's 1991. So it must be about tabs 4. It's quite a very old case. And it's paragraph 38.
So it's tab 4 of the original bundle, is it?
It should be, yes. King and the Great Britain China Centre, 1991 IRLR 513.
Tab 4 is Islamic something or other.
Right. Hang on. Let me just. This should be at page 8. Is this 8218 8224? Hang on. 8224 in the top right hand number.
Just a minute. I'll try it. I'll look for it. Oh, there we go. I've got it. I was in the wrong authorities bundle. Here we go.
I'm afraid that I have just I've been rummaging around to check this is the correct page. But paragraph 38 of this report, which is at the bottom of 8086.
8086.
Yeah, it's top right numbering should be 8086. Bottom numbering should be the bottom paragraph numbering in the report should be 38.
Sorry, you asked me to go to 8224.
No, sorry, 8086.
Right. Okay.
I think something's. And then over to 8087. I'm going to hold it up so that I'm.
Yes. Yes. All right. Well, it's taken forever to load in my machine, I'm afraid.
I'll just read it out then.
Yes.
From these several, so this was a authoritative distillation of the principles. From these several authorities, it's possible, I think, to extract the following principles and guidance. 1, it's for the applicant who complains of racial discrimination to make out his or her case. Thus, if the applicant does not prove the case on the balance of probabilities, he or she will fail. 2, it's important to bear in mind that it is unusual to find direct evidence of racial discrimination. Few employers will be prepared to admit such discrimination even to themselves. In some cases, the discrimination will not be ill-intentioned, but merely based on an assumption he or she would not have fitted in. The outcome of the case will therefore usually depend on what inferences it's proper to draw from the primary facts by the employment tribunal. These inferences can include any inferences it's just and equitable to draw in reply to a questionnaire. There's no questionnaire procedure in the DIFC. 4, there will be some cases where, for example, the non-selection of the applicant for a post or promotion is clearly not on racial ground, a finding of discrimination, a finding of difference in race will often point to the possibility of race discrimination. In such circumstances, the tribunal will look to the employer for an explanation. If no explanation is then put forward, or if the tribunal considers the explanation to be inadequate or unsatisfactory, it will be legitimate for the tribunal to infer that the discrimination was on racial grounds. This is not a matter of law, but as May LJ put it, almost common sense. It's unnecessary and unhelpful to introduce the concept of a shifting evidential burden. At the conclusion of all the evidence, the tribunal should make findings as to the primary facts, and draw such inferences as they consider proper from those facts. They should then reach a conclusion on the balance of probabilities, bearing in mind both the difficulties which face a person who complains of unlawful discrimination and the fact that it is for the claimant to prove his or her case. That, Your Honour, is the law in a nutshell. That is the approach we say that you should take.
I just don't see how it really applies with great force to this case, because really there are two alternatives. You say that Mr. Mahmood was discriminated against and suffered all that he suffered as a result of discrimination on the ground of protected characteristics. The bank doesn't say, no, there's no explanation for this. The bank doesn't sit silent. The bank says everything that happened to Mr. Mahmood was a consequence of the unsatisfactory aspects of his role at the service as an employee.
Correct.
So it's not as if I have to fill gaps by drawing inferences. It's a question of choosing which of those two is to be preferred.
Yes, I'm heartened by that, and And what we say is that is exactly why the focus of so much of the cross-examination was dealing with the bank's alternative explanation, and we say that what one ended up with, and it was done with great skill on the other side, but what one ended up with was a series of incidents over the course of Mr. Mahmood's employment, which were really very few in number. I mean, one dealt with an email dispute with Mr. Law in Hong Kong being escalated to Mr. Phoebe. One was then dealing with the decision to which Mr. Mahmood admitted may have been ill-advised, but it's not suggested this conduct was in some way wrongful. And what we say is it's been blown out of all proportion. I mean, there was a lot of cross-examination on that. But with regards,
the bank puts that Mr. Mahmood was persistently escalating matters that he should have when he should have got on with business. Instead of getting on with business, he would threaten to escalate everything. That's
yes, well, this is the word. When the word everything is used, what we say is that there are a series of instances which the court has had over the course of several years of employment, and we say that they simply don't justify that. I mean, we're looking from memory at something like 5 email chains. So what we say is that, I mean, let me just take the other example. In the case of the 365 feedback about Mr. Akbar, it's sort of portrayed as some sort of state crime or high misdemeanor has been committed by Mr. Mahmood for having sent this feedback. The evidence here is that Mr. Long saw this feedback before it was sent. He later supported it. You can see, and it's referred to in our closings, the email exchanges between him, Mr. Phoebe, and Mr. O'Donnell, whereby Mr. Long says in terms, I'm concerned about how this has been dealt with. It's been dealt with, effectively as an issue about Shiraz rather than Mr. Mahmood, rather than about Mr. Akbar. The court has seen the way that all of this plays out, and what we say is the court has also seen no evidence, no proper evidence from the bank to the effect that if someone else had done this, they'd have been treated in the same way. The closest one gets to this is Mr. Vasselli. It's very interesting that Mr. Vasselli hasn't been called by the bank, we say, but Your Honour says it's the impetus is on us. But anyway, the point,
Mr. Beacon-Smith, we could talk about this case for the rest of.
I have concluded, so I'm just addressing the point. But can I just conclude by saying that the bank's alternative explanation it needs to be understood. The question for the court, it could be the case that the court finds, yes, some of what Mr. Mahmood did, raised hackles, but his race was still a significant influence on the decisions that were made. And that's what we say is this case. And what we say here is there is the scale and exaggeration and force and frankly vitriol of the reactions to what Mr. Mahmood did or did not do simply cannot be ascribed to his manner in some sort of vague way. It is clear that this was bound up with a deep personal hostility to him. And on that note, I conclude.
Thank you. Thank you, Mr. Bickford-Smith. Mr. Setti, you ready to start, or would you like a break?
No, I think in the circumstances, given that we're now three hours and 20 minutes in, we should crack on. My learned friend's been going for.
Do other council have time constraints today?
I'm sorry, Judge.
Do you have any time constraints? Do council have any time constraints?
No.
All right.
No. But I note that my learned friend has been going for 3 whole hours, and that on top of the 20 minutes of housekeeping at the beginning. But that's not the criticism. It's simply
feel free to do the same if you want, Mr. Setti.
Thank you, Judge. This is a claim of direct race discrimination, victimization, and race-related harassment. There is also a spurious, we say, other claim relating to Article 43(3) in Schedule 2 of the employment law. But I'll spend a little time on that aspect. It's essentially a claim where the claimant is complaining that a great many people, individuals, all senior members of management, have all been consciously or subconsciously, but it's difficult to see how it could be subconscious, because what he claims here is a conspiracy. For example, my learned friends made it quite clear a few moments ago. Mr. Sheikh apparently brought influence to bear on Miss Al-Najjar, who brought influence to bear on Mr. Masood, all in a linked chain of discriminatory motivation. So he doesn't pull any punches. He is complaining of a wide-ranging conspiracy in terms of the number of senior members of management involved. He's complaining about a long-term conspiracy in terms of the number of not just weeks or months, but years of concerted detriment caused to him, all because of protected characteristics or alleged protected acts or allegedly related to protected characteristics. And those are the 3 essential tests for direct discrimination, victimization, and harassment. Now, Judge, in closing of evidence, you quite rightly, after having been referred to, we had a bundle, I think, trial bundle of about 8,000 documents. We had many witnesses cross-examined over some 9 days. And it is fair to say that my learned friend had every opportunity, without time constraints, to go uphill and down dale with every defendant witness to test and interrogate the apparently innocent explanation that they provide, the discrimination neutral or discrimination free explanation they provide for the actions and decisions that they took. So when I come to dealing with the Brown point, as my learned friend calls it, but really it's the Dunn point, we shall need to take that into account. There's only one act in this claim which is actually in time, and that is the act of dismissal in January of 2020. Everything else is out of time. All harassment claims, for example, are out of time. And there is going to be a very substantial time hurdle for the claimant. But even the act of dismissal is not an unlawful act for which liability should be found for the reasons I shall go through. Now, the oddity about my learned friend's position on the case is that the way he doesn't structure his submissions, both in writing and orally, is to say, this was my client's pleaded case. This is the pleaded case that we're asking the defendant to prepare for trial on, and this is the pleaded case that falls within the jurisdiction of the court to determine. And in relation to that pleaded case, we have all agreed a list of issues, and he didn't do anything by reference to issues in his written and closing. There was some in his written towards the end of it. And then to actually look at what evidence.
Could I just pause? Sorry, Mr. Sedig, can I just pause there? I looked again at the list of issues, and they were prepared quite a while ago. And the case has really moved quite a lot from there. I mean, I just can't really see the utility of me going through by reference to those issues. And some of them, frankly, are poorly expressed, to be really frank. And one of them, number 4, for example, asked me to determine whether there was, in fact, whether the Shiraz conflict of interest was real or not. Well, why would I determine that?
You don't need to. For the reasons, Judge, you said in closing of evidence, you're not conducting an inquiry into the processes and fairnesses of the...
And those 40 issues seem to me to have actually been constructed on the premise that I was conducting an inquiry.
Well, indeed. Indeed. But can I say, Judge, this is precisely why I have taken pains in closing and in opening to set out what I consider to be the substantive allegations that are pleaded and need to be determined, and those which are what I've referred to as background evidence. You might want to refer to them as non-substantive or something upon which you don't need to decide. That's what I mean by background and non-substantive. They are of evidential relevance, but they're not anything that's calling you to make a decision on as such.
Yes. Essentially, the 40 issues, the most use I intend to put them to, unless anybody objects vociferously, is as a kind of aid memoir to myself, to make sure that I've covered all the bases. But to go through them and answer all of them specifically would be tedious, not only to the author, but also to the reader, I think.
Well, I entirely agree, Your Honour. But the reality is when a defendant is faced with a shopping list of individual alleged unlawful acts of discrimination, it has to meet each and every one. And that's why, one may call it tedious, but it was necessary. But it may not be necessary for your judgment that I need to answer each of those, and why I say they are either misconceived or not put or just fail on the evidence. So in my written closing, I'm not going to take Your Honour through a great deal of law. I hope nothing that I've said in my closing written submissions about the law has been contradicted by what my learned friend has said recently. So I'm going to take it that I have accurately and fairly summarised the legal principles at play for both direct discrimination, victimisation and harassment. Now, the first point that really does need to be made is that you cannot, in cases like this, change your case without amendment. The case is the pleaded case. It's a question of law as to what the case is. It's either there or it isn't. Many an appeal court has determined such in most common law jurisdictions. So the starting point has to be what the pleaded allegation is and how it is put. The list of issues, Judge, is, of course, an aid memoir. It's a roadmap. It's meant to be of assistance, but as it says itself, it's not a substitute for the pleaded cases. So your anchor point, your source point has always got to be at stage 1, what's in the amended particulars of claim about this, what's in the defence, what's in the witness evidence and documentary evidence, what's in the transcript. And that really does have to be gone through if one is not to have a complaint from the complainant subsequently that some pleaded allegation of discrimination has not been addressed. In the one thing I should add, which takes me, I'm rather surprised by it, is that you can't change the protected characteristic that you seek to rely upon as the weather changes. You have to pursue your pleaded case. It is abundantly clear, if you look at the amended particulars of claim, And we went to this in opening. It's in the transcript on day 1 too. But the there are two racial characteristics that the claimant relies upon in this claim. One is set out in the amended particulars of claim, I'll say APOC for shorthand. One is set out in APOC 61A, 62.2, and 62.4. The second is set out at APOC 152. There's no doubt about it. There's no mystery. The first one is a protected characteristic, which is defined as the claimant's status, quote, as a British Asian of partly Pakistani origin who spoke with a British accent and was taken to associate with British colonial rule and or to suggest that he had repudiated a Pakistani identity ascribed to him. 61A, 62.2, 62.4. Now, this is the reason why the claimant has pleaded that members of GIB in particular, in fact, only members of GIB, have acted against him. It's because of those racial characteristics. That's the race basis. That is a protected racial definition, or the protected racial reason why he says GIB treated me to my detriment. Nothing else. Nothing else. You can't redefine it as broadly not being Pakistani, or broadly something to do with nationality, or broadly something to do with British Asian, or broadly something just to do with an accent. It is that. It is because he says certain people took against him, in the GIB department, that is, because he was a British Asian, partly of Pakistani origin, who spoke with a British accent, and he was taken to repudiated his Pakistani identity. Now, that issue, I'll come on to the detail of how that was put in the case. But you can't, my learned friend can't change it unless he's seeking to apply to amend, which he's not. So that is the pleaded reason why. Let me be very clear about every word I use here. I'm not going to exaggerate or use hyperbole. That is the pleaded reason why the claimant says he was treated as he was by the GIB members. But he secondly says that he was treated badly by the white members of management in compliance because he was not Caucasian with white skin. That is quite clear. Paragraph 152 of the APOC. It says this in terms, in respect of the treatment meted out to the claimant by the management of the defendant's compliance function, the claimant's case is that the appropriate hypothetical comparator would be a Caucasian person with white skin. None of this is complicated. None of this is anybody taking technical points. It is the claimant's case. So when it comes to the direct discrimination claim, essentially what needs to be determined is whether the claimant was treated in the way in which he alleges he was treated. That's the first question of basic fact as to what happened. And the who did what and how to him is spelled out in considerable detail in the evidence Your Honour has seen and read, and is in large measure, 99% of it at least, is set out in my Appendix 1, because the vast majority of what happened, how and when is set out in that material from the defendant's point of view, admittedly, but the vast majority of the detail is and documentary references are all set out there helpfully. The critical question is the reason why. And there are two aspects here. Well, there's a less favorable treatment and a reason why. Ultimately, in relation to each alleged pleaded detrimental act of discrimination, the court needs to decide, did it happen as the claimant alleges it happened, or did it happen in some other way? That's just factual narrative. Did what happened, as found as a fact, amount to a detriment in law? In other words, does the claimant have a justified sense of grievance about it, or is he being hypersensitive, or is it a fully fair, performance rating, whatever it might be in the circumstances. So it's not a justified sense of grievance, because it can't then amount to a detriment in law or a disadvantage to him, reasonably. The next question is, was he treated less favourably than the statutory comparator? And in this case, he has chosen to rely not on an actual comparator, but a hypothetical comparator. One goes back to paragraph 152 of the APOC. He says a hypothetical comparator is what he relies upon, who was not a British Asian, but a Pakistani national of Asian race. And then he says that he specifically says he was treated less favourably because of being British Asian, partly Pakistani, British with British accent, associated with British colonial rule, and or repudiated Pakistani identity. So his case in relation to that racial characteristic is that A, B, or C treated me to my detriment in circumstances where they would have treated somebody not of my race more favourably. And that gets you so far in the statutory definition under the DIFC law of the less favourable treatment element. But then it must be shown that it was done because of the racial characteristic. And so the next question is, so you've established what occurred. Secondly, whether it actually amounts to a detriment in law. Thirdly, whether it was less favourable treatment than the hypothetical comparator chosen by the claimant. And then fourthly, whether the reason why it happened was infected by or caused or because of considerations of not being British Asian with or Pakistani heritage, except having repudiated Pakistani heritage, etc., or not being Caucasian with white skin. So there is a developmental analysis that the court has to undergo, and I hope that's very clear, and that's the basis in which I will relevantly make my submissions on that in a moment. So the less favourable test is, I've set out the law in relation to that, at least in the UK, and the because of element at paragraphs 9.4 onwards and 9.6 onwards of my submissions. We need to pause for a moment on the law just to observe that my learned friend says sweepingly that Your Honour will be familiar with the causation test in Western Australia or in the general common law. But here, there has been ample, high authority that it is not a but-for test when assessing the reason why something has occurred in a discrimination case. The fact that, as is said in the Amnesty International and Ahmed case, this is paragraph 9.8 of my closing, the fact that a claimant's sex or race is part of the circumstances in which the treatment complained of occurred, or of the sequence of events leading up to it, does not necessarily mean that it formed part of the ground or reason for that treatment. And that's been followed subsequently in the Gould and St John's Downshire Hill case. That's more than well established. And Martin and Devonshire's is also an instructive authority. This is, and Judge, I can, if after this hearing you wish to have all the cross references to which authority number.
I've seen them in the bundle. I've seen the case in the bundle. Yeah.
So long as you can get to it, and I'm more than happy, Judge, for you to cut me short if you think you've got the point. No. But this issue of causation is fundamentally important, and I say this unashamedly because you have made absolutely clear, quite rightly, the core of this case. In fact, what this case is really all about is the reason why. Everything else is detail. It's factual narrative, most of which is unchallenged, and in the event, it's really why things happened as they did. And Martin and Devonshire's says that the section is not breached if the employer can show that it took the action in question, not because of the protected characteristic, or as in Martin, because of the protected disclosures, protected act, sorry, but because of the way that the employee conducted him or herself in relation to it, provided that that conduct was properly and genuinely separable from the characteristic. So in other words, did we treat him because of him constantly escalating matters and his manner of interacting with people, or did we treat him because of his racial characteristic or any alleged protected act or related to a racial characteristic? And you have plenty of case law on this subject. I don't want to labour the point because you have it clearly set out.
Would you accept that if discrimination on the ground of the protected characteristic made a material contribution to the steps that were taken in relation to the claimant, that he would succeed?
Almost. I'd almost agree with how you've put that, but I totally agree that the protected characteristic does not have to be the 51% motivation. It could be a 20% motivation. It can be a material contribution to the legal cause as to why he was treated to his detriment in circumstances where others who do not have that protected characteristic would not have been so treated to their detriment. I agree with that.
Yes, right, good, thank you.
No, that's wholly uncontroversial. But what you still need, Judge, what you still need, and I accept this is the first case of this kind to reach full trial in the DIFC, but what you do need is, on the evidence, findings of primary fact to be made, and then on those findings of primary fact, they either give the answer as to why something happened, but if they don't give the answer as to why something happened, you would have to infer why something happened from those primary facts. And there would have to be something in those findings which lead to a more likely than not inference that the prohibited factor played a material motivating contribution to the decision, to the adverse decision to the claimant. And I say in this case, you just simply don't have that, despite my learned friend's very lengthy attempt at trying to undermine credibility of defendant witnesses. And at 9.10, I make the reference to CLFIS and Reynolds, where I say that where the manager committing the alleged discrimination, in fact, had no discriminatory motivation, but was acting on false information provided by another manager with that motivation, it is not possible simply to conflate all their acts. Each individual must be judged on their separate circumstances. That's a Court of Appeal case from 2015 recently. Lord Justice Underhill, who had given the judgment in Ahmed, the case I took you to a moment ago, the Amnesty International case, stated in CLFIS that liability will only be established where the protected characteristic formed the motivation for the individual performing the act complained of. Unwittingly acting on the basis of someone else's tainted decision will not be sufficient. I see no basis, he says, on which the individual employee who did the act complained of can be said to be discriminatory on the basis of someone else's motivation. And that was recently applied in the EAT case of Alcedo Orange, which held that the Court of Appeal decision Reynolds was very good law. Why do I say this? I say this because in my learned friend's closing just now, he says this. He says, we don't say anymore that Mirna Al-Najjar is a discriminator. We don't say anymore that Mahmood, I think he's, I've forgotten his name, but we all know who he is a discriminator. We don't say that Mr. Zulu is a discriminator. But, Judge, what we say is that there's this puppeteer behind the scenes in Mr. Sheikh who is pulling the strings. He's making these decisions, procuring these decisions, forcing these decisions upon, or forcing Mirna Al-Najjar to act as she did, forcing Mr. Mahmood to act as he did, forcing Mr. Zulu to act as he did. Where's the evidence for any of that? Where's the transcript reference that any of that was put? Where's the reference as to whether that was even put, whether the reason why that was done, those individual decisions were taken, was on grounds of the protected, because of the protected characteristic, because of a protected act, or because of a reason related to the protected characteristic? And the reason why it's not put is partly because the claimant now doesn't know their own case. They've dropped their case against so many individuals. Why do I say that? Well, my learned friend just now says he's dropped his case against Mirna Al-Najjar. She's no longer a discriminator, apparently. Dropped the case against Mr. Zulu. And that does make sense because in fact, the claimant dropped it if it was alive even then, when I cross-examined him on day 1 and 2 and asked him to spell out to me who exactly were the co-conspirators. Judge, do you remember the exchanges I had with the claimant? Gave him all the time in the world to list. And you'll recall that what he did was to list the 4 individuals in white individuals in compliance, I think 5 or so individuals in GIB. He stopped at that on day 1, and on day 2 he revisited and added the 4 people who raised the speak-ups. He didn't at any point allege that a co-conspirator was anybody involved in HR, ER, I3, or any other investigation process. Now, you would have thought his claim stopped there, and he wouldn't then go on about their involvement. And if he was going to go on about their involvement being influenced by others, then he'd make the link. But there is no link, either in submission or in evidence. But really, we need to focus on the evidence here. It just isn't there. And I hope that it is important. And one other point I should make at this stage is this. My learned friend says that now, for the first time, for example, he's not pursuing a claim against Mr. Zulu, Mr. Mahmood, Masood, and some claim against Mahbub, and some claim against Ms. Al-Najjar, for example. He says that. Judge, I think you need to know, if not me needing to know, right now, which claims have actually been abandoned, or whether I'm wasting my voice in replying to some of them, when actually they're no longer anything of any material relevance to the case. Because certainly he indicated a couple during his closing, but I was wholly unclear as to what claims have now been abandoned. But I'll just state that because I think it needs to be said. The victimization claims, the law in relation to that is clearly set out. Here, of course, there are a number of very clear, and Judge, I should add that I have been very careful to cross-reference and anchor my identification of each allegation of direct discrimination, each allegation of a protected act and victimization, and each allegation of race-related harassment to anchor that in the pleaded case. And in my submissions, you'll have seen my extraction of each act of pleaded discrimination as a discrimination 1, 2, 3, 4. I hope that made sense.
Yes.
Of protected act 1, 2, 3, 4, of victimization, detriment 1, 2, 3, 4, and harassment 1, 2, 3, 4, for example. And where I have said it is not pleaded either at all or as an act, an unlawful act in the particulars of claim, in other words, it just forms part of the factual narrative, but not actually pleaded as such, I've made that clear also. And that's how I come to the various numbered detriments in the analysis. I invite Your Honour to assume that analysis, but not uncritically. I think you can test my references to full force, but I say they are accurate and have been double checked. And I've cross-referenced them also to the extent that Your Lordship finds it, Your Honour finds it helpful to each issue in the list of issues. So again, no one's hiding any defence to a claim. So you should have all the APOC references, you should have all the list of issue references, all the defendant witness paragraph references, all the and within there in Appendix A, you'll have all of the page references to various turgid emails and lengthy documents that were gone through. When it comes to victimization, again, the claimant has a difficulty because he has to establish that on an occasion of making a complaint, that what he did or said amounts to a protected act in law. And as my learned friend took you to Article 60, subparagraphs 1 and 2, in order to do so, he must, and the only relevant one under Article 62, subsections A to D, is D, which is making an allegation, whether or not expressed, that A or another person has contravened this act. So it has to be a clear allegation of unlawful discrimination or victimization, something contrary to the act, to the employment law. It is an important authority in Shamoon, where Lady Hale confirms that, quote, an unjustified sense of grievance can't amount to a detriment. So the point I make there about even hearing victimization claims, the first question is, did what the claimant alleges amounts to a protected act occur? Did what he says amounts to a detriment occur? Because if it didn't happen, it didn't then happen. But if it did happen, what you find as a fact as happening, did that amount to a protected act? And did that amount to a detriment? Only then do you go on to the next stage of the analysis to understand why the detriment happened and whether the reason why it happened was motivated, consciously or subconsciously, by the knowledge of the protected act. So the victimizer needs to know of the protected act. And you'll have seen in my submissions that I'll come to in a moment in relation to each matter with which we're going to be concerned that these matters weren't put. Harassment, the authorities on harassment are important as well, because it has to be related to the pleaded protected characteristics. And if it was intended, and this is an important point, whilst harassment can occur if merely the effect is creating the adverse environment, the main case of the claimant is that the defendant employer intended. It was their purpose to cause the harassment. This was positively, consciously motivated to do so. Primarily, I think, by Mr. Sheikh is the suggestion by my learned friend. So one needs to see how that was put and how that's come across in the evidence. You've seen my authority of Richmond Pharmacology and Dhaliwal, and in that authority, Lord Justice Underhill, Mr. Justice Underhill, as he then was, did say, and this perhaps is of some relevance to this case, where we see there are instances of the claimant, perhaps, and in my submission, certainly, taking a hypersensitive approach to any thing that doesn't quite go his way. And you'll see in that case, the quote is set out at 13.2 subparagraph 3 of my submissions, where Lord Justice, Mr. Justice Underhill as then was, cautioned that we accept that not every racially slanted adverse comment or conduct may constitute a violation of a person's dignity. Dignity is not necessarily violated by things said or done which are trivial or transitory, particularly if it should have been clear that any offence was unintended. While it is very important that employers and tribunals are sensitive to the hurt that can be caused by racially offensive comments or conduct, or indeed comments or conduct on the other grounds covered by the cognate legislation to which we have referred, it's also important not to encourage a culture of hypersensitivity or the imposition of legal liability in respect of every unfortunate phrase. I only raise that in case we are ever in the territory of finding, not that I say we are, that, for example, the alleged Akbar comment was made. Now, the focus, and this is not a pleading point, an overly unnecessary technical point, the focus in all discrimination claims when we're dealing with the reason why, or whether in harassment claims you're dealing with the whether the treatment is related to the protected characteristic, one always must have in mind what is the protected characteristic. And it's not good enough to say it's race. It's not race. It is the defined racial characteristic that the claimant is relying upon. And that's why it is incredibly important that the case is fairly put to the witnesses. Incredibly important, of the essence in every discrimination claim, particularly where one is, can I say this, relying upon a hypothetical comparator. So one's relying upon, would this witness have treated the hypothetical comparator who doesn't have the claimant's protected characteristics, would they have treated that person more favorably? Now, to get to the bottom of that, you've got to explore that with the witness. And then there's the reason why. Did this witness act as he did because he was moved by considerations of the claimant's protected characteristic? Now, it's not good enough just to say because he's Asian, for example, because that's not the claim that's being pursued here. So one really does need to have a very close eye to the transcript. Fortunately, in this case, the transcript is very clear, showing all the indiscretions of both counsel and our lack of eloquence. But the transcript really doesn't lie. It tells you exactly what happened and what was put and how it was put at trial. Your Honor, I won't take you through the various authorities that I've referred to under the heading of related to. But perhaps there's one, the TSESC authority, which is in the opening bundle. It's referred to at paragraph 13.6, where I say this. Importantly, whilst the view of the complainant that the conduct in question is related to the protected characteristic in question is a relevant matter, it's not determinative. And His Honour Judge Auerbach reminded us in the TSESC and Weir Valleys case, a case in which a woman of British age and origin complained that a remark by a psychiatrist that a young man in his clinic should join ISIS, that'll sort him out, was not found to be related to race. So the fact that it looks like there's a racial element to a comment doesn't necessarily mean that it is related to the racial characteristics relied upon by the claimant in the case. The ET had accepted it was racial harassment because of a perception that ISIS, in the minds of a significant proportion of the general public, is that it is an international organization connected with Asian people, in particular in such areas as Pakistan, Afghanistan, and Iran. However, setting aside this finding, the EAT held that the ET needs to articulate distinctly and with sufficient clarity what feature or features of the evidence or facts found have led it to the conclusion that the conduct is related to the characteristic as alleged. Here, there was no evidence to justify the finding that ISIS was related to Asian or South Asian people, and it was not a matter of which judicial notice could properly be taken. So pause just to mention the issue of judicial notice. My learned friend can't invite you to take judicial notice that everyone assumes that they were being challenged about the very particular protected characteristic that the claimant pleaded here, if it wasn't put to them. Now, I deal with burden of proof at section 15. This, of course, is critical in this case. It means that decisions, and in fact, all decisions in the DIFC in discrimination claims will be decided in a different manner on the evidence as they are in England, because there is no reversal of the burden of proof at any stage. And here we've set out quite clearly what the correct tests are. But at every stage, the burden is on the claimant. At 15.7, I make the observation, which is important in this case, that if at that stage of looking at less favourable treatment, if you pass that stage, it doesn't mean that the treatment was on the protected racial grounds. In other words, a finding that the applicant has been treated less favourably than a hypothetical comparator won't lead to an inference that it was on racial grounds. And even if, let's imagine for a moment, a witness is not found to be credible, that doesn't mean that the reason why they acted as they did was on racial grounds. And an inference cannot be drawn simply from the fact that an employer has behaved badly. So in other words, let's imagine the claimant, over the years of which he complains, in every respect of which he complains, was treated really unfairly, really harshly. No reasonable employer would treat them in that way. Whilst evidentially that gives rise to a question as to why was the treatment so bad and so consistently bad, that in itself is not enough, is the point I'm trying to make, to warrant an inference that the reason was a protected racial characteristic or a protected act. So the point here is unfair treatment, however unfair, is not less favourable treatment, and unfair treatment, however unfair, is not on racial grounds or for reason of a protected act. And that then brings me on to this point about done. Remember, this is a case that the claimant brings against a hypothetical comparator. It's all about the mind and the inner workings of the decision makers. That's what this case is all about. It's why they did what they did, or what they would have done had the claimant not had the protected characteristics he has. Those matters need to be put fairly to the witness. We have authority in that, binding authority, at least in England, from the Court of Appeal in the Dunn and Secretary of State case. Judge, I don't propose to read out sections of section 16, but it is of the first importance in a discrimination claim that the case, particularly where there's a hypothetical comparator, particularly where you're alleging conscious or subconscious discrimination, particularly where you're alleging a conspiracy, particularly, Judge, when you're alleging, as you are against Miran al-Najjar or Mr. Zulu or Mr. Mahmood, that it's not them that were doing it, but they were being influenced by others who were so motivated. It is incredibly important to understand who made the decision, who took the act or omission, and why they did it. You can't import somebody else's motivation to them. And we know from Dunn, I've cited paragraph 26 of the EAT decision in Dunn of Mrs. Justice, similar as she then was president of the Employment Appeal Tribunal in England. She's now Lady Similar in the Supreme Court. At paragraph 26, she says, fairness and proper procedure does demand that the substance of an allegation is put to a witness so that he or she has a proper opportunity to rebut or explain it. However, as Mr. Boosfield for the employee submits, there are many different ways in which the substance of an allegation can be put, though he agrees, put, it must be. Moreover, we consider that in all but the most obvious cases, so in all but the most obvious cases involving direct discrimination, a critical part of the tribunal's consideration is the mental processes, whether conscious or subconscious, of the putative discriminator. If those matters are not explored and the claimant's case is not put, it is difficult to see how a tribunal can properly consider them. And that really is what this is about, because the general rule in civil cases is that a party is required to challenge by cross-examination the evidence of any witness of the opposing party on a material point which he or she wishes to submit to the court should not be accepted, or whether his case should be believed. This is a case, Judge, about putting the claimant's case. It's not about, oh, we've got very detailed explanations from a defendant witness as to why they did what they did. That may be the case, but that's not putting your client's case to the witness. That's a different proposition and a very fundamental one. And the purpose of the rule is to make sure that the trial is fair. Preserving the fairness of the trial. What does that mean? That means that it means fairness to the party whose evidence is being challenged. It means fairness to the party who has adduced the evidence of the impugned witness. It means fairness to the judge to be able to make a proper assessment of all the evidence to achieve justice in the case. And cross-examination gives the witness the opportunity to explain or clarify his or her evidence, explain or clarify why it is he did what he did, explain or clarify why he says he was not consciously, or why he says he was not subconsciously even, motivated by any considerations of a protected characteristic or protected act, or why it was not related to a protected act. He needs to be given that opportunity, because he may say, actually, there were some other reasons, now that you mention it, and that all needs to be explored in evidence. You can't then rely upon in closing and say, well, that witness is not to be believed as to the reason why he did what he did, and you should find that the reason why, you should infer that the reason why is an unlawful reason, when that simply hasn't happened. Now, I accept that the rule is not to be applied rigidly. I'm not saying but it is quite a fundamental principle. And of course, your Lordship has observed, it really goes to the overall fairness and what you can do with the information and the quality of the evidence that you've currently got. But of course, if my learned friend had been curtailed in his cross-examination, not given enough time, or it would have involved far too much time in cross-examination to pursue the point, or it was a collateral or insignificant matter, or some other relevant reason to avoid having to put the case. But there is no good reason in this trial to have not fairly put the claimant's case in relation to each substantive alleged pleaded act of discrimination and victimization and harassment. I think you referred to an old case on this. Whilst we have been hearing my learned friend on this, you'll be pleased to know that the UK Supreme Court has in fact revisited this point in a case I've just found called Griffiths and Chewy UK Limited. The citation is 2023 3 Weekly Law Reports 1204, a decision of Lord Hodge, Deputy President of the Supreme Court, at paragraph 70. Your Honour, I can circulate that if necessary, but effectively it says what I have just said. So What does that mean? That means that the claimant's case has to have been fairly put. I've spelt out who the claimant alleged were the discriminators. I've spelt out in my submissions 16.6 what he needs to have put to each witness in relation to each alleged substantive complaint of discrimination or victimization. And that has not happened. It's happened in some cases, but not all. But the fact that it happens in some cases shows how easy it is to put the case. It shows also how instructive it is and instrumental it is to put the case to the witness. On our side of the room, we were waiting for the moment in cross-examination when the key questions would be put. And the observation that on our side of the room we noted on each turn after each witness was that on the critical question of the reason why, the critical questions were not put. Now, we could either assume that they were one of the ones that were abandoned because the claimant has realized upon mature reflection that it wasn't a good claim after all, like he has in relation to some, or that it was simply a more, it was overlooked. But either way, it either was put or it wasn't. It either needed to be put or it didn't. And those matters, Judge, I will leave with you to determine. But what was put, I've set it out in my skeleton. On the occasions that it was put, the pleaded reason why on the British Asian whose Pakistani origin and British accent and relinquished their heritage protected characteristic, that was only put to Mr. Akbar in relation to what I call allegation D3, the sending of the 2 anonymous speak-ups. And you have the reference in footnote 1, I think at the bottom of page 24 of my submissions. But it wasn't put in relation to any other direct discrimination allegation, be it against Mr. Akbar or against any other witness. And in relation to the white Caucasian point, the pleaded reason why was only put to Mr. de Groot in relation to allegation D1, which was the informal reprimanding following the claimant's 365 feedback. I've given you the transcript references to that. And it was also put to Mr. Long with respect to allegation D3, the sham dismissal. And I've given you the transcript references for that, but not any other direct discrimination allegation against Mr. de Groot, Mr. Long, or any other defendant witness. I'm either right in that or I'm wrong in that. This is a critical issue. And in order to reach findings of fact, one needs to be able to reach them based on, or the quality of the findings of fact that one can reach is affected by how the case has been put in evidence, particularly how it's been challenged or not in cross-examination. So, Your Honour, in section 17, I deal with applying the law to the pleaded facts. And the way this is structured, and you may read through and take swiftly some sections of this because they refer to some of the issues in the list of issues, which you may not consider are core or need to be dwelt on for too long. But the structure of this section is as follows. It's drawn some criticism, I hear from my learned friend. I've adopted this in many a trial of this kind, which has been well received, but let's just see how we go. Background issues 1 to 6, you've indicated those are the kinds of issues on which you don't think you need to make any real determinations. I think, Judge, unless you wish me to dwell on background issues 1 to 6, I'll swiftly go through this as quickly as I can. So, issue number 7, it's an alleged protected act. And the point is, the question is, did the claimant tell Mr. Long that not simply that there was a Pakistani non-diversity problem within the Islamic banking team, but more critically, that this led to bullying of him and Mr. Vasselli? So did he complain to Mr. Long about racial bullying by GIB? And I've given you the references, as I do in each of these sections. It starts off with giving you the references in the defendant's witness evidence. So you have them there, and you have it summarized in Appendix 1, paragraph 6. And then I deal with the evidence as it was seen and heard in terms of relevance, and the references to the other important thing about each of these issues is when I take the issue from the list of issues and I give it a protected act number or a discrimination number or a victimization number or a harassment number, I give you also the source point as to where it is anchored in the amended particulars of claim. That really is important. So at the end of each heading, you get the APOC reference. And the telling thing will be that if you don't have an APOC reference, you might be forgiven for thinking that it's not there. And that's because it isn't. And then I've given you the transcript references in relation to Mr. Long's denial that the claimant had complained to him about racial bullying, over and above complaining to him about there being, over and above him discussing with him the fact that there is an overconcentration of Pakistanis in the GIB team. So what does this mean? And at the end of each of these issues, I should very pithily, in bullet points, Judge, give you what I say is our position. On this, our position is issue 7, in other words, Protected Act number 1, did not happen. So he did not, claimant did not tell Mr. Long that he was being racially bullied by GIB. And that is the weight of the evidence. And there is, we say on the evidence, no basis on which to infer that the claimant did say that to Mr. Long, someone with whom he had many a one-to-one regular meeting.
Well, sorry, this is why I think the issues have been very curiously expressed and with no criticism to those who drew them up.
I wasn't involved in that.
There's a question there about whether, and issue 8's the same. Did the claimant tell Mr. Long certain things? But there's no question about whether those things actually happened.
Well,
surely the first question is, was he racially bullied?
Exactly.
Only then you get to the question of whether there was a protected act. So it just seems all a bit strange. Anyway.
Well, I was not involved in the case when the list of issues was formulated, and I am disappointed by the list of issues, if I can be frank. It is not a document that I would wish to put my name to in that way. But nevertheless, it's what we had to deal with. And it was for the claimant, because it's the claimant's claim, it's his shopping list of allegations. It would be him to tell us, oh, this is how I'm putting it, not like that. So a list of issues primarily, but both sides are to blame, I think, on its formulation. Primarily, it's for the claimant to set out what his, what the headings of his claim are. The issue number 8 is on the did it happen, Judge. I think, to be fair, if the question is was something said or complained about, in a sense that is a discrete question about a protected act.
Yes,
so
of course,
because Judge, the claimant may not have been bullied racially, so it may not have actually happened, but I accept that the claimant could have complained about it himself, believing that he had been racially bullied or something like that. But the question here is whether he made. The question here is whether he made the complaint.
You can't be protected. You can't. A protected act doesn't cover things, complaining about things that didn't happen.
It doesn't cover things if you're making a complaint falsely and in bad faith. Right. So in other words, if you're making an allegation which didn't take place, then that is not capable of amounting to a protected act.
All right. I understand.
Yeah. So, but sometimes people can be protected, I accept, by making a complaint, even if the underlying thing didn't happen, so long as there's good faith in the pursuing of that matter. Let me jump quickly to background issue 8, which is in the next section. It's called a background issue because it is not relied upon as a pleaded protected act. That's why I say it's of background relevance only. And this is the point about whether the claimant told Mr. Long that he had been mocked for his British accent by the GIB. And the evidence, we say, the weight of the evidence, I'm not going to make any pejorative submissions on obviously what you should find. I will simply tentatively put it this way, that the overwhelming weight of the evidence is clearly in my client's favour in relation to whether it is more likely than not that the claimant mentioned his British accent being mocked. On this feature about the British accent being mocked, and I'll come on to it in relation to other sub-complaints, But it's a curious feature that almost in relation to every defendant witness and in relation to all people that investigated the matter, that the claimant never complained to them about it either. But we'll come on to that in a moment, perhaps. But in relation to this issue 8, which is not substantive, our position is twofold. And these are my bullet point answers to this. First, not pleaded as a protected act. Second, did not happen on the evidence. Let me move on to background issue 9. And this is whether Mr. Phoebe reprimanded the claimant. You've got this is 17.5. You've got the pleading references. It's not pleaded as an unlawful detriment, and therefore it's a background relevance only. I've given you the references to the HKMA disagreement with Harris Law and Mr. Phoebe's evidence on the alleged reprimand for that HKMA disagreement that the claimant was involved in. And you've got the who, what, how, when set out in Appendix 1, paragraph 4 and 5. But focusing, as I want to do in my submissions and as I've done in these core closing submissions, is on the reason why. And I've explained there the reason why evidence from Mr. Phoebe, which was not undermined in cross-examination, and the weight of the evidence is clear that Mr. Phoebe did not reprimand the claimant, whether formally or informally. So our position on that is as follows. Issue 9 is not pleaded as an unlawful act. First bullet point. Second, it did not happen as alleged by the claimant. In other words, the conversation that took place was not a reprimand. And thirdly, if you find that it was pleaded, and if you find that it happened as alleged by the claimant, then we say the following 3 points. The claimant harbors an unjustified sense of grievance about it because it was a justified reprimand if you find a reprimand occurred. Secondly, the matter was not put to Mr. Phoebe that he would have treated a white comparator more favourably in relation to how he treated the claimant. And thirdly, it was not put to Mr. Phoebe that the reason why he spoke to Mr. Mahmood in the way that he did on that occasion was because Mr. Mahmood was not a Caucasian with white skin. So all of these elements would have to be satisfied for us then to reach any findings of fact upon which an inference could be drawn of discrimination.
Well, if the witness denies a conversation, surely the rule in Brown and Dunn doesn't require you to go on and say, well, if the conversation took place, were you motivated by the fact that? I mean, it's just he denied that it ever happened. So
yes, indeed. But in order for the employer to be liable for that incident as an unlawful act of discrimination or victimization or harassment, you would need to find that the unlawful motivation was there.
But I'm only talking about the Brown and Dunn point. When a witness, the obligation is fairness. You can't really, if the witness denies making a statement, yes, you can't say to him, well, the motivation for the statement that you deny making was correct. Blah blah. It doesn't carry any water, does it?
I agree with you on that, but the claimant's well, no, because there may be a nuance as to the manner in which Mr. Phoebe spoke to the claimant or the words he uttered to the claimant. And he may say, I was gentle as an angel, and the claimant may say, no, you weren't. But on the basis that he said what he said, the motivation behind, even though Mr. Phoebe says he was an angel, it needs to be put to him that he was motivated on that occasion by, we can all disagree about what exactly was said, but he was motivated on that occasion by those unlawful characteristics. That would need to be put on that kind of matter. But I agree with you on some other aspects, Judge. If the argument is whether it happened or not, you can't take it much further. But on something like this, you can. So I respectfully make that point. Let's move on to issue 10.1, which is the first pleaded allegation of discrimination. When I say discrimination, it's shorthand for direct discrimination. Yeah. And this is whether Mr. de Groot informally reprimanded the claimant. Judge, you have the pleading references there. And Mr. de Groot, of course, denies that. You have all the references to the factual context for the claimant's 365 feedback and the reaction to it in the various defendant witness statements set out at Appendix 1, paragraph 7. You have our position on the evidence, which we say was perfectly credible and not undermined. There was no concession made by Mr. de Groot in his cross-examination in relation to this critical aspect of this allegation. And I've indicated his paragraphs 36 and 37 of his evidence. The matter was put to the claimant, and you've got the evidence of the claimant there, the transcript references. But what I've said there in relation to the evidence of the claimant and the extract from my cross-examination of the claimant on this point is how demonstrably and evidently hazy the claimant was about the conversation with Mr. de Groot, and how the claimant conceded that he could not recall exactly how the conversation went. And I've given you the extracts from the transcript there. And the other important aspect of it is not just the claimant's hazy recollection about it and the fact that he conceded it may well have happened how Mr. de Groot says it happened, but that the claimant also conceded that it was because of the way in which he delivered the 365 feedback, which was he even understood at the time was the motivating factor. Judge, I don't suppose, given the time you need me to read through that transcript, but I've set it out there.
Yes, I have read through it.
Great. And the claimant was able to put to Mr. de Groot that the reason why Mr. de Groot blamed the claimant for his 365 feedback on Mr. Actor was because compliance, quote, was very much a white boys club. And you'll recall that that was expressly put in that way. That perhaps is the closest one gets to the Mr. de Groot being challenged on this in relation to the claimant not being Caucasian with white skin. Compliance was very much a white boys club. There's a focus there in the challenge in cross-examination on the color of his skin, not necessarily on even being Caucasian in itself. There is no finding, we say, a primary fact on which the court could responsibly infer that Mr. de Groot was discriminating against the claimant on this occasion because he was not Caucasian with white skin. So what's our position on this? Our position is, again, it did not happen as alleged. That's the first point. Even if it did happen, then the claimant, we say, is harboring an unjustified sense of grievance about it, because Mr. de Groot speaking to the claimant about this incident was perfectly reasonable and justified and fair. And on the evidence, there's no finding of primary fact that can be made from which it could be inferred that Mr. de Groot would have treated a Caucasian with white skin more favorably. And on the evidence, there's no basis upon which an inference could be drawn on the reason why either. In other words, that Mr. de Groot reprimanded the claimant because he was not Caucasian with white skin. We are talking quantum leaps of rationality here in trying to get to the point of establishing liability on each of these issues. Let's move on to Discrimination Act number 2, Mr. Long's 2018 performance appraisal, giving the claimant a 2C rating. Again, you've got this is an act only of discrimination, direct discrimination, number 2. You've got the pleading references, the witness statement references, at least the defendant's witness statement references. And we know that Mr. Long was the claimant's line manager, very close to him, regular contact with him, very fully appraised of his performance, his abilities, his attributes. And I won't go into any great detail here. You have the extract where the allegation was squarely put to the claimant. And this was quite telling, this extract perhaps, because we put it this way. The question was at the beginning, right, where is the evidence that Mr. Long was influenced by some racial, based either on you not being a Caucasian white or because of you being the British Asian who has apparently relinquished Pakistani heritage? Where is the evidence that any mindset of that kind from any other quarters was brought to bear on Mr. Long in his assessment of your performance? The answer is, well, as there's been no disclosure. The evidence is my testimony. Here, which is under oath. I say, I see. He says my testimony here to that effect is that Mr. Long, during my performance meeting, told me the stakeholder feedback from GIB wasn't great. I said, we agree with that. And he told me that stakeholder feedback I had really upset. He used stronger language than that. I had really upset Mr. Phoebe and Mr. de Groot and various others in compliance management with regard to this 365 feedback. My question, that probably doesn't come as a surprise to anybody either. Answer, so that's the evidence, sir. That's what he said to me in my performance appraisal. Question, but where is the racial element? Where is the evidence of the racial element? How on earth does anybody draw any inference that it is not other than the manner in which you proceeded with these matters? It is actually you not being a Caucasian and or not of white skin, or you having a British Asian status with relinquishing of your Pakistani heritage. Where is it? I believe I've answered your question already. Have you? You have not disclosed it. So this is how he puts his case at its height. And at the end of this passage, he says, the claimant says, the only specific instance that came up in that meeting was in relation to the way I had done the 365. I delivered the 365, not I delivered, let me correct, the reaction to the 365. So he perfectly understood the reaction to the 365 was because of the manner in which he rendered it. So can I just say this in relation to this point? It wasn't put to Mr. Long in cross-examination that he had decided to give the claimant a 2C rating because he's not Caucasian with white skin. Wasn't even put to Mr. de Groot when in relation to his feedback on this particular rating, that was motivated by Caucasian, by the claimant not being Caucasian with white skin. It wasn't even put to RS that his feedback on the claimant's rating was motivated by the claimant being a British Asian of Pakistani origin, British accent, relinquished his heritage, etc. So where does this get us on this point? It gets us to this position. It's a clearly unfounded allegation, but it comes to this really. We know what happened, so there's no allegation about what happened on the rating. There's no evidence that the rating was influenced by unlawful considerations, if I can shorthand use that. It cannot amount to a detriment in law, because giving someone a performance rating which is fair, which is reasonable, which is justified by a line manager, is not a detriment. It's unable to amount to a detriment in law. The next point is that the next bullet point on this is that Mr. Long did not grade the claimant less favorably than he would have treated others who were Caucasian with white skin. You can't come to that conclusion on less favorable treatment because the matter wasn't put to Mr. Long, the decision maker. And Mr. Long did not grade the claimant because he is not Caucasian with white skin. The matter was not put to him. We then move on to issue 10.13. This is the third discrimination act, and this is the sending and content of the January 19 anonymous speak up complaints against the claimant. Your Honour, I've set out where it's pleaded. I've set out the factual evidence from the defendant's perspective and summarised that. These two were anonymous, two were from known individuals. Miss Al-Najjar met with the two identified individuals, Geeta Nilakantan and Fatima Yusuf. One individual was going through mental health support due to the claimant's behaviours in part. And one of the claimants also, complainants raised that the claimant had created psychological fear on the floor by standing behind colleagues and looking at their screens and over their shoulders. Now, the substance of the complaints was in respect to the claimant's behaviours in the workplace. And on the evidence, we know that this was looked into because on the evidence obtained by Ms. Dada, the complaints against the claimant were not upheld. And the report did not find that it appeared that the claimant's confrontational style, sorry, the report did find that it was the claimant's confrontational style that intimidated some employees and could have created friction between the Islamic banking team and compliance. But further, there was an apparently unhealthy relationship between the claimant and Mr. Akbar. Now, the claimant's counsel put allegation D3 to Mr. Akbar on the basis that it was Mr. Akbar that had submitted the two anonymous speak-ups, and that this was because the claimant was born in Pakistan, identified as British, spoke with a British accent, and had repudiated his Pakistani nationality and identity. So let's just focus here for a moment. When it came to this allegation against Mr. Akbar, my learned friend put a very particular protected racial characteristic to Mr. Akbar as the reason why, and rightly so, because he put the pleaded case. How is any other witness to know that something else is the pleaded case if it's not put to them in the way in which it was put to Mr. Akbar on this occasion? How are they to know? Now, of course, they may have responded to it in their witness evidence beforehand, but they haven't been challenged under cross-examination in relation to the reason why being the pleaded protected characteristic. And I use those words advisedly, the pleaded protected characteristic or characteristics. And that, Judge, is the only occasion at trial that that particular pleaded protected characteristic was put to any defendant witness.
Now, the two anonymous complaints,
yes,
I think it's right that one of them referred to the colonial era cop, and the other one referred to English scholar, as I recall. So they are, as I said earlier, there's evidence of there is very limited evidence of any specific racial of any communication that has a racial content other than Mr. Mahmood's allegation that he was mocked. And I think the two of them, so that the complaints in January 2019 from the identified complainants didn't contain any racial content.
Correct.
And Mr. Bickford-Smith told me earlier that Mr. Mahmood didn't know about. I'm not sure whether it was any of the complaints or just the two anonymous complaints, but we can put aside the two identified complainants for the moment because there's no racial content to those, and the evidence is that from Ms. Najjar that they were very upset with the way that Mr. Mahmood had been behaving.
Yes.
But in relation to those two, you heard me ask Mr. Bickford-Smith questions earlier. Let's assume that they were from employees of the bank, which is, I think, a reasonable assumption. It may have been that Mr. Bickford-Smith, well, I want to say it was Mr. Akbar, but clearly it would have had to come from employees of the bank because they wouldn't have known, they wouldn't have had access to the information otherwise. So do you accept that the bank would be responsible for those communications as coming from their employees?
Well, firstly, the bank can only be can't be responsible for communications if we don't know who they've come from.
But assume it's an employee of the bank.
If we make an assumption or we infer that it was a current employee of the bank, then the bank is, and if the communication contains a racial derogatory comment, because that's what it would have to be, not just some kind of being hypersensitive to something that was said in passing, but if it contains some kind of deliberately detrimental or even unintended detrimental comment, which was offensive racially, then that clearly is an potential act of discrimination. Whether
by the employer?
No. This is what I'm coming to. Whether that's the primary act, as it were, the primary actor is committing that act, or but whether the employer is liable is obviously going to be it's got to be just and fair in the circumstance. And this really is where we come back to the employment law, vicarious liability of employer provisions in the employment law of 2019, Article 54. I was going to deal with this later. I thought you were going to make a different point, Your Honour, but I think
I just because we were talking about this, if you want to leave it to later, that's fine. But the other question I have on this, and I might ask Mr. Bickford-Smith about this in due course, is that if as he says, Mr. Mahmood didn't know about at least the anonymous complaints until these proceedings were commenced, has there been any discrimination in the sense that has there been any unwanted treatment or conduct, given that the complaints were all dismissed? It's hard to see how you can be discriminated against by something you didn't know about.
Exactly.
Which had no consequences.
Your Honour, it's not because he says he learned about this after the event. It stands to reason that he didn't plead them. And originally, and or otherwise actually. So the reality is that it's not part of his substantive claim. It might become, it might be evident, something that he learns of later in disclosure might become evidentially relevant. But I see that what he did do in his amended particulars of claim, this is issue 10.3, the issue I'm talking about right now.
Yes.
It might be the case that he brought this in. I wasn't involved in the case at the time, but he might have brought this in after becoming aware of it and then amending his particulars of claim to bring it in on that occasion. So this is particulars of claim paragraph 40C to F. Just going to go to that. So these are part of the amendments, and he became aware of it as a result of the DSAR and then amended his claim.
Yes, all right. How is it?
But the relevance of it, I think, was appearing within the context of whether this was an excuse or a good justification to extend time for an out of time complaint.
Yes.
And the difficulty that my learned friend has is that the claimant's case is that he was aware of being racially discriminated against. He was complaining, he says, about being racially discriminated against, hence all protected acts of which he pleads. And therefore, he could easily have brought a claim for racial discrimination far earlier. So just the fact that he wasn't aware of one aspect of the narrative here, because that arose in subsequent DSAR disclosure, doesn't justify extending time by however many months and years he wishes, because for here it'd be having to go back to by at least a year and a quarter, because it's a January 19 these complaints. His claim wasn't presented, I think, until late spring of 2020. So that would be the relevance.
Yes, but again, it's hard to, but go back to the fundamental question: how can this be an act of discrimination if he didn't know about it during the course of his employment and it didn't have any consequences?
Well, exactly.
So anyway, that's a question Mr. Bickford-Smith can address in reply.
And in any event, Judge, and I'll deal with this very clearly when dealing with continuing act. But where's the link between this and the subsequent decision to dismiss for redundancy, which is the only in-time complaint? We don't know who this if it's an employee, who the employee was, and even assume for a moment it's Mr. Akbar or somebody like that. Where's the link between that and the decision to reorganize under a global reorganization process and deleting the claimant's role and him going through a selection exercise and being made redundant? There's no link whatsoever. I thought Your Honour was suggesting there was a relevance here to the continuing act point. But just focusing on this issue of, so what he's saying it was an act of direct discrimination that these January 19 anonymous speak-ups were made against him. Well, very little can really be found as a fact on the evidence before us, because we don't know who the author of those anonymous complaints is. And we've heard Mr. Akbar be challenged on that, and he is quite clearly, and we say convincingly, denied any involvement.
Would the fact of an investigation, even if it leads to an exoneration, be a detriment within the meaning of the Act?
It could. So if the bringing of a disciplinary investigation against the claimant, where the decision to bring the investigation against the claimant is motivated by unlawful factors, then yes.
Right. So the question then would be, so the fact that the complaints contained racial slurs doesn't mean that they were the cause of the detriment, because it's the other material in the complaint, the complaint of misconduct in employment that resulted in the investigation.
Indeed.
Yes, all right. I'll try that.
And this is why many times people come a cropper on these kinds of cases where the factual narrative involves some references to race or protected characteristics, but actually they're not the causative reason why the allegedly unlawful act was subsequently done. And it is really important to understand precisely what is the detriment pleaded. Is it the decision to commence disciplinary investigation, in which case you look to the decision maker on that? Is it the outcome of the disciplinary investigation, in which case you look to the disciplinary decision outcome decision maker? Is it disciplinary appeal, in which case you look to that? But you're looking at the mindset of different people faced with different circumstances at each turn, who need to be having the case put to them squarely and fairly. So on this point, this is all about whether the anonymous speak-ups were an act of discrimination. On the evidence, we say there's no sufficient evidence to make a finding of fact that anyone in GIB sent it, or sorry, that Mr. Akbar sent it, who was challenged on it. But it does come to another point, and that is that the claimant's case does need to be put in this regard as well, that if he's putting the case that Mr. Akbar sent this, and I know Mr. Akbar says he didn't, it does need to be put to Mr. Akbar that the reason why he sent it, even though he denies it, was for the unlawful reasons. And
didn't you tell me that it was? Didn't you tell me that that was put to him?
No, that one was not. Sorry, this was the only occasion that the particular pleaded detriment was put to us. I'm sorry, that's absolutely right. That's I've confused. I've scrolled down a bit too far.
Yeah.
But this reference to the yes, I think I don't need to say anything more. I think on the anonymous speak-ups. The fourth discrimination allegation pleaded is issue 10.4. This is that Mr. Long failed to act on the claimant's alleged complaints. Now, of course, our case, look at the earlier pleaded point, is that the Protected Act didn't happen. He didn't complain to Mr. Long about racial bullying by GIB. And if he didn't complain about that, there was nothing for Mr. Long to act upon. So this is a consequence, as it were, of the earlier Protected Act issue. So there was nothing to investigate, nothing for him to do. And in any event, I think the way in which the claimant puts their case is, I told my line manager I was being racially bullied. He did nothing. What there isn't in this case, curiously, given the seriousness with which the claimant takes this particular point, is on this occasion, I told my line manager to commence a formal process. We have nothing to that effect. So that's why you don't have anything in writing where the claimant is trying to formally register or lodge or file a complaint, a grievance, a disciplinary matter against anybody in GIB, which he could then expect his line manager to take up formally. But assuming even for a moment that the claimant did make such a race discrimination complaint, that's what it needs to be a Protected Act. On the evidence, there's no finding of primary fact that can be made from which it could be inferred that Mr. Long would have acted on the same complaint if made by a Caucasian with white skin. That's the less favorable treatment point. And there is no evidence upon which any finding can responsibly be made, which could lead to an inference that Mr. Long did not act on the alleged complaint because the claimant was not Caucasian with white skin. So we again see that complaint fails. 10.5 is what I've referred to as the first unpleaded discrimination act. It's unpleaded discrimination number 1, issue 10.5. This is an allegation in the list of issues that the defendant failed to address the alleged culture of discrimination, bullying and harassment evident from the 30 January anonymous speak up and the claimant's alleged complaints to Mr. Long. I think this again follows on, Judge, from the earlier points and can be conflated with them. But the point is, it's not pleaded as an act of unlawful discrimination. That's the first bullet point, not pleaded as an unlawful act of direct discrimination. Otherwise, point me to the amended particulars of claim paragraph number. Secondly, the matters were investigated by Ms. Dada and considered at length. And you have all the detail that we went through in relation to Ms. Dada's investigation, which I won't rehearse.
But what she did, but there's no evidence that she investigated the allegations of the racial slur, is there? And that this is the complaint, that there was failing to address the alleged culture of discrimination. So that two of the anonymous complaints, there was material in them which suggested that somebody else, an employee of the bank, was at least partly motivated by Mr. Mahmood's racial characteristics or background, whatever you want to call it.
Yes.
And the bank did nothing about it. Now, the bank's case, as I understand it, is, well, what do you do about anonymous complaints? Mr. Bickford-Smith says, well, you don't need to be Sherlock Holmes to work out that there was a problem within the Group Islamic banking function, and that these complaints very likely came from within there, and that suggested that there might be racist issues within GIB that needed investigation. So what do you say to that?
All of the complaint is generally put about the defendant failing to address this alleged culture. It's not Ms. Dada. And
yes. Well, I agree. That's the point I'm putting.
If you
Dada investigated something different.
Quite exactly. If you look at all of the investigations that the defendant did in this case, including the ones that culminated in the I3 and the Mr. Mahboob's investigation into the claimant's victimization concerns, you'll see in relation to all of those that there was a great deal of time expended on the claimant's situation. And where is it that the claimant, in all your 10,000 documents, where is it the claimant is telling individuals that it is critically important that a particular thing is being overlooked here and it needs to be investigated, or it can be investigated?
You couldn't tell anybody about the anonymous complaints because you didn't know about it.
Oh, that's true. That is true until
that's no answer.
Well, that isn't an answer. He learns about them later.
So why didn't the bank do something when these complaints, they investigated Mr. Mahmood? They didn't investigate whether there was a culture that was producing anonymous complaints that had racial overtones.
Well, did they need to do that if they hadn't been presented with a formal? The complaint here is saying this bank didn't go to the lengths that it went to formally in other investigations with this one, but those arose from a formal written grievance or a complaint and things of that kind. Where is the request for the claimant to pursue? Where is the formal complaint from the complainant, the claimant here?
Well, you can't complain about things you didn't know about.
Well, then how can you?
Well,
I think the allegation is this, Judge. I think I've got this. I think the allegation is this. Forget the fact that I didn't make a big deal about it. You employer read these two anonymous complaints. You should have voluntarily, unilaterally spotted a couple of references, one reference in each of these anonymous complaints, and you should have taken it upon yourself to undertake a formal, wide-ranging inquiry into culture and what does he say? But do you see the point I'm making? So that's got to be
I don't really, because see what happens at the end of January, there are 4 complaints that come in altogether.
Yes.
So there's clearly something going on. There is clearly a problem.
Yes, but the complaint, Judge, the pleaded complaint at issue 10.6, let's be clear about this. The pleaded complaint.
No, I'm 10.5. I'm talking.
But still on 10.5.
Oh.
Right.
Oh, well, 10.5 and 10.6, they're the same. They're the same. They're related.
This is why I'm bringing 10.6 into this with 10.5. They're not. They are two of the same thing. In 10.6, the claimant's complaint is the defendant did not discipline the authors of the anonymous complaints. That's what 10.6 is. Okay. And 10.5 is you didn't conduct a disciplinary investigation into it. So they are two elements of the same complaint. And our point is you can't conduct a disciplinary investigation into anonymous complaints.
But you can. You can when you've got 4 complaints coming in at the same time, and you've obviously got a problem in a relationship between the compliance function and the group Islamic banking function, manifest in the fact that you've got 4 complaints coming in at the same time, 2 of which have racist overtones. And
well, I'm not
all you do is investigate. You don't do anything about the racist overtones.
Yes.
You simply investigate the other complaints against Mr. Mahmood, and you make no attempt to find out whether there was in fact a coordinated movement going on within Group Islamic banking to cause harm to Mr. Mahmood because of his racial characteristics.
No, that was looked into. And if you look at Mr. Mahboob's comprehensive investigation into the claimant's victimization complaints and concerns. That
wasn't until much later.
Yes, but here the claimant
it didn't involve the anonymous complaints because Mr. Mahmood didn't know about them.
No, Mr. Mahmood, the claimant didn't know about them at the time. Yes. But the fact that these anonymous complaints had been made were the subject of investigation.
By whom?
I believe it's Miss
Dada.
Dada looked into the complaints against. I just want to be careful about. There was that Miss Dada conducted the investigation into the complaints against the claimant arising from the 4 speak-ups.
Yeah. But that's we've already agreed that's irrelevant. Because the question is not whether the complaints against the claimant should be investigated. The question was whether the fact of the complaints with the racial slur should have been investigated. And I'm not aware of any evidence that they ever were. Is there any evidence that they ever were?
I'm not going to shoot from the hip. I'm going to double check that, Your Honour, and come back to for a short break if I can. But let's just follow this through. Let's imagine, and this is exactly what the cases that I referred to about on causation and the nuanced legal test relate to. Let's imagine someone let's imagine there's something to do with a racial overtone that's made a reference to, and it's not looked into. I don't agree that automatically the employer was obliged to look into it, but let's imagine for a moment they should have looked into it and they didn't look into it, and so they were at the very least unreasonable.
You've got a duty to keep a safe workplace. You've got a duty.
So let's imagine for a moment that they should have taken it upon themselves to conduct another investigation into this particular aspect. Let's just for a moment. I don't accept that. But let's just assume that we still need it to be put. And we need it to be need there to be evidence upon which primary findings of fact can be made that had the claimant not had his protected characteristics, that this employer would have gone about investigating those 2 anonymous complaints, and that the reason why they didn't.
No, I don't follow that at all. The complaint, there is an allegation that is directed at precisely at the protected characteristic of which Mr. Mahmood says was infringed. That he's a colonial era cop and he's a British scholar.
No.
So why does it have to be put to people? I don't understand that at all. Can you explain that to me?
Yes, I can. The first point, Judge, and I think I've made it, but I don't want to lose sight of it, is that this is not a pleaded act of direct discrimination.
Yes, I've heard you say that a number of times.
So sorry. In which case, in many respects, only unless I'm wrong about that, we don't need to spend too long on it.
Yes.
Do you see my point?
Yes, I do.
So we can waste a lot of time on whether it is or isn't.
The anonymous complaint is pleaded, You took it to me. It's paragraph 40C.
Yes, but whether the failing to address the alleged culture of discrimination, bullying, and harassment arising from looking at the anonymous complaints is suggested at issue 10.5 as a freestanding direct discrimination allegation, and I say it is not. It is a criticism the claimant makes in the evidence, and it's something you can look at and in the round and understand whether that is relevant to any other substantive complaint, but it is not a complaint, a pleaded cause of action in this litigation. Do you see the point I make?
Yes, I do.
So that's why I say I'm not shying away from it. I don't say it's irrelevant. It is relevant because the claimant wants to say, look at this other thing that happened to me or didn't happen to me and should have happened to me. Take that on board. And I accept the claimant can say that. It is relevant, but it is not something which can found liability unto itself because it is not a pleaded act of discrimination. And if I might move on to the actual pleaded act of discrimination, which is 10.6, which is related, but it's the failing to take disciplinary action against the instigators of the 30 January anonymous Speak Up complaints. And you had heard evidence from the defendant's ERHR witnesses that it was standard practice that as the complaints had not been found to have been malicious or fraudulent, and it wasn't possible to identify the authors of the two anonymous complaints, and that's why nothing further was done about it. Now, that was from the ERHR witnesses. Now, you may think that had you been acting in their shoes, may have done something differently, but the reality is that an honest answer, even if it's not the way in which you would have conducted the business, Judge, on that occasion? Is it an honest and credible answer? Is there any reason to think that it's not credible? Is there any reason to think that a white person would have been treated any differently, and that the reason why the two anonymous people weren't found and disciplined was because the claimant is of a particular British, Asian, Pakistani origin, relinquishing his nationality with a British accent, or not white, Caucasian? Do you see the point? That we would have to go through all of those hoops, even simply to get to the point of.
Just let me take you up on this allegation that it's not pleaded. So you'll need to go back to the amended points of claim.
Yes.
So you go back and we've looked at paragraph 40 capital C, which pleads the anonymous complaint and the colonial era COP. And then if you go further down, it's paragraph 40G, these complaints were investigated. It's apparent from a heavily redacted DR there had been a group complaint against the complainant. The group dynamic is apparent. The January 2019 complaint alleged that claimant's conduct had been resulting in the environment on the floor being contaminated. In the premises, it is apparent, alternatively fairly to be inferred that there was, at least from late 2017, a culture of discrimination, bullying and harassment on grounds of national origin and identity within the defendant's Islamic banking function in Dubai. And then paragraph 48, further, the defendant took no action to stop this. Well, why isn't that a pleading of the issue in 10.5?
Sorry, Judge, where were you reading?
Paragraph 40G and paragraph 40H seem to me to squarely raise the issue in paragraph 10. Issue 10.5.
I mean, it's fair to say that the claimant refers to a culture of discrimination, bullying, and harassment. I don't see.
And said the defendant took no action to stop it.
Sorry, that's the culture, not the did not.
Yes.
Where's the I'm reading the issue here.
It's apparent alternatively that there was at least in 2007 a culture of discrimination, bullying, and harassment on grounds of national origin and identity within the GIB
yes
function. The defendant took no action to stop this in the next paragraph.
I did not read that as, I mean, that's about the broadest of allegations in terms of complaints were made against me I say that there's a culture, and the respondent defendant did nothing about these anonymous complaints.
Well, but what it is precisely the allegation that I've been trying to put to you, and that was that there were group complaints. There were 4 at the same time. There appeared to be a common thread. 2 of them had a racial slur,
yes,
and the bank did nothing about it. Well, that seems to me to be precisely what this pleading is saying.
Perhaps we can cut this this way, or deal with it in this way sensibly, in my submission, and that is ultimately one needs to look to see the evidence. And I'm being reminded that the complaints were passed to Ms. Dada to investigate.
Yes, but that's to investigate the complainant, to investigate the claimant, not the complainants.
Yes, but one needs to understand that the you have 2 anonymous complaints. The task of the investigator is to investigate the complaints that are made. No complaint at the time is made by the claimant.
Well, how could he? Didn't know about the complaints.
Exactly. So the only complaint that the claimant can feasibly can even possibly suggest now is that my employer, receiving these 2 anonymous complaints, should have of its own motion undertaken a detailed investigation into the culture of a detailed investigation into the culture of the GIB team, because he doesn't know about it, so he can't complain about it at the time.
Well, wouldn't that have been a proper course for the employer to take? If you've got evidence of racial, if you've got evidence of that raises a suspicion of racial vilification, isn't that exactly what you've got to do to fulfil the duties imposed upon you under the employment law?
No, not necessarily. And the point is this, that firstly, these are anonymous complaints. Secondly, we
went through this at the trial. There's a commonality in the materials.
Yes.
You wouldn't need to be Sherlock Holmes to work out that there was
that's right.
Somebody stirring the pot.
Yes, absolutely. Judge, we're not pretending otherwise. But the point here is that can I put it this way? Let's be relevant. The reason why no action was taken was explained by the defendant witnesses. And it was explained
because they were anonymous.
Well, they said because it was anonymous, and it was also said by the witness that it was standard practice because there was nothing in those complaints that was found to be malicious or fraudulent. Do you recall that evidence?
Yeah, but it was racist. There were things in the complaints that were racist. They weren't malicious or fraudulent, but they were racist.
But the point is, let's say for a moment that, Judge, you as a extremely diligent human resources professional might take a different course because but the point is, why is it that course was not taken is the question. That's the only question here. So you've got the explanation for it, and we believe the explanation or not, and it could be an explanation which is one which you would have agreed with at the time or disagreed with it, but that's not the critical question here. The question is the explanation that was given credible? Is it actually the reason why they did not investigate at the time in the face of these 2 anonymous complaints? And is that would those people that made that decision have behaved differently if the person had been not British Asian with those characteristics or white Caucasian? And was it because of those reasons?
I just don't understand that, because the act of, you accepted earlier that the act of discrimination is the sending the anonymous complaints. So why do we have to ask whether the investigator did something? Because if they're confronted with a suspicion of racism and they do nothing about it.
Yes.
I mean, clearly, there's not going to be a suspicion of racism if the person is a Caucasian. So, or whatever. So in other words, I don't understand why you say the complaints people had to be motivated by a discriminatory motive when they did nothing. There's an act of discrimination, and which raises a question of whether there is a toxic workplace environment, and the employer does nothing, thus thereby exposing the employee to the potential continuation of the toxic workplace environment.
But Judge, I'm putting it this way. the omission, because that's what's being complained about here, an omission, a failure to act.
Yes.
It has to be being said, and I think I should dwell on this because I think it is critical. Let's just assume that an act of discrimination had taken place in the two anonymous complaints. Let's just assume that.
Yes. Yes.
And an employer decides that for whatever reason, at the moment, that it's not going to unilaterally undertake some formal investigation into it. Let's just assume that as well. And even let's assume that's a really bad employer decision. Okay, it's unfair, maybe. The critical question still is, why did the employer reach that bad decision? And would the employer have done it differently had it been somebody not of the claimant's protected characteristics? And was the reason why the employer?
I just don't understand that point at all.
Okay,
sorry,
okay. Well, let me explain why. Let me explain why.
Yes, you're right.
And please, Judge, I really do. I think this is the complaint here is the employer's failure to act.
Yeah.
Not the original complaint, not the original statements in the speak ups. So the complaint here is not the original. The complaint here, the employer faced with these two discriminatory references did nothing about it. Let me say that's the complaint as I understand it. So one must look at the mental decision making of the person that decided not to do anything about it. And we see in the evidence of the defendant's witnesses as to why they did not do anything about it. It's in the evidence, it wasn't challenged. And it certainly wasn't undermined. And you may not like it. And you may think, well, if I was an Australian human resources person, I'd done differently, or an English one. But the fact is, they gave the explanations of why they didn't pursue that process. Now, the allegation is that not pursuing the process is motivated by unlawful considerations of racial characteristics. That's the allegation.
Well, I don't think it is. I think the allegation is that the complaint was an act of racial discrimination for which you as the bank are responsible, unless you can bring yourself within 54 or whatever it is.
Okay.
And when you get an act of discrimination and do nothing, you can't bring yourself within 54.
I tell you why I say that, because I have taken these allegations from the list of issues, and the list of issues at 10 point, it's at 10.5. And let's have a look at it, Judge, please. We really do need to look at this. It is not that the sender of the anonymous complaints committed an act of discrimination for which the employer was responsible or liable. That's not the complaint here. It is 10.5 in the list of issues, the defendant failing to address the alleged cultural discrimination, bullying and harassment evident from the 30 January 2019 complaint and the claimant's alleged complaints, Mr. Long, the defendant failing to take disciplinary action against the instigators of the 30 January 2019 complaint. And even if you go back before then, it's all about the defendant failing to act on matters. It is not that I was discriminated against by two unknown individuals on these two separate anonymous complaint occasions for which my employer is vicariously liable. That is not a complaint that's been pursued.
Mr. Setti, I've got to say, you're the one who's been carrying on since day one of this case about going to the pleadings.
Yes.
And I took you to the pleadings, and I think trying to get away from what seems to me to be a pleaded case by going to the terminology of the issue is not an answer.
No, it isn't an answer, but it's an answer to why we have understood the claimant's case in this regard in that way, and that is a clear answer to it. That's why lists of issues are there to clarify, not to mystify.
But they are without prejudice to the pleaded case. You told me that. You told me that several times.
I did.
So
but Your Honour, I will. If my learned friend wants to resort back to away from this issues to a pleaded matter in that way, then I will. I'm happy to say that we'll go with the pleaded case. Of course, I am.
All right. Well, the pleaded case. But the point of the matter case is that you got the anonymous complaint.
Yes.
The anonymous complaint creates the inference that there was a toxic culture within group Islamic banking, and you did nothing to stop it.
Yes, but that is Miss Dada's failure. That should have been put to Miss Dada. As far as Miss Dada
Ms. Data was instructed to do something by her superiors. She was delegated the task.
Yes,
the anonymous complaint went to the head of HR. I think it was Miss starts with B. What a Tabra.
Yes.
Tabra commissioned Data to do it.
She may have focused on the wrong thing in her complaint when she was delegated the task to look into it. But it's the complaint that the claimant is making is a failure to deal with the two references in those anonymous speak-ups. Now, let's assume that's pleaded. So ultimately, still, Judge, we have to look for the evidence upon which we can make primary findings that the reason why ERHR did not pursue this line of inquiry was because it's an allegation of direct discrimination. Was because
I'm just having a lot of trouble accepting that, because the direct discrimination is the complaint, and the allegation, the pleading is you failed to do nothing about it.
Yes, exactly. So the allegation in the pleading is my employer failed to do anything about a discrimination reference.
No. The pleading. Well, all right.
Do you see my
point? We've said enough on this. I think. I
think I should just end this, if I may, Judge, respectfully, simply to say that I want to record it that I'm happy to go with the whatever's laid out on the four corners of the pleading document. I'm happy with that. But what we have understood the claim to be in this regard, and I made it clear in opening because this was set out in the opening as well, that we understood the complaint is that not that the employer is vicariously liable in law for the two anonymous speak-ups. Let me be very clear, that's never understood to be the complaint. It is some failure by the employer to act upon receipt of those two anonymous speak-ups.
Well, what would you have done if you had been aware that you're said to be vicariously liable? It couldn't have made any difference the way you conducted the case, could it?
No, because
you're not prejudiced by your misunderstanding. If the plea properly construed is an allegation of discriminatory act for which by somebody who can be inferred to be an employee and for which you are therefore liable, your misunderstanding of the plea doesn't help you, does it?
No, it's not misunderstanding of the pleading. It's whether the pleading is a complaint. Let me put it this way, and I'm with facts are going around in circles. Does the pleading make a legal claim of discrimination, a freestanding substantive complaint of discrimination against the two writers of the anonymous complaints? Separately, or is the pleading saying, look, these complaints, anonymous complaints, were registered. My employer did nothing about it. Now, my understanding is that it is the latter. That is confirmed by the list of issues. We confirmed that in the opening. Nobody resolved from that. All of our witness statements have dealt with that on that basis, and we've explained why we did nothing about it, and that matter wasn't undermined. And ultimately, what hasn't happened here is that there is no suggestion that the reason why we didn't do anything about it was unlawfully motivated.
Well, I don't want to put words in your mouth, but would one answer to be to this, that unless I find as a fact that there was a toxic culture within GIB driven by race, it doesn't matter, because an investigation wouldn't have changed the course of history?
No, quite.
Is that an answer to this proposition or not? Well, perhaps that's more a question I'm throwing at Mr. Bickford-Smith, really. So,
I don't see. I mean, one needs to understand what is being complained about, and I don't want to repeat myself. I think I've been as crystal clear as anyone can possibly be in faced with this.
But what I'm really putting to you is, if contrary to your submission, I find that a reasonable employer would have conducted an investigation. If I find that in fact there is no evidence of racial vilification as a culture within Group Islamic Banking, then the investigation wouldn't have changed the course of history in any way, and Mr. Mahmood, who didn't know about these complaints, has suffered nothing.
Exactly, absolutely. But the reality here is that, and I think one needs to be very clear about this. In race discrimination claims, it's often labels such as workplace discriminatory culture, environment are loosely bandied around. That does not absolve a court or tribunal from the very difficult task of identifying specific acts or omissions which were motivated unlawfully. So in other words,
and that's why I've spent so much time talking about these two, because these two fall within that category.
Yeah,
these two anonymous complaints.
All it does, all it might do is suggest that there are some malcontents within the department or some individuals, but the connection, the causative connection with what happens to the claimant by other people subsequently, the connection still needs to be made. In other words, let's imagine for a moment that there is a rotten apple in the state of GIB. Let's imagine that. One still needs to connect the dots on the evidence, and one needs to understand that the decision makers, who are varied and different at various points in time, where's the evidence of them being motivated by the unlawful protected characteristic, and less so, where is even the evidence of any collusion between them, even assuming there's one element in GIB which is a rotten apple, as I call it. Does that clarify, Judge?
Yes, it does. Thank you.
And it might be just the way to deal with it, because otherwise we will, and it will be a feature of my closing in relation to time limits, because you may have, even if you have one unlawful act 2 years out of time, that's out of time, unless that
unlawful act you didn't know about. That's pretty good ground for extending time, isn't
it? Yes, it would be if the it depends what you're saying the act is. If it's the act occurred when the act occurred, in terms of the failure to investigate.
If the complaint is that there was an anonymous complaint that should have been responded to in a particular way and it wasn't, and I didn't know about the anonymous complaint, therefore I didn't know about the way in which it was responded to, then surely that would be a good case for extending time, wouldn't it? It'd start time running from when the person found out about it, which it seems was in March 2021 when the DASR material was provided.
The claimant's date of knowledge is relevant to the time principle. I accept. Yeah. But that doesn't give the claimant an extension of time in relation to everything else, for example, and maybe only in relation to that. Only in relation to that one discrete out of time event. So I don't want to, I think it's disproportionate. I don't want to spend too much time on something which ultimately won't lead anywhere for anybody. Is this an appropriate time just to take a short break? I just think I need to catch my breath.
Yes, right. Is 10 minutes long enough? Or do you gentlemen want to have some food, or how much longer do you think you'll be, Mr. Setti?
I think I'll be a while longer, because I just need to go through these.
About an hour?
Yes.
And Mr. Bickford-Smith, you'll want a time of reply. Do you want to take a lunch break? It must be getting close to lunchtime where you are, gentlemen. Do you want to take a lunch break, or do you want to press on?
Yes, I think that would be sensible.
Right, take a lunch break.
Yes, it's 1:20 here in the UK.
1:20, is it? All right. So when do you want to break? Come back at 2 your time.
A 40-minute break. That's fine.
Yes. All right. We'll resume at 2 p.m. your time.
Thank you, Your Honour.
Go and leave the lines open, and we'll take it on then. Thank you.
Okay. I'm grateful for Your Honour.
Thank you.
Your Honour, I'm here. I'm just trying to boot up the camera.
Okay. Well, if you can hear us all right, Mr. Bickford-Smith, perhaps Mr. Setti, you could start.
Thank you, Your Honour. Your Honour, just to finish off that last point, I was making the point that it's one thing to complain about the content of the 2 original complaints as an act of discrimination, and another to complain about the failure to investigate the 2 references in the anonymous complaints. They're 2 separate allegations, and we've certainly understood the latter to be the case, and that is what appears, we say, from the way in which the case has been prosecuted by the claimant. But on that latter point, we should just be reminded of the following fundamental facts. These anonymous complaints came in, they went to the investigation team, and the investigation team passed them to Ms. Dada. It's not correct to say that the defendant ignored the complaints. They were passed to Ms. Dada, who undertook, she may have undertaken an inadequate investigation. Those. She may not have spotted the 2 references in the 2 anonymous complaints and acted on them. And as you know, she was the subject of, she was underperforming and she was subsequently dismissed. That's all in the evidence. And she, so she may not have addressed the 2.
Well, I think the correct statement is she was put under a performance plan and she resigned.
Yeah. Correct. Correct. And if one looks, for example, at part of her investigation was into the toxic work environment within the GIB team, albeit she was looking at these in terms of the complaints against the claimant, and we see reference to the toxic work environment within the GIB team at in Myrna Al-Najjar's witness statement at paragraphs 31 to 33.
That's a different toxic environment. I think that the toxic environment that was under the tension between Mr. Mahmood and the rest. It wasn't
correct.
Racial.
No. I'm not making excuses. I'm simply saying that she looked at it through the prism of these are complaints against the claimant. She didn't look at it the other way round. It seems, but that is, if it is a failing, it's a failing of hers. And we know that she was subject to performance management, and we've seen the quality of her investigation then as well in terms of the ways in which that developed. But if there's a fault there, it's the fault of Miss Dada, and we know that she was underperforming from Myrna Al-Najjar's paragraph 55. But Judge, the other point to remind ourselves of is the fact that the claimant does say that he complained to Mr. Cuss, who conducted the subsequent BMA review, which conducted a review into the culture of GIB and the environment. You recall the BMA review conducted by Mr. Cuss?
Yes.
So it's not the case that the defendant, the bank, undertook no processes whereby it investigated the culture in GIB. And then, of course, you also have Mr. Mahboob's subsequent investigation into the victimization concerns of the claimant, where he had ample opportunity to raise anything he wanted to raise. Now, that was therefore considered. There's no evidence that Miss Dada was directed or influenced or procured not to investigate the 2 references in the 2 anonymous complaints. So the point is that she may have looked at it only from the perspective of complaints against the claimant and didn't go any wider. But the fundamental decision that we are here today tasked with, however imperfect an investigation it may have been, I don't agree it was, but however imperfect it may have been, was the reason for that omission, was the reason for that grounds because of the claimant's protected characteristics, because of course this is said to be a direct race discrimination claim, and would Miss Dada have not made that omission had the claimant not been a British, Asian, or Pakistani origin who's apparently relinquished his heritage? Do you see the point I'm making?
Yes, I do.
So, I'll say no more. And it comes back to just the general principle at the beginning, which I laboured on the law, which is many cases go to trial because there may be elements of unfairness or procedural impropriety or some things which could have been done better in exercises of duties of care and things like that. But that doesn't get you anywhere. That might get you only as far as first base to establish that there's been some kind of detriment. In other words, the claimant was entitled to more and more didn't happen in his case. But what it doesn't get you to is to answer the reason why. So the reason why the omission occurred. And so that I'll just leave it at that. And I said there's no evidence at the moment to indicate that the reason why was that Ms. Dada was motivated unlawfully. So that also deals with, can I just check one point? Yes, there's a reference. If you go to my Appendix 1, Section 22, are you there?
Whereabouts in Appendix 1?
Paragraph 22.6.
Yes. Page number, do you have a page number for that?
I don't have a free page number, but if you're the PDF, Your Honour, is bookmarked helpfully. I've created bookmarks. If you know how to use those, you can jump straight to Appendix 1, Section 22. Can you do that?
Right. No. Let me have a look. Let me see if I can find the bookmarks. There they are.
You can reveal the bookmarks.
Oh, yes. There we go. Yes, I've got them. I found them.
Wonderful. Can I just say, Your Honour, if you haven't...
And it's 22. So which number one is it, appendix?
22.6.
I've just got 22. Ms. Dada's grievance investigation. That'll get me there. Yes, I've got it.
Yes. Go to 22, and then if you within 22, you look to 22.6, and
got it.
We see there that Mrs. Al-Najjar never had any discussion about disciplinary action being taken against whoever submitted the Jack James complaint or the 30 January complaint, i.e. the other anonymous one, because she did not know who had submitted them. Regardless, she would not expect any disciplinary action to be taken against an employee who submits a grievance or speak up unless it was shown that they had done so maliciously or in bad faith. That was not the case in this instance, and that's her paragraph 36.
But that's a quite inadequate answer to the proposition, isn't it?
No.
But say, well, our policy is defective because that policy wouldn't involve any response to the most blatant and outrageous racism.
Well, the policy may be defective, and it may be that may well be the case, but that is the explanation.
Yeah.
That is that may not have been fair to the claimant, but that is the discrimination neutral explanation for why no action was taken against the proceedings or anything was taken against the two anonymous authors of the complaint. And then she also says that paragraph 37 in the next paragraph there, 22.7, Ms. Tabara assumed responsibility for the Jack James complaint and the 30 January complaint in her capacity as the head of ER for the UAE. She ultimately delegated all the complaints against the claimant to Ms. Dada to deal with, and Ms. Dada then dealt with them. And
so, Mr. Sethi, it seems to me it would be a very construction of legislation of this kind, which would produce, let's take an extreme example. Say there is outrageous, overt racism within an area of a large corporation. The corporation knows about it and then does nothing and says, we did nothing because our systems are bad and because the person who we conducted to conduct the investigation was an idiot.
Yes,
that surely can't be right.
Judge,
that would be a very odd construction of the legislation.
Okay, Judge, can I answer that? That would be right. I know I hear what you say about being odd. That would be absolutely right. And given the time, I can produce cases which deal with this. But let me put it this way: you could deal with somebody. You could fail to act on the most outrageous discrimination complaints if the reason why you fail to act on those discrimination complaints is not discriminatory in itself, because it's down to gross negligence, or the most spectacular failings of procedure, that is an innocent explanation which would not found in liability for unlawful discrimination. And sometimes, and if you want to work in extreme examples, there's a colloquially there's a type of defense sometimes referred to in discrimination law as the bastard defense. In other words, I'm a bastard to everybody, regardless of the color of their skin, and I don't have a problem with the color of someone's skin. I just don't like dealing with grievances, however outrageously, obviously serious they are. Now, if that's the explanation, so long as that's credible, then that's the explanation, and it's free of discriminatory taint. The fact that the background relates to a complaint of discrimination or something to do with discrimination is background context, but it's not the motivating factor behind the omission or the failure to act. So I hope this is being recorded and to transcribe today's closings, because
yes,
I want to be very clear on this, very clear, crystal clear, in fact, that in response to the example you give, Judge, I disagree. And even the most, where you would have expected someone to act in the face of a complaint of discrimination doesn't mean that their failure to act is discriminatory. It might be a breach of a duty of care for health and safety or other things, but it's not unless you have to make a primary finding of fact on the evidence that what motivated the individual to not act on. Firstly, you've got to know that Miss Dada saw those two, she spotted those two references in those two anonymous grievances. Secondly, that the reason why she didn't act upon those was because she was motivated by the protected characteristics or protected acts. And we need to get to that position. And that is not, as I understand the evidence at all in this case. Can I move on, unless, Judge, you have further questions?
Yes. No.
But do you feel, and be frank with me, Judge, do you feel that I've been sufficiently clear on that?
Yes, I understand your position. I'm not saying I necessarily agree with it, because it's complicated and I need to think it all through, but I certainly understand where you're coming from.
Thank you, Judge. I'm grateful. And yes, let's move on. So, if I can then go to 10 point, I think we're at to really 11 to 12. It's the second alleged protected act. And what it is that the claimant is suggesting, and this is quite ironically well timed given the discussion we've just had, he is saying that he orally repeated to Mr. Cuss of the BMA team the complaint that he was being racially bullied by GIB. And the long and short of this matter is that there is no evidence apart from the claimant's say-so, that he informed Mr. Cuss of this. And when one looks at the documents surrounding Mr. Cuss's BMA investigation and review, there is no reference to the claimant raising this. And if he had raised it, then there would be a reference to it, because it's such a serious matter and he was looking into the culture of GIB. And when one does see what Mr. Cuss was looking into in relation to any issues to do with race and the GIB, one sees this at page 2769 in the trial bundle, when on the 26th of June 2019, Mrs. Al-Najjar receives an email from Mr. Cuss asking her to explain the wholly Pakistani origins of the team and the lack of Emiratis. So in other words, the lack of diversity was something that he was clearly looking into. And we say all of the evidence that we've heard does not point at all to the claimant raising with him that he was being racially bullied by by GIB. And so the reality is that we say the claimant did no more to say to Mr. Cuss than what he said to Mr. Long and others, that there was a diversity issue in GIB, but didn't go further to say that he was the victim of racial bullying by GIB. So there's no evidence to corroborate the claimant's assertion. And even if it's found that he did say that to Mr. Cuss, there is no evidence to support a finding. This is important, Judge. So imagine, and let's park my primary submission that the evidence indicates the claimant did not likely say that to Mr. Cuss. So the Protected Act did not occur. even if it is found that he did, there's no evidence to support a finding of fact that Mr. Cuss told anybody else that the claimant had alleged a Protected Act complaint to him, that he was being racially bullied, right? So that Mr. Cuss told anybody else, let alone is there any evidence to suggest that that other person acted on such knowledge that the claimant had made a Protected Act to Mr. Cuss in meeting a detriment out to the claimant. Do you see the point?
Yes.
So what does it matter that even if he did tell Mr. Cuss that, where's the link to what subsequently happens to the claimant to suggest that what subsequently happened was victimization because of something the claimant said to Mr. Cuss? And as I understand it, Mr. Cuss is not a individual discriminator in this claim. The next issue is against really Mr. Phoebe. It's what I call background issue 13. It's not pleaded as an unlawful act of discrimination, victimization, or harassment. The allegation is that Mr. Phoebe gave some negative feedback to Mr. Long, I believe, in an internal email in a discussion about the claimant's performance rating. You see, Judge, at 17.13 of my closing, I make the references to the relevant factual material, the who, what, and how in relation to the 2018 performance appraisal. And what we see here is clearly the claimant had let's just say a high opinion of himself. This is the rating you'll recall, Judge, that the claimant self-rated himself as 1A. Do you recall that evidence?
Yes, I do.
The highest rank given to the highest performing employees in the bank's global business. I won't say much more about that. I've made written submissions on this, and the reality is that the claimant put to Mr. Phoebe in cross-examination that Mr. Phoebe's email to Mr. Long of the 28th of February 2019 at 1901, that's page 2030 of the bundle, in which he was critical of the claimant's rating himself a 1A, was written by Mr. Phoebe because the claimant is not Caucasian. So Mr. Bickford-Smith fairly put this allegation to Mr. Phoebe of direct race discrimination, albeit that it's not a pleaded unlawful act. And you see the quote that I've set out in from the transcript at 17.13. Do you see that, Your Honour?
Yes.
Where he says, my learned friend says, I put it to you that the simple fact is you are all Caucasians, correct? And he says, correct. I put it to you that consciously or subconsciously, part of your reaction to the claimant and the reason why you feel so free to sound off about him, that's in that email, in the way that you do, is that he isn't. And he says, I would completely disagree with that. So you see there a very good example of exactly how to put the direct discrimination claim against a defendant witness in relation to something actually which wasn't even pleaded as an unlawful act. But there we go. But in all circumstances, we say Mr. Phoebe's feedback may have been firm, but it certainly was very fair and can't be criticised. If Mr. Phoebe's feedback was firm but fair, then it cannot be a detriment in law. It was reasonable. And on the evidence, there's no finding of primary fact from which it could be inferred that Mr. Phoebe would not have given the same feedback to a Caucasian with white skin, and or that Mr. Phoebe gave the feedback to the claimant because he is not a Caucasian with white skin. So that's how we deal with that point. In relation to issue 14, if I may, and Judge, will I rely upon you to just stop me if you think I'm going too fast?
No, I will. Yep.
In relation to issue 14, this is an unpleaded protected act. It's what I refer to as unpleaded protected act 1. Now, the claimant is saying that his 1st of April 19 speak-ups, I think there were 2, were protected acts. Now, he wants to rely upon. And the first thing to note is that he does not rely upon this issue. The protected acts are exhaustively pleaded at APOC second numbered 68A.6 68A.2, 103A.4, and 130A. And crucially, they are then summarized again. In other words, the claimant summarizes what his protected acts are after individually referring to them in the pleading at those 3 sections. He then summarizes them and cross-refers back to them in paragraph 152, capital A. So he's very clear as to what his protected acts are that he wishes to rely upon. This is not one of them. The fact that he may mention in some factual narrative in a pleading a matter doesn't mean that it is something that he intends to rely upon. Now, we say that in any event, he alleges that his speak-ups allege breaches of Article 40 of the 2005 law and Article 43 of the 2019 employment law. But the problem he has is that neither speak-up, in fact, alleged breach of Article 40. Further, neither could allege breach of Article 43 of the 2019 law, since that was not even in force at the time of those speak-ups. So he has a problem with this amounting to a protected act anyway, even though it's not pleaded. So we say not pleaded, not capable of amounting to a protected act in law. And the history behind this, Judge, is that they were originally pleaded as whistleblowing disclosures in his original particulars of claim, but they were struck out by order of the court. And he's sought now to rephrase them in his argument, it seems, as a alleged protected act, which it isn't. If you're the other point is, Judge, is this: the other reason why it's not a protected act in law is that you need to be alleging a breach of the he says that they allege a breach of the employer's general duty of care under those articles 40 of the 2005 law and 43 of the employment law. The problem he has there is that alleging a breach of that can't amount to a protected act. In order to amount to a protected act, you've got to be alleging a breach of Part 9 of the 2019 employment law. In other words, that there's been some unlawful discrimination. And that's what's required by Article 60, subparagraph 2, subparagraph D. In any event, on the 15th of July 2019, Mr. Amos, Miss Ayrton, and Mr. Bucket attended a call with the claimant to discuss his latest concerns. And the claimant was asked specifically whether he felt he had been subject to any victimization because of his speak-ups. And he confirmed that he did not believe he had been subject to any victimization. That's in Simon Block's Bucket's witness evidence at 75, which was not contradicted. So it's not pleaded as a protected act. Even if it was pleaded as an amount of protected act in law, and in any event, the claimant himself indicated that he was not victimized for having raised it. So this, we think, does not get anywhere. The next point, issues 15.1 to 15.7. These are about treatment by Mr. Shape, and it's said that this was victimization because of some protected act. It's 15.1 to 15.9 and 16 and 17 of the issues. And what the claimant is understood to be alleging here is that Mr. Sheikh victimized him because the claimant raised the 2 speak-up disclosures on the 1st of April. Now, you've got my submissions just a moment ago that those 2 speak-up disclosures don't even amount to protected acts, but let's assume they do amount to protected acts. He's saying that he was victimized as a result in these list of issues. His problem is that they're not pleaded as acts of victimization. Because APOC 152B makes clear that the acts of victimization are limited to those set out in APOC 68A.1, 69A, 91A, 101B, 109, and 142, namely the dismissal. Do you see that, Judge?
Yes, I do.
So this is only a matter of evidential background, and you might not wish me to spend much time on it, given that there is a list of things that he complains about. But in terms of the factual narrative evidence of who, what, and how Mr. Sheikh interacted with the claimant after the 365 feedback and all the various issues that form the factual backdrop of this claim, we say it's hardly surprising that there was a reduction. You recall the evidence that Mr. Sheikh sought to introduce Mr. Long more and more so into meetings with GIB because of the relationship breakdown with the claimant. It's not surprising that in those circumstances, there was less interaction with the claimant, of which the claimant complains. That's the explanation for it. That's the non-discriminatory explanation for it. And we say that that is perfectly credible and consistent, and in the chronology of events makes complete sense. There is no evidence upon which findings of fact can be made, we say, to indicate that the reasons were something sinister, something else, something unlawful, as relied upon by the claimant. But it's an unpleaded victimization set of allegations. That's set out, Judge, at paragraph 17.15. Mr. Sheikh gave evidence on this extensively in his witness statement, dealt with it in cross-examination. But again, with cross-examination, the difficulty is that not only is it not a pleaded act of victimization, not only is the claimant's sense of being slightly sidelined an unjustified sense of grievance in the circumstances, because he's the author of his own misfortune here in causing GIB's back to be put up, if you like. But the difficulty is for my learned friend is that there needs to be evidence, including putting it to Mr. Sheikh, that the reasons why in those 9 or 10 respects the claimant was so treated was not because of the explanation given by Mr. Sheikh, as I've set out, but because Mr. Sheikh was aware that the claimant had recently submitted his 1st of April disclosures or protected acts.
Well, it's just another example of it's the same question that runs through the entire case, and that is, what is the reason for what happened?
Yes, exactly.
Is it the prohibited motive, or is it not? And
yeah, but here,
you're
absolutely right. But here, you see, the interesting point is, or the compelling point is, that Mr. Sheikh was never told that Project Barroso related to disclosures made by the claimant until after the claimant had left the bank. So he therefore could not have changed his behavior towards the claimant as a result of the claimant making the disclosure on the 1st of April, which led to the Project Barroso investigation. And Mr. Long never discussed Project Barroso with Mr. Sheikh or any other member of the GIB team. And Mr. Long says he didn't recall any noticeable change in the way Mr. Sheikh behaved towards the claimant following Project Barroso. And the reality, we say, is that the relationship had not been very positive for a long time, even before Project Barroso got underway. But I'm not going to go into the details of these 9 or 10 points that the claimant makes against Mr. Sheikh. It wasn't properly explored, and in any event, you have the evidence. It is instructive to note, however, that Mr. Mahmood subsequently found that the observations made by the FCCI3 team in the Project Barroso report were very relevant, when he found that GIB are reluctant to involve Mahmood in matters often going directly to group compliance rather than utilizing their dedicated resource. GIB view Mahmood's involvement to be detrimental to business processes due to the nature of the way he works. While many of those interviewed by FCCI3 stated that Mahmood was a very competent compliance officer, there are many examples where his communication style is non-conciliatory and escalates matters quickly. That's Mr. Mahmood, para 88E, not undermined in cross-examination. Mr. Mahmood concluded that the increased involvement of Mr. Long was because of a growing lack of confidence in the claimant as a result of the claimant's way of working and interaction, and Mr. Mahmood found no evidence that the claimant had been victimized by having his role unduly undermined. And that's 88F. Now, of course, this is the bank's own internal investigation process, but nevertheless, it was conducted quite thoroughly by Mr. Mahmood. And we see that those are the findings that he made closer to the events in time. So we say here, no pleaded act of victimization, and it's an unjustified sense of grievance by the claimant, if not him being the author of his own situation there. 17.16, Judge, that is the only admitted protected act that on the 6th of August 2019, the claimant allegedly complains to the I3 team about the alleged Akbar comment to Mr. Vaselli. And what is interesting here, you have my submissions there in writing, but save for that protected act, the claimant emphasized in his interviews with I3 that his concerns about the GIB related to culture, governance, and control, and particularly the performance of Mr. Akbar. The claimant did not make any allegation of discrimination. He did not say anything about his race or nationality, nor did he make any allegation about his accent being mocked. And this is quite important.
Mr. Setti, I've read your submissions. There's not much point to be achieved by reading them to me again.
Very well.
So you can take it. I've read them. So
I'm grateful.
It is getting on, and I've anyway.
But the one point I would say here before I move on to the next issue is that it's the point I make in subparagraph D, and that is that the claimant was interviewed not briefly. He was 9 hours of I3 interviews with the claimant, and Mr. Bucket has given direct evidence that he did not once allege that the claimant did not once allege that he had been subjected to discrimination or harassment because of his race or nationality, or victimized because he had raised the complaint of discrimination or harassment. And it was the claimant himself who admitted to Mr. Bucket that the claimant had lost his temper when which had led to him shouting and interrupting and speaking over others. So there are admissions that the claimant made to Mr. Bucket which are of relevance. Let's move on to issue 18. And of course, Judge, can I just say in relation to all of these, one would expect there to be moments in the cross-examination of Mr. Bucket where if he is said to be a discriminator, or which I don't believe he is, but if he is, one would expect the case to be put to him. And even if he is said to be the person who received a protected act, one would expect again the same point put to him, but which it was not. That's important. 17.17. This is the sixth discrimination allegation and the first allegation of harassment. And this is about whether Mr. Akbar made the alleged comment to Mr. Vasselli on the 5th of August. I'll cut this short, Your Honour, because this is something, of course, that was laboured in cross-examination, but it didn't hit home on exactly the point that needed to be put, for example, to Mr. Akbar. Because there's the point about whether it was made, and there's a point also about why it was made. But at the moment, it is suggested that this was made because of the claimant's protected characteristics, and it related to his specific protected characteristics. That matter really did need to be put to Mr. Akbar. But the other point is really this, on whether it happened, and it's a point you've observed yourself, on the quality of the evidence before this court. Mr. Vasselli could have been called. He was not, by the claimant. And it is for the claimant who knows the claim, the defence that's being mounted here, to do so. So what the quality of the evidence is before the court is of double hearsay, as you observed earlier. And I don't need to go into that, Judge, you'll have read the submission. But there is a point even on if it was said, whether it is fair and just on the test of vicarious liability to hold an employer liable for a comment made of that kind, depending on what you find was said. Because of the reasons why I say and the cautions given by Lord Justice Underhill that not every single unfortunate comment should be sound in liability. Dealing with issue 19, Protected Act number 4. Now, it is suggested that during an investigation interview on the 5th of September, the claimant told Mr. Tabara that there was a discriminatory environment in the Islamic banking department that focused on his British nationality and saw his accent mocked. So we see a very specific reliance upon him saying he'd complained to somebody in ERHR about his nationality and accent being mocked. And our position is that no such allegation was made to Mr. Tabara. Now, the factual evidence surrounding this is set out at Appendix 1, paragraph 26. The claimant did not put to Mirna Al-Najjar or to Pavneet Bajwa that the claimant made this specific complaint to Mr. Tabara. There's no documentary evidence or witness evidence to support the bare assertion that he did so. And at best, we say, he alleges that on that day, he told her that Mr. Akbar had made the comment that he knew how to deal with British people, even if they had been masters. Now, we say that is not the Protected Act pleaded at APOC 64 about a discriminatory environment in GIB, which saw his accent mocked. So the pleaded Protected Act 4 did not occur. Moving on to issue 20 to 20.4, this is the 7th act of discrimination, the first act of victimization, and the second act of harassment. This is about Mr. Barra's suggestion and Mr. Long's ultimate ratification or decision to relocate the claimant to the compliance floor. Again, I won't go through the factual detail, which is set out. But what is clear is that the claimant's sense of grievance about this is unjustified. It was to his advantage, in fact, to relocate, given his reported feelings of stress and the poor state of relationships he had with GIB. And the reason for the move was his well-being and the breakdown in the relationships. So the two reasons: his protecting his well-being, looking after him in discharge of the employer's duty of care, and the breakdown of the relationships. Now, allegations, this allegation is an allegation of direct discrimination and harassment, was simply not put to Mr. Long. At no point is it put to Mr. Long that he decided to move the claimant either in circumstances where he would not have decided to move someone who was not Caucasian, with white skin, nor was it put to him that it was because the claimant was Caucasian with white skin that he moved him, nor was it put, for the purposes of harassment, that his decision related somehow to the claimant being not Caucasian and with white skin. Nor was it put to him that was his purpose, if indeed the claimant's case is, as I've said it is, he's claiming a positive conspiracy, not just one which was inadvertently resulted in detriment to him. So he's saying that Mr. Long had it in for him. So when was any of this intent going to be clearly put to Mr. Long for the purposes of a discrimination claim? And in terms of victimization, you see, allegation of victimization was put to Mr. Long, in that it was suggested that Mr. Long decided to move the claimant in response to the claimant complaining to Mr. Barra on the 5th of September, the Protected Act 4 that we don't agree happened. Now, Mr. Long was not aware of Protected Act 4 when Mr. Barra first suggested the floor move. And in fact, he says it in evidence, and I've quoted from the transcript to that effect. So we need evidence that the alleged victimizer had knowledge of the alleged Protected Act and acted with that knowledge to the claimant's detriment. Nor for completeness was it put to him in cross-examination that the floor move was caused because of that awareness of that Protected Act, let alone any other Protected Act. So we move on then to issue 21. That's a claim of discrimination, victimization, and harassment. This is Mr. Barra's decision to recommend bringing disciplinary proceedings against the claimant. You have the source references for the factual details. The reason why disciplinary proceedings were brought against the claimant was his suspected misconduct. The reason for it wasn't on the instructional impetus of Mr. Sheikh or Mr. Akbar, and there's no evidence to that effect. You have my submissions in writing on this summarized. The important thing is that Ms. Tabara, who is the decision maker here, okay, is not an alleged discriminator. She's not one of the individual discriminators. And there is no evidence that she was acting in concert or on the instruction of others with a discriminatory mindset. This may be one of the issues, Judge, that my learned friend has abandoned. I'm still wholly unclear as to what claims no longer I need to respond to. There we go. But Mr. Sheikh and Mr. Akbar had no involvement in this disciplinary process. And then what you see in my subparagraph 5 of 17.20, I focus on the what was not put. It was put to Mirna Al-Najjar in cross-examination that she had decided to put the claimant through a disciplinary, and Mr. Barra was following her instructions. So let's be clear about this. The claimant's case as advanced at trial was against Ms. Al-Najjar. It was saying that Ms. Al-Najjar was instructing Mr. Barra to act as she did. Or that somebody else was instructing Ms. Al-Najjar to instruct Mr. Barra. Well, however complicated the conspiracy gets, the evidence doesn't support it. I mean, even Ms. Al-Najjar is not one of the 3 compliance members or 4 JIB members or 4 speak-up complainants that the claimant confirmed were the targets of his discrimination claims. The other thing is that it wasn't put to her that she allegedly, that Ms. Al-Najjar made the decision to commence disciplinary proceedings against the claimant.
Mr. Sethi, I'm sorry to interrupt. I'm struggling to see the utility of this. It's been a very long day.
Yes.
And you're not saying anything, as best as I can see, you're not saying anything that isn't in your written submissions. I just wonder what the utility of it is.
What I'm saying in addition is this, Judge, where I say that something was not put, that the reason why was not put to the witness, in other words, that the treatment was done because of the protected characteristic. Can I just be clear? There is an additional preliminary question to that, which also was not put in each case, and that was the less favourable treatment question. So what I say is that the less favourable treatment question was not put to the witness in each case, as well as the reason why. That's because both of those are parts of the legal test for direct discrimination. And the less favourable treatment, you need to put the hypothetical comparator to that individual. Why?
Well, Mr. Sethi, we're spending a lot of time talking about pleadings in Brown and Dunn. And I have to, of course, I will listen carefully to all that, but I don't think that's what the case is going to turn on.
Well,
so I think, and it's all in your written submissions anyway.
It is.
I think it would help me if you just focus on points that are not in your written submissions.
Well,
there's not much point having an oral hearing if counsel turn up and read their written submissions to the judge who's already read them.
Judge, let's look at 17.21, and I'll only say things that are not there. As I understand it, Mr. Abu Shaz is not an individual discriminator. Am I right? If I'm right, we can move on.
Well, Mr. Bickford-Smith, I think that's a call to you.
Sorry, Your Honour, I've got a lot to say about Mr. Sethi because he is. I'll answer.
Can you answer this question?
No. The question was: is Mr. Abu Shah a discriminator? Or
no, it hasn't been put that he is.
All right.
And he didn't give evidence.
That's your answer, Mr. Sethi.
That is that's.
But Your Honour, I should say I have been staying silent through this. I simply do not accept the description of our case or any of the points that are being made. The reason I was reluctant to get involved in answering questions is that if there's going to be repartee here, I'm more than happy to say that a number of the points that have been advanced to Your Honour in the last half an hour are quite simply wrong on the facts and wrong on the documents. And I'm going to be having to spend a significant amount of time going back through the pleadings.
Well,
because
I have
is
exactly
simply
the same position in relation to my learned friends.
Yeah, exactly.
Details this morning.
And that's
time doesn't allow us. We're dealing with the big points here.
Well, do you want to? I'm not. It's almost 10 o'clock at night here. We've been going for 7 hours. I'm not going to go into the middle of the night, gentlemen. If you're going on like this, we'll adjourn and come back another day.
Well, Your Honour, let's perhaps not do that. I shall only say things to you which aren't in the written submissions. But the point is, see, this is a very helpful matter. Here you have an example of an act of discrimination, victimization, and harassment. And my learned friend says, actually, you know what? We've all been up the wrong tree here. It's nothing of the sort. So if he's not an alleged discriminator, victimization, and harasser, I will move on. Then let's go to Mr. Zulu, issue 23. Is he an alleged discriminator, victimizer, or harasser? If not, I can move on. You see my difficulty,
because the issue. Do you what's the phraseology of this issue? Issue 23. I mean, I also have to say I don't understand it. We have it.
Focus on the question, please, Mr. Bickford.
No, I'm going to say you, Mr. Sethi, are attempting to have.
Is it an act of discrimination, victimization, or harassment?
Mr. Sethi, please let Mr. Bickford-Smith say what he wants to say.
It is not the case that the question my learned friend has asked is dispositive of the issue.
And the answer to the question is...
Why is that, Mr. Bickford-Smith?
Which issue are we looking at? Issue 23.
Mr. Zulu.
Which paragraph of the list of issues are we at now?
Issue 23.
Issue 23, paragraph 17.22.
Sorry, issue 23 is the same legal issues arise in respect of the rejection of the claimant's appeal against the written warning, correct?
Yes, that's Mr. Zulu's disciplinary appeal decision. Now, is that disciplinary appeal decision an act of discrimination or victimization or harassment or none?
The point that the question that you asked was if Mr. Zulu, your question is premised on Mr. Zulu needing to be the discriminator. That is not a case that is pleaded. And my fundamental objection to this going through of the list of issues, Your Honour, is that at one and the same time, Mr. Sethi has said that he's not happy with the list of issues. As I understood it, he assented to Your Honour's proposition that the list of issues be at most a helpful guide. But he's not going to the pleading, except where...
101B. 101B. Let's not waste time. 101B.
All right, let's go there.
B.
Capital B.
Yes. The appeal outcome was a detriment. It clearly was a detriment. Yes. Do you not agree? Do you not agree? Do you not agree that a decision to reject an appeal is a detriment because the formal warning stands? On what definition of the word detriment is that not a detriment?
Judge, if you read on and say, look at the next paragraph, the defendant is liable under 61.5, read with 59.2 of the employment law. The defendant is liable under 61.5, read with Article 62 of the employment law. The defendant is breached its duties under Article 43.2, and it's all based on Mr. Zulu's appeal outcome being a detriment.
No, it's not. It's based on the whole of the section from paragraph 92 onwards. Further and in the premises referred to are those at paragraph 92 to 101A and 101B and the rationale for this is set out in 101A.
Yes, look at it. The appeal outcome letter. Who wrote that? It's Mr. Zulu. Are you suggesting it was done by somebody else?
No, well, there is correspondence in the bundle between Mrs. Al-Najjar and Mr. Zulu, is there not? In which she says that the appeal should be dismissed.
Judge, you see my difficulty, I hope.
Well,
but Your Honour, I hope you understand my difficulty. I mean, I'm being asked roving questions about the case, but I'm being asked.
Yes, well, I don't think it's appropriate to interrogate, to run this process on the basis of interrogatories issued to counsel, because there are premises, there are also assumptions and premises underlying any question, obviously. So I don't think this is useful, but I don't think it's particularly useful, as I've said many times, to go through the issues, because as I've also said many times in the course of the day, the issues are very poorly phrased, and they don't always correspond to the pleadings. And Mr. Sethi has been at pains throughout this trial to tell me repeatedly that the pleadings are the boundaries, provide the boundaries of the case.
And Judge, when every issue I have headlined in my closing submissions, everyone, where there is a corresponding relevant pleading entry, it is set out in the title. So at 17.22, you have APOC 101B, and you have the corresponding amended defence reference. So I've been transparent about it. That's the pleaded case that we, however it's put in the pleading, but it is, you've got it on record. My learned friend is saying that Mr. Zulu is not an individual discriminator, and we can leave it at that. That is very helpful. Let's move on, because we can then see the case that was put, which was obviously doesn't support that. So 17.23 is Mr. Long's decision in relation to the claimant's 2019 performance appraisal to give him a 4D rating and to propose a PIP, a performance improvement plan. And our position on that is clearly set out therein. It was a firm, fair, permissible decision for his line manager to make. But what is clear is that that allegation, unlike, Judge, the earlier performance rating allegation that was put to Mr. Long, this performance rating allegation was not put to Mr. Long fairly, as it should have been, as I've set out, other than the victimization element. In terms of background, issue 28, this is Mr. Mahboob's review. It said that it failed to capture key details about the claimant's victimization concerns. This morning, my learned friend confirmed, or for you, Judge, in the afternoon, presumably, my learned friend confirmed that Mr. Mahboob is not the subject of having made direct any discriminatory decisions. In any event, it's a background issue, so I won't spend time on that. Issue 29, and I'm only referring to issue numbers for ease of reference, Judge. You don't need to rely upon them. Yes. You can rely on the APOC references happily. But the next one is a discrimination allegation, which is pleaded, but an unpleaded victimization allegation. And it is whether in a meeting with the claimant on the 21st of June 2020, Mr. Long, together with Ms. Al-Rashdan, proposed a mutual separation agreement. And it suggested that that is an act of direct discrimination and victimization. As I say, you only have to look at APOC 152 capital B to see that it's not pleaded as an act of victimization. I've set out in there our position on it. I need say no more. I've also indicated what was not put. And I can leave the matter there.
Yes.
Let's look at the next one. It's a discrimination and victimization matter. It's the decision to terminate the claimant's employment by reason of redundancy. It said that the termination of the claimant's employment for redundancy was a sham or pretext. In short, Your Honour has seen, and this is the only in-time complaint as an act of discrimination and victimization, Your Honour has seen that it is not seriously challenged that Tracy McDermott was the person that made a very high-level executive group-wide decision to make job cuts and to cut costs. Mr. Phoebe was the architect of the reorganization in Project ICE, or spelled ICEE, to delete a number of management jobs at certain levels. Mr. Long and Mr. de Groot implemented the Mr. TP's reorganization plan in the Africa Middle East region, and that included reorganizing a job affecting the claimant's role, and that ICE was not, the reorganization role was not Mr. Long's idea. It was much higher up the chain. That is the essence of the decision to make job cuts and how that, the genesis of that, that was divorced from the history of the rest of the history of the matter. I know the claimant would like to make a link. The claimant then, of course, sought to apply for the, quote, new role. And as we know, he competed for that. There were more than one person, but only one role. And on the defendant's evidence, the better qualified, the better experienced, the better suited person, by the unanimous view of the various members of the selection panel, interviewing panel, decided that it would be Mr. Patel who would be appointed to that new role. Mr. Patel being
somebody, I know all that. It's written in your submissions, and it was made clear at trial.
But the point is, I'm glad you've put it in that way. It was made clear at trial that there is no I say rhetorically. Therefore, where is the evidence upon which a primary finding of fact can be made that the decision to go through these redundancies and make the claimant's job redundant, and to ultimately the fact that he was unsuccessful in his application for the new role, where is the primary factual evidence upon which any inference can be drawn that it was motivated by the protected characteristics upon which he relies, or upon the protected acts, if they are protected acts, upon which he relies? And I say you have not been taken to anything, despite this being the only real in time complaint.
Well, you know as well as I do, the case that's put against you is that this was all part of a process that was started years earlier with the proposal of an MSA, and that this was the whole thing was a sham device to get Mr. Mahmood out of the bank.
Well, he wasn't the only one who was.
When you ask rhetorical questions like that, it's just going to invite Mr. Bickford Smith to repeat what he's already told us. So, you know,
but I think what
I understand the rhetorical flourish, but really,
it's not,
we all know what the cases are.
Well, it's actually it wasn't so rhetorical, Judge. What I was saying is, where is the, apart from saying that there's a history of this matter and there was clearly a breakdown in relationships. Clearly, the people didn't think that he was particularly good at his job. That much is a given. But the reality is that where is the causative link? Firstly, that there was a sham. That's the first point, because that would then amount to the detrimental treatment. That's the first point. And you've heard from numerous members of very senior management who've been interrogated uphill and down Dale on the subject. And there isn't any circumstantial or other evidence upon which a likely finding of fact can be made, I say, which would lead to the adverse inference of the motivation that's at play here. So I do say that the evidence is not there. Can I deal with the time point? Now, when it comes to timing, there are three. There are really three observations. The first is what is in time and what is out of time, and everything is out of time other than the dismissal, and all allegations of harassment are some months out of time. In terms of a continuing act, it is not right that there is generally a number of processes that are going on involving different people, involving the claimant, that is, over a period of time, and that gives rise automatically to a continuing act. The law on continuing acts, and this is not set out, so I'm adding to the written submission, is essentially this: that the court will have to find that each incident of substantive pleaded discrimination. So let's just take direct discrimination for a moment. Let's say you would have to find that there was a direct discrimination established in January, March, June, August, September, whatever of 2019, and that it was connected to what happened in 2020, in early 2020, in January 2020. Although, albeit that the decision to dismiss was slightly earlier. So you would have to find that those individual events are made out. Now, it is not correct, as my learned friend was suggesting, that you sit back and take some global view. You have to look in a micro way in relation to each pleaded claim of discrimination, because only ones that are actually discrimination can then be brought in time, because you're now at a final hearing stage. So if they're not an act of discrimination, then it would not be part of a continuing course of conduct which is capable of being extended, because only substantive pleaded detriments which are out of time, which are made out, my learned friend can make a submission that it should form part of the continuing course of conduct. In other words, you may well find that none occurred, or some occurred and some didn't, but it's only the ones that you find are made out that you need to then look to see how are the ones that are made out, and I'm very clear on this, how are the ones that are made out then connected? And if different people made those decisions, if they were made there's no other nexus in connection between them other than they concern the claimant, then that we say is not enough. And we know that from ample, at least in the English appellate authorities up to the Court of Appeal, where there needs to be real nexus in time, in place, in person, most importantly in person, because we're talking here about a continuous act. It's not that different people were doing something similar, it's that the same person did something repeatedly, or that he told the next person to be passed it on, and that there's evidence of that, and therefore there's a connected sequence of acts. That is the only way in which one then, and it has to be acts that are connected on the evidence to the dismissal. So let's be clear about this. It doesn't matter if there's a number of earlier things connected together. They have to connect to the only in-time act, which is the dismissal. There's no harassment claim in time. So all the previous victimization claims need to be connected to the victimization of dismissal, and all the out of time direct discrimination claims likewise. That is the way that this needs to be analysed. And if there are, crucially, so many different people involved, the difficult task, although I would say it was easier, because there's just not the evidence of connection, that you will not be able to, we say, reliably find on the evidence or primary fact the relevant connection. Now, in terms of out-of-time complaints, the question is, should the court exercise its discretion, and it's an exceptional discretion, to extend time for out-of-time complaints? And they, of course, and remember here we've got a 6-month time limit, not like the short 3-month one in England. And in the DIFC, the question is, are there circumstances justifying disapplying the, what I say is a generous 6-month time limit? And if there are, so you've got to identify what those circumstances are. So, for example, it might be in relation to the non-knowledge of the anonymous complaints granted, but not anything else. What further period does the court then consider was reasonable? So if there was something preventing the claimant. Now, just the mere fact that the claimant was undergoing an internal process is not a good enough reason in a discrimination claim to say I was going to await the outcome and I wasn't going to bring the claim, particularly where there is a 6-month time limit. And then the only other point I would stress here is that the English authorities on extending time are not applicable directly, because in England, there is a test of what is just and equitable. And in the DIFC Article 61(2)(b), the test is what the court considers reasonable. And I say that that accords with the test in English unfair dismissal extensions of time of reasonable practicability, because reasonableness there is construed in a far more narrow way. The test there is, was it feasible? Was the claimant able to bring a claim? Or was he too unwell or something of that kind, which meant that he wasn't able physically to do so? So feasibility of bringing a claim, we say, is the test in the DIFC, not the far broader just and equitable extensions of time by analogy with the UK. There is a marked distinction. The DIFC drafters will have been clearly having one eye to the English statute when making sure that they deliberately departed from the just and equitable or fair and just reasoning, as we've seen elsewhere in the employment law of 2019, and imported the test of reasonable. And then, Judge, of course, the burden of extending time rests entirely with the claimant. He has to lead evidence on why it was not feasible or why it's not reasonable. It was not reasonable to expect him to have brought his claim within 6 months of each event. He hasn't done that in his evidence before the tribunal, and so he hasn't led evidence in support of any application by him to extend time in relation to each of the out-of-time complaints, which are all of them other than the dismissal. So, Your Honour, with that said, unless you have any other matters on which I can assist.
No, thank you, Mr. Setti.
Thank you.
Mr. Bickford-Smith, how long do you think you would be in reply?
Your Honour, this matter to some extent has been taken out of my hands. My instructions are to observe that it's 10 o'clock at night where Your Honour is. We have been going by my calculation for 7 hours.
Yes.
I am not going to be an hour, but I do need to take Your Honour through points, and I think that I see no. This hearing was. I can't remember what it was originally listed for, but clearly it's gone long.
For 4 hours.
Yeah.
And I'm kicking myself for not putting you under time constraints when we started. But there you go.
Well, Your Honour, I would say this. I do just in my defence say this. We spent some time at the start, understandably, on housekeeping. What I was seeking to do was to close the case.
Well, let's not waste more time redredging the past, Mr. Bickford-Smith. That is a waste of time. So the question is, do we press on or do we adjourn? And if so, when would you gentlemen, when would everybody be available again?
It would be best, I think, if we could. press on. I think my learned friend, how long have you got?
I've got about 40 minutes, but
should we just get that done now?
Right.
I mean, I'm surprised you can have that long in reply.
All right, well, let's get it done.
Judge, it's a right of reply on the law, and I don't think there's anything controversial on the law. And I'm surprised that my learned friend wants to have 40 minutes of a second bite of the cherry.
Why do you say it's right of reply on the law? That's not a concept I'm familiar with.
Certainly,
in Australia, we have a general right of reply. I don't know what the practice is in the DIFC.
My understanding,
there's a right of reply, but it's limited to matters that could not reasonably have been anticipated.
Yes, exactly. Well, if you put it that way, that you can then understand the fairness and the limitations on it.
Yes, that's right. It's not a general roaming right of reply, Mr. Bickford-Smith. You need to say this is a new point, some new point that wasn't in the written submissions.
Indeed.
Your Honour, the issue I have with that was that, and this will be shown or not by the transcript, was that I took Mr. Sethi to be saying on several occasions that if I didn't disagree with him now, I would be taken to agree things. And I want to be absolutely clear that
Well, I don't. That's not something I would ever act upon.
I didn't say that either.
First of all, the characterization of this pleading. I dealt with this already in my opening today, so I will be brief. Your Honour will already have the key point. The pleading is a broad pleading in a number of material places, in particular paragraph 152.7a. And there are numerous other places where a series of broad averments are made. And it is simply not the case, as I said in opening today, and I'll just repeat this, it is simply not the case that we accept the premise of my learned friend's argument about what needed to be put and so on in terms of alleged narrowing of our case. It is plainly apparent when one looks at the specific paragraphs in issue. So I'll just give a simple example for Your Honour to read afterwards. If one looks at paragraph 62.2 of the particulars, one sees what is said there about a specific incident. The point that I am making to Your Honour is that what is happening here in this exercise that we've been going through is that whenever there is a word of limitation, either within or something that can be taken to narrow a plea, this is being taken to narrow the case across the board, and that is simply not a fair reading of the document as a whole. That's my point, Your Honour. So we see, for example, that in paragraph 62.2, there is talk about the claimant's status as a British Asian of partly Pakistani origin, etc. But if one looks at that, that is not quite plainly wording that delimits the entirety of the pleading. It is a sub species of paragraph 62, which relates to specifically what Mr. Akbar said. Okay, and that is, of course, why it was put to Mr. Akbar. The complaint was being made that, oh, well, it's only to Mr. Akbar that you've put this case. Well, that's because that's the person who the allegation was against. And that is, if I may say so, Your Honour, I just say that this characterization of the pleading, Your Honour should be very hesitant before accepting this without going back to the pleading itself. With regards to the list of issues, I say this only about the list of issues. It is a document that has been now, in my submission, overworked. It was helpful. The case now should turn on the pleadings. But I do urge Your Honour, when Your Honour is looking at this issue, not to proceed on the basis that the case is the narrower of whatever emerges from a combination of the transcripts, the evidence, the witness evidence, the pleading, and the list of issues. Your Honour needs to consider carefully what case has actually been put. Now, so that is going to conclude my observations on the pleading. The second point is that on a specific point of evidence, on specific point of law, I want to refer Your Honour to the supplemental authorities bundle. I'm going to put on my timer, Your Honour, so I'm going to beat my own time estimate. There's a promise.
Right,
In the supplemental authorities bundle, there is a case called Woby. I think it's a tab 1 or 2. Let me just get this. And what one sees there is,
what is it? It's Al Kharafi?
No, it's Gate Mina DMCC and Woby Mina FZE.
Yes,
and what one sees there, and it's just an indication that the DIFC, if I may say so, follows what I would regard as normal practice with regard to pleading. That's all I'm taking to there. But that one sees from paragraphs 36 and following complaints made about alleged departures from the pleaded case, and what the judge, I believe it was Sir Richard Field, said there was quite simply at the end in paragraph 59, the case put in its closing submissions is not such a departure from its pleaded case that it could only be considered if Woby obtained permission to amend the RRAPOC. Now, that is simply to, I would hope, console Your Honour in the thought that this is not a jurisdiction where there are unusually recondite rules of pleading. The simple answer to this is that the purpose of the pleading, in conjunction, it must be said, with things such as the list of issues, the skeleton arguments, and so on, the witness evidence, is to put the defendant on notice of the case it has to meet. What is a totally different type of argument is that the notion being put forward by the defendant in this case, namely that before liability can be established, a huge series of hoops have to be jumped through in terms of every stage of this process, because it's being said it has to be specifically pleaded, it has to be in the list of issues, it has to have been put in very microscopic terms to the witness, it has to be corroborated by contemporary evidence. And that is simply not the way the exercise should work.
Well, where do I find a definitive statement of your case? Is it in the points of claim, or is it in your closing submissions, or where do I find it?
Well,
is it the list of issues, or how do I find? You say I shouldn't take a narrow view of your.
No, Your Honour, it's going to be a very simple answer. Your Honour should read the amended particulars of claim, and Your Honour should read the closing submissions, and that's why I've directed you to Woby. And if Your Honour concludes that there is, as I do, Your Honour does not need to read anything else, because as I took Your Honour through earlier, the case advanced in opening is where we are now.
Yes, right.
So that's that. But Your Honour, the simple point about the claimant's case is that it has always been right at the centre of the claimant's case from the time of the amended particulars of claim. Can I just make it a little bit simpler? If Your Honour goes to page 64
of
the bundle, the trial bundle.
Yes.
That is the pleading about the dismissal itself, and that's clearly the most important act in this case. Yeah. And what we see here is, if I may say so, for a pleading settled before disclosure. In fact, remarkably similar to where this case ends up, does it not? So the suggestion that there has been some wholesale change in the claimant's case, or that the defendant is not on notice. If I just ask your Your Honour, to read pages 64 and 65 in the bit in red. And that is the claimant's case. On that most important issue. And on, I should just check that I've got the right page. It should be paragraphs there. 142A, 142, 142.5, etc.
Yes, all right.
So the point to follow, Your Honour, is that this is not a case where there has been some wholesale departure from what was being alleged. The constituent parts of that case have been put in considerable detail to all of the relevant witnesses. Just some factual corrections on what's been said orally. Something was said about Mrs. Tabara and the Protected Act. Could I simply direct your lordship, for your lordship's note, to 3726, which I believe we may in fact have covered already, but if not, it is 3726 at the bottom. It's in very small type, so I'll read it out. I mentioned that the function lacks diversity. There are 13-14 staff from Karachi. Please see the email enclosed the attached table. Ali Naqvi, who's listed as being from Lahore, moved to Karachi. I have no problem with harmless banter regarding my nationality in the context of sport, Brexit, etc. However, I do believe that for someone of a different nationality to the majority of the function, to have their nationality highlighted by a senior member of staff in a negative context is not acceptable in such a homogenous environment. So that's the end.
That was 3726, was it?
That was 3726.
Okay.
Can I also refer your honour to 42?
What is the document I'm looking at 3726?
It's a note of sorry, I've lost. It's a note by. It's a note of. Once goes back. It's a note of taken by Ms. Tabara of her interview. It's.
And that's with the claimant.
Yeah, and then we see that we have a comment document, etc. But that's the origin of this. Then we have
So what he says, to have their nationality highlighted by a senior member of staff in a negative context. What's he talking about? What incident is he referring to?
The incident with Mr. Vaselli.
Right.
You can see that above. And the point about this is a very simple point, and I am keen to focus on the headlines. The point here is that this is all in the context of the seat move, what the move off the floor, etc. And what was said earlier is, oh, well, there's no protected act, no evidence of protected act. Well, here it is.
I'm sorry, Judge. I don't believe this document was referred to in evidence. So perhaps my learned friend can give us a transcript reference, or.
I can't start. I'm sorry. First of all, I did not interrupt Mr. Setti. Second, I'm attempting to meet my.
He's giving evidence.
Today.
Well, no, it's
a document. I'm not giving evidence. I'm referring to the document.
Judge, you're asking my learned friend about the context of the document, and anyway,
well,
point of matter.
It was a simple enough request to stop me, to save me the time of having to read the document myself, yes. Mr. Sethi.
Understood.
It wasn't an invitation to give evidence.
Well, in that case, I apologise.
Yes,
thank you.
Then we have a point, or a significant point on the law. Your Honour asked in the course of my learned friend's submissions what the law was with regard to detriment, and I have in the course of the submissions going on looked this up, and this extract will come to the court. I'm sure I'll be chased for it if it does not by someone. I wasn't asking Your Honour to do that before Your Honour things, but this is just from Harvey, which is a leading English book on employment law, and I just think it's helpful. It says the term detriment is not defined in a particular statute, but it's a concept that's familiar throughout discrimination law. In light of this, it has long been argued that the term should be construed in a similar fashion, in which case a detriment will be established if a reasonable worker would or might take the view that the treatment accorded to them had in all the circumstances been to their detriment. Now, that is that there is an authority there cited, which I have a suspicion is actually related to whistleblowing, but the point in any event is that is the test, a simple test for detriment. If a reasonable worker would or might take the view that the treatment accorded to them had in all the circumstances been to their detriment. And Your Honour's question, in a sense, was, well, how can there be a detriment when someone does not know of it at the time? Well, the answer to that is, unfortunately, a very simple one in the world of employment. Things happen behind people's backs. Doesn't mean they're not detrimental to them. So I think that the question of the claimant's knowledge is relevant to time and limitation, but it's not going to be particularly relevant to the question of detriment. The question that is going to be potentially relevant to the issue of detriment is what causally flowed from these complaints. And there is a question there for Your Honour, which we say should be answered in this way. There was clearly a detriment because these things fed into a negative narrative about the claimant, and one can see that after Your Honour will recall Mrs. Al-Najjar's visible in evidence frustration at the fact that this investigation cleared the claimant, and one can see that later on further detrimental action is taken. Now, the question for the court is an assessment of fact as to what happened. My respectful submission is that this entire issue could be short-circuited really in the following way. If the court accepts that there has been a detriment and that it is discriminatory, I don't like taking points against myself, but I do believe in being realistic. If Your Honour is apprehending that I will thereby say that that act entitles Mr. Mahmood to a year's salary, that is not my submission. That is going to be an issue that arises in my submission at the stage of remedy.
Yes, but when we on this question of detriment, the detriment has to be causally related to the Prohibited Act.
Correct.
The Prohibited Act is not making a complaint about Mr. Mahmood.
Correct.
And so the two of the four complainants were perfectly entitled to unless you can persuade me that they were motivated by race, which there doesn't seem to be any evidence. They're perfectly entitled to. So those complaints were investigated. So the question is, did the reference to a cop of the colonial era cause any detriment? And it's difficult. What do you say the detriment was occasioned by the inclusion of those words? What detriment was
that wouldn't be.
Didn't even know that they were there.
No, I understand Your Honour's question, but that is this is a ground that has been travelled. The answer is that you would look at you would not just say, well, what damage did these specific words do? You would take a step back and say, were those anonymous complaints significantly more than trivially influenced by the claimant's race or nationality? The answer to that question is yes. Then you would say, well, what damage or what causal effect did those two anonymous complaints have? And at that stage, again, I don't believe in wasting time. Your Honour knows the case and the point. Either Your Honour concludes that these documents need to be seen as part of a totality of conduct involving Mr. Akbar, which was tainted by race and nationality discrimination, in which case we say the answer is self-evident, and there is. Now I don't want to break my promise. That was a 15-minute timer. I said I'd be 40 minutes. I intend to be 30, so I've got another 14 minutes.
Again, Your Honour, it is a right to reply in limited circumstances. It's not a second bite of the cherry. It's beginning to sound like a second bite.
I'm addressing the question raised by Your Honour. I mean, it seems to me that
I agree.
I don't want Your Honour.
There's no need to explain, Mr. Bickford-Smith. Just get on with it.
The answer to that is that either Your Honour is going to say this is all connected to a series of detriments around this period, January 2019, which caused a detriment, or if Your Honour, to use my learned friend's words, starts separating things out. If Your Honour concludes that these complaints need to be viewed in their own terms, the answer it would seem to me is that you would face a causal question of were these things trivial, or did the fact that there were 4 complaints rather than 2 lead to a different reaction from HR, ER, and that would be a question of fact. But the crucial point about these emails, which I didn't want to get lost sight of in this, is that it's their evidential importance that really matters in many ways. Because what these show, in conjunction with Mr. Akbar's comment to Mr. Vasselli in the August of that year, is that when you get to the flashpoints, it is when you get to the flashpoint that people show their true colours. And what emerges at the flashpoints of this case is that the claimant's race or nationality were problematic and led to detriment to him. And that is what really most matters. I'm not saying nothing else about these things matter, because quite plainly it does. There is a claim. It is a good claim. There is no sensible basis for keeping it out. But what I don't want your lordship to do is to start saying, well, how many dirham is this claim worth, at least at this stage? That's a matter that your lordship, your honour, could consider in due course. The issue really here is what does this show about the wider case? So that's where I am on that. Now, I am attempting to some submissions were made orally by my learned friend, particularly this follows up from the arguments that he's been making about this issue of separability. And your honour will recall asking my learned friend some questions about well, surely this must be an act of discrimination with respect to both real and hypothetical scenarios. And what was being said was that there were a number of boxes to be ticked before that liability can be established. And we say that this attempt to overanalyze the facts and apply legal glosses which are not there in the clear wording of this employment law. Your Honour has the employment law. Okay? It should be given effect according to its terms. What we cannot have here is mysteriously the situation where the most obscure and recondite aspects of UK employment law, notably the decision in a case called Reynolds, which my learned friend referred to orally, we cannot have an attempt to say, well, this obviously applies, but then, by the way, the more favourable bits of UK employment law don't apply. That is part of what I would describe as a heads you lose, tails we win approach that has been seen too much specifically on the law. It is not right. And can I just refer to your lordship, Your Honour, to the case of Denby, which I took your Honour to for other reasons, but it is very good on the question raised by Reynolds. And one of the points there advanced in simple terms is that Reynolds and all of this argument about separability and, oh, well, if X makes a decision and didn't know about something that Y knows about, then liability will not lie. That is not a license to employers to have a opacity in who has made decisions about what and when. Now, the next question I had, and again, I'm just focusing very firmly on reply. Can I deal with, it seems to me right to make this point. We had reference already to Mr. Cuss. The claimant gave evidence about Mr. Cuss, what he said to Mr. Cuss at paragraph in his witness statement. And that evidence was that he did complain of bullying. Mr. Cuss has not been called to give evidence. And I don't see how any successful challenge to that evidence has been given. So that's with regard to Mr. Cuss. With regards to something that was said briefly about Mr. de Groot, now, again, it is entirely open to my friend to make the submission he does by reference to the transcript, by reference to the claimant's recollection in witness evidence being hazy. But what's not okay is that one does need actually to remember that there is contemporary evidence here. Can I refer to page 2816 of the bundle? And what's said there is, historically, when I have discussed the challenges within Group Islamic Banking with Manu, that's Mr. de Groot, his messaging has been supportive, sympathetic and understanding, but the tone of the email below and the sudden emergence of my stakeholder management as an issue that may merit my job as being advertised are a significant and sudden change from the messaging I've historically received, etc. As mentioned, I do not accept the personalization of my handling of the issues that have arisen within Islamic.
Where are you reading from, Mr. Bickford-Smith? You're reading 2816.
2816. Can I just check that I'm in the right page?
Whereabouts on the page?
It's after the last bit of the blue text. It's during my conversation.
Oh, yes. Okay, all right. Yes. Yes, okay.
Now, to be clear, I'm not saying that this fully makes out the claimant's case on all aspects of what his evidence about Mr. Groot is, but I am saying that this is a document that should be taken into account by the court when considering whether the claimant's evidence is actually as hazy as has been suggested.
Well,
Finally,
so I'm not following that. What should I draw from this? What he's saying is that
what he's saying is this goes to the issue of what was the claimant reprimanded by Mr. de Groot, etc. Yes. Yeah. And what we're saying here is what he is saying contemporaneously is there's been a change in tone. Yeah. And yeah. What I say is that is consistent with the claimant's evidence orally.
Well, all he's saying really is that they've been very nice and friendly to me and sympathetic, and now I've been told that the inadequacy of my stakeholder management is such that my job can be advertised.
Correct.
Well, that's not the same as saying he's been reprimanded, is it?
No, I didn't say it was, but I'm saying it is consistent with the claimant's case on this issue.
All right.
Well, the point I'm making specifically is it's quite clearly not the case that what the claimant is saying is simply years after the event with no supporting material there. With regards to the speak up, again, that is the case is being, we say, artificially limited. These points about the speak up were put fairly and squarely to Mr. Sheikh. My learned friend has an argument that the speak up as a matter of law cannot be a speak up. We take issue with that, and that's where battle is joined. One point that does follow from the speak up incident, and the other.
So the speak up can't be a protected act, you mean?
Well, that's my learned friend's case. Yeah. So what we say is that just moving beyond that question of law, what we say is that the court, in assessing these questions of causation, has got to ask itself the very basic question of why we have someone here whose initial performance ratings, but this is all in the closing, but I just mentioned this. The court has got to, and the reason I mention it in reply is that this attempt to parcel and sub-parcel and sub-sub-parcel events up and to put them in little silos is not the correct approach to fact-finding, but Your Honour will be aware of that from long judicial experience, which has given Your Honour great stamina. So I'm going to try. I've got, according to me, 4 minutes 28 seconds left of my self-imposed mini cap. I simply make this point, which is a very important point. There were references made orally to Mr. Mahmood's conduct during employment. Can I please just check that the court, obviously the court has a forensic and precise black letter focus on precise emails, and that is the correct approach. But the court will also recognise here that what we are looking at is a handful. There are literally 5. If one goes back to my learned friend's cross-examination, let me give the reference here. If one go, and I'll just give this reference to Your Honour now, we will see that day 1, pages 112 to 126, concerned the claimant sending the draft framework document to compliance management before GIB management. Page 131 to 134 related to who had deleted the ORF section, who had written the ORF section. So that's within the same document. We then have day 1, pages 170 to 195 about the exchanges with Harris Law. Day 2, pages 1 to 6, it was the same. Day 1, 179. This is the origin of this argument about escalation. But what the court needs to look at is to say that when it's submitted, this is the claimant's modus operandi, how great is the evidential basis for that submission? Likewise, we then have the 365 feedback on Mr. Akbar. Very notable how little has been said in closing about Mr. Long's knowledge of this and all the claimant's evidence about that. And what we say here, and the reason I do want to leave the court with this point, is that there does come a point in things where if they're said often enough, they sort of pass into common currency. And I did have a concern arising from some of the oral exchanges that might be in risk of happening here. It is absolutely not accepted that the claimant was a problem employee. What has happened in this case is, and indeed Mr. Cuss himself used the word, it is a tragedy. We have someone here who was, on any view, a gifted compliance officer, very well rated in the bank, whose career ended. Now, the question that in the bank, and the question the court has got to determine is why that was the case. And the reason I underline that is that that is where the answer to this case lies. If the answer is going to lie in some of the more recherche niches of law or of procedure that have been seen, the court is unlikely to reach the correct answer. what was needed here and what is needed are clear and, if I may say so, courageous findings on the fact. And those, Your Honour, are my submissions.
Good, thank you. All right, well, that completes the hearing, and I will, of course, reserve my decision. It'll obviously take me quite a while to go through all the material that you've given me, gentlemen, both now and during the course of the trial, and there's a massive paper, as you've seen. So I have no idea when how long it's going to take me, but there are a few other things in the queue. But I will do my best to get on to it as soon as I can, but I can't make any promises as to time.
Well, Your Honour, speaking of time, it would be wrong. It would be totally wrong for me, on behalf of both advocates and parties, to thank Your Lordship for sitting this late. I'm extremely grateful.
That's all right. It's much better than adjourning, so that's good. All right. So thank you both for your assistance. Thank you all for all your assistance, because I'm sure there are people behind you who have put a lot of work into the submissions that you've provided me with today. I'll reserve my decision and publish my reasons as soon as I can.
Your Honour, may I just add, would Your Honour like me to arrange for the authority of Griffiths and Tui to be emailed to you, because I did refer to it in closing, and it is a very recent Supreme Court authority.
I think that would be helpful if you could arrange for that. Just send it to the court, and the court will send it on to me.
Grateful.
Yes, sorry, I just on the Griffiths point, the simple point for Your Lordship about Griffiths is that was about the primary purpose of Brown and Dunn, i.e. challenging evidence actually given. Thank you.
All right. Thank you. All right. Good afternoon, everybody.
Good afternoon.
Good night, Judge.
Bye. Bye.
Bye.